For nearly a century, Fortune has been the gold standard in business journalism. Trusted, insightful, influential. Fortune India carries forward this legacy, delivering editorial excellence and sharp insight into the people and the ideas shaping business in India and beyond. Every day, across platforms, Fortune India offers exclusive interviews, in-depth analysis, and reporting that goes beyond the headlines. It doesn't follow the news. It sets the agenda. Its flagship lists and rankings: Fortune India 500, Most Powerful Women, 40 Under 40, and Best CEOs are industry benchmarks driving conversations in boardrooms and beyond. It is no surprise then that it's the trusted read of CEOs, policymakers and entrepreneurs powering India's economic growth. This legacy of influence extends powerfully into the digital space. With surging web traffic and a fast-growing base of engaged readers, its digital footprint is expanding rapidly. Fortune India is more than a publication. It's a platform where brands connect with influence. Through curated events, tailored content, and strategic partnerships, it offers brands the opportunity to engage with the right audience, credibly and powerfully. With Fortune India, brands don't just advertise.
To all of you, can we please have your mobile phones put on silent mode so that we go with the flow of the event today without any disturbance of the ringtones? It will be really helpful if I could get your help in that. Once we have you all settled inside the hall, we are all set to start. All right, so once again, good afternoon, distinguished guests, members of the legal fraternity, and esteemed dignitaries. It is my privilege to be your host for an event that celebrates excellence, integrity, and leadership at the highest echelons of the legal profession, Fortune India Legal Excellence Awards and Lists, Lexa 2025. Can we please have a big round of applause as we look forward to start this event on a sharp note? I think that's a very lazy round of applause. Can we hear it louder? Fantastic. Thank you so much for doing that for us. My name is Preeti Dahiya and I will be your host for the day, and it's a pleasure to be in front of this distinguished gathering. Now, for decades, ladies and gentlemen, Fortune has been a global authority in business storytelling, chronicling the enterprises, leaders, and ideas that shape economies and define the future. With Fortune India, that legacy continues, bringing to light the voices shaping India's corporate and legal landscape. Today marks a significant milestone as we present the inaugural edition of Lexa 2025. The overwhelming response from leading law firms, corporate legal teams, and independent practitioners is a testament to the strength and vibrancy of India's legal ecosystem. As we gather today, we do so at a pivotal moment, one defined by technological transformation, evolving regulatory frameworks, and a renewed emphasis on ethical responsibility. Our discussions today will reflect these shifts, offering insight into the future of law and its practice. So our first session, our first panel discussion of the day is going to explore the intersection of technology and legal ethics, examining how artificial intelligence is reshaping legal practice while raising critical questions around accountability, transparency, and professional responsibility. So, ladies and gentlemen, we are going to commence with this thought-provoking discussion, and the theme of the first panel discussion is AI governance and ethics in the practice of law, balancing innovation, accountability, and professional responsibility. First of all, for this discussion, I'd like to introduce our panelists to you, and I will name them one by one. We'll request them to please join us on the stage as I take your name. Let me begin by introducing Mr. Pranesh Goyal Founding partner, MGCO Legal, known for his expertise in corporate advisory and regulatory frameworks. Sir, can we please invite you on stage? Can we please give a warm round of applause to our panelists as they join us here on the stage? Sir, for your reference, all the name cards are along with the chairs that we have kept for you. Our next panelist for this discussion is Ms. Hiranmayi Ralabandi, General Counsel and Chief Governance Officer, WeWork India, a leader in corporate governance and compliance strategy. Please welcome her on the stage. Joining our two panelists also would be Mr. Zohaib Amin, General Counsel, Zycus Infotech. He will bring in deep insights into technology, law, and digital transformation. Welcome, sir. Can we please have a big round of applause for our panelists here? And to moderate this session, I'd like to invite on stage Mr. Tushar Gunderia, Senior Vice President, Legal and Compliance and Company Secretary at Blue Dart Express, an accomplished professional with extensive experience in regulatory and corporate legal matters. With that, I'm going to hand over the stage to Mr. Tushar, sir.
Hello, good afternoon, everybody. Hello. Yeah, good afternoon, everybody. So we are going to have a very exciting and interesting session, which in today's scenario, it's not only important, but it is already shaping the future across the globe. And the power of AI, we have already started acknowledging, but how it is going to reshape the future, that will be very interesting journey to watch. And I would start my opening remarks with, just ponder for a while, when the machine starts thinking, what becomes the responsibility of the professionals, When machine starts thinking and starts, throwing solutions and options before you, legal advice and something, then what should be the responsibility, ethical practice going forward of the lawyers and the professionals? And it is going to, change, it is going to impact in all walks of life, not only legal profession, be it in the corporate or in any facets of life, it is going to have a dynamic impact over a period of time. And we have with us, esteemed co-panelists. They have already been introduced. So I would straight away start with the session. And my first question would be, I would address it to Hiranmayi. So I would like to ask you your thoughts and inputs. When AI is already influencing legal workflows from research to drafting, in your view, what are we looking at productivity tool or a dynamic shift are we looking at a dynamic shift in the legal practice over a period of time?
Thank you, Tushar. And before I express my thoughts, I just want to give a small disclaimer that whatever thoughts or opinions that I have right now are my own and not necessarily of my organization. With that, I think it's a very fascinating question that Tushar has posed as to what is the current status of AI. I think AI, when it came as a productivity enhancer, right? Which helped us to probably work on our due diligences, research, drafting. As Tushar rightly said, that's how it started the tone. But I think there's been a dynamic shift now from that productivity enhancer where lawyers have actually, started using AI for the purposes of being a decision support layer. That's what I think AI is finally evolving into, where basically it is adding value to whatever stuff that we are giving to our clients. When I say clients, for law firms, it's obviously the clients otherwise, but for us as internal lawyers, it's our internal management and stake. So what AI is doing for us is basically, it is helping us scale, it is helping us probably build in more efficiency, it is giving us more speed, it is basically augmenting the decisions that we are taking. It is helping us become a strategic advisor is what I feel that AI is doing. So at the end of the day, what I'd like to say is, it may have started as a productivity enhancer, but at the end of the day, definitely there is a shift with productivity enhancement as the entry point, but definitely leading to us being strategy advisors and using AI to the extent where we are collaborating more with the AI rather than AI taking over us completely. That's what I feel.
Okay. Good, thank you. I would request Zoeb if you have any thoughts on inputs on this.
Sure, thank you. Uh, with the introduction of AI, I think there will be some fundamental changes, not only in operational aspects, like as said, the AI is going to help us in doing some routine and mundane tasks. So lawyers' work is going to be getting enhanced. Lawyers are going to support for more strategic decisions. And while there will be some operational changes, there will be an opportunity to restructure the team members of the legal department, law firms, because there will be an opportunity to reduce the team members. At the same time, there will be some requirements to add new roles and responsibilities. There will be a requirement to add AI validators, because once we get outputs from the AI, as per the requirements of AI governance, there is a need to validate those outputs. So there will be a need to have an AI validator who can validate the outputs, and the validated outputs can then go to the senior counsels for more strategic decisions. And then with the introduction of AI, there will be requirement to develop new skills for assisting the legal services. There will be requirement to develop the prompting skills. Yes, prompting skills, while interacting with the AI, it is not just about asking questions and getting the output. It's about interacting with the AI with a developed prompting skills. When I say prompting skills, it's like asking questions in a proper structured manner. We should be knowing how to ask the right questions to the AI. Because if we don't ask the right questions to the AI, the output will be not in accordance to our requirements. So there will be requirement to have prompting skills as well with the development of AI. And AI is evolving. Right now we are talking about input and outputs. Later on, AI is going to get into the domain of operations, from input-output to agentic AIs. So there will be a need to align ourselves in accordance to the development of the AI and the legal services which we look forward to provide to our clients.
Yeah, thank you, Zoeb. I would request Pranesh, what's your thoughts on that?
So in terms of whether it is just a productivity tool or a game changer, I definitely think it's a game changer. And Hiranmay and I were just discussing this. I think a lawyer's role generally is perceived in a bubble which is very, very limited, and it couldn't be further from the truth. So because I run a law firm, I know that a lawyer's function isn't just a legal function. It is often a management function. It is a discovery function. It is an accounting function. It is also a strategy and legal function. Now, why this is a game changer is because it has fundamentally changed cost structures. It has fundamentally changed how you retain things, whether you're even required to have a stellar memory, because AI will do that for you. Your accounting functions have fundamentally changed. Your internal strategy functions have fundamentally changed. And then beyond this, there is a legal function that with time, AI might be equipped with and be capable of. I think the fundamental difference between the current AI legal models and us as lawyers simply is empathy and strategy. Everything else I think AI can currently even perfectly do. But I think as far as empathy is concerned, as far as understanding why a decision might look great on paper, but it maybe doesn't suit a client's family, or it doesn't suit the larger aspirations that a client might have, this is something that AI particularly right now is not empathetic towards, or is not it's something that it is thinking about. But I think in the long term, AI might become capable to even do that. It is 100% a game changer in terms of how we operate and how we look at things. Things are going to become more competitive because cost structures have fundamentally changed. You don't need, an army of officers within the organization to manage things that maybe a 2,000 rupee ChatGPT subscription can do right now. So it is a game changer, and I think it is high time that all of us start adapting to the system that's been built. And I think, we'll just start revolving around all of this.
Okay, thank you. So, see, if we have heard all the three co-panelists, one thing is coming out very clearly. AI is an extremely powerful tool, and it is going to 100% reshape our future. Now, but with that also means it will throw up on various immense opportunities but at the same time, it will come with a profound responsibilities. So my next question would be in terms of ethical conduct and the responsibility, which AI, how we will have to govern towards that. So I would request Zoeb, if you can throw some light on if an AI generated legal opinion turns out to be a flawed, where does the accountability lie? Whether it will remain with the lawyer, professional, or the AI service provider?
That's an interesting question. While we use AI, I believe the lawyers, the counsels, and the law firm should remain accountable. Because if something goes wrong with the AI, we cannot raise our hands and say that the AI providers are responsible. Because the AI providers, even if they make the AI 90 to 95% accurate, still for the 5%, it could be very catastrophic for the legal aspects. So we should remain accountable for that 5% as well. To give you an example, even if while we are interacting with the ChatGPT and we ask a question to the ChatGPT that, okay, can you review a contract and give me the results for the contracts which are less than $5,000, it should be reviewed autonomously. And we set that rule. Now, the ChatGPT will review the contract which are below $5,000 and give the results to us. But while reviewing the contracts by the ChatGPTs, it may say that for the liability clause, it should be capped to $5,000 without realizing the fact that the data which is being handled through this contract is quite critical. There, the role of the lawyers become very important to catch this up. Because if we don't catch this up, it will be very catastrophic in nature. So accountability is very important. In fact, it's a breach between the trust and confidence, between the trust and confidence of the clients and the lawyers. Because the clients engage with the lawyers, the clients don't engage with the ChatGPTs. The clients pay us for giving them expert opinions, for giving them strategic plannings. The clients don't pay us for getting just the outputs of the ChatGPTs, right? So accountability is very key. And if this bridge is broken, then there will be no trust and confidence between lawyers and clients. And if there is no trust, there will be no professional relationship between clients and the lawyers. So to keep up the professional relationship between clients and lawyers, it's very important that we remain accountable for the usage of the AI.
Yeah, thank you. Very good perspective, actually. Hiranmai, if you have any thoughts on this, actually.
No, I think I completely agree with Zohaib here. So, see, you can delegate quite a few tasks, but professional judgment is something that one can never delegate. So you have to continue to be accountable, as it's all about ethics at the end of the day, right? So there has to be a human oversight of everything. Whatever your AI does, it can't be treated as the final output, but it's to be treated as an input, and the accountability always remains with us.
Okay, thank you. Pranesh, you have any thoughts on this?
Yeah, actually, I have a lot of anecdotes, but let's consider a parallel possibility, right? You write a draft, as we did before AI using Microsoft Word, and say the formatting goes entirely off before it is filed before the court. Microsoft Word was never wrong. We were wrong. It's a similar set of technology that just operates differently. So the responsibility of a lawyer will absolutely never go away. I think only that person should be responsible who's stupid enough to take it as a final output. Ultimately, AI is assistive in nature. It is not a replacement to an existing law firm or a legal team in-house, which is why it should be taken in that light. It should be taken as an added team of lawyers that sort of assists primary partners and associates in the firm that generate the right output for the clients. But absolutely, I think as far as ethics are concerned, a client should have to bear the brunt of a bad prompt or somebody careless enough to just take an AI output as the final output.
So I would say the one thing which is coming out very clearly is, AI can give a lot of solutions. It can throw upon a lot of options, but it But another question, very interesting question to Hiranmay. So where should the legal profession draw the ethical line in using AI, especially in sensitive matters like litigation strategy or client confidentiality?
I don't think there is any doubt on where you can draw the line. At the end of the day, the ethics or the AI aspect of it is extremely principle based, and there is no way that one can compromise on the data confidentiality of the clients. So that's extremely critical. So AI is all about responsible use and transparency, and we have other regulations across the world which are again totally transparency based principles. So it is very, very important for us to be clear that that's not something that can be compromised. We also have the DPDPA Act in India right now, which also talks about data protection. And this also obviously then goes ahead and applies to your AI as well. As far as litigation strategies are concerned, again, they are highly sensitive. You have family law cases, you have so many cases, right? If you start using client data and you put that in some kind of a chat GPT or any of these AI tools that we have, you're already compromising the client data that you have, right? And you're just getting some stuff from there and you're exposing it, because we all know what AI does. It goes through the entire history. It goes through the decades of stuff that is already there on the internet or wherever it's available, and that's how it comes up. So you're compromising. So there it becomes extremely critical for us, first of all, to ensure that whatever client data that we have is not there on any open AI kind of a thing. We may be using certain tools which are probably just customized for us, and that data is being used maybe to draw conclusions or summarizing. That's a different ballgame altogether. But if your litigation strategy is heavily dependent on AI outcomes or inputs or whatever you want to call that, then I think it's extremely important for us to avoid it. Or if we do want to use it, get a client consent in place before we start using it. So these are a couple of things that one should be extremely, extremely careful about.
Yeah. Certainly, I agree that it's very important to keep the client's data confidential. When we speak about AI, there are technologies available in the market. It's not just the open AI chat GPTs which we use. There are technologies available in the market like Microsoft Azure. It provides a dedicated instance of ChatGPT where you can use that ChatGPT. That will be a dedicated instance to you. It will not be in the public domain. Nobody else would have access to your inputs and outputs. Nor the Microsoft Azure is going to store your data or utilize your data for training purposes. There are options. So when we talk about AI governance and balancing it with the client's confidentiality, there the question arises that we'll have to make the right investment in the AI while we decide to use AI for our providing legal services to the client. We cannot, if we are taking highly confidential data from our clients, we just cannot keep using free open AI chat GPTs because accountability remains with us. There we have to make some additional investments in getting dedicated instance, even if it is costly, but we cannot compromise with our clients' confidentiality. That's how there will be a requirement to balance clients' confidentiality with additional investments and continuing with the innovations and usage of the AI as it evolves.
So I would like to extension of that question. So do you think that all law firms should have some, AI governance framework for, which can, expect certain kind of conduct, behavior or use of AI?
Yes, certainly. It's very important to have AI governance framework at corporate level, law firms, and also for the individual lawyers as well. When we talk about corporate governance, it will be primarily driven by the global AI governance frameworks which are there in different regions. EU AI Act is there, Singapore is coming up with the principles AI governance, and many other regions are coming up with the AI governance. There are some golden principles of AI governance around all of these AI governance frameworks like transparency, human oversight, accountability, fairness. So we'll have to adhere to these governance requirements while providing services to the clients. And one of the most important thing is that even if we have governance framework at corporate level, at law firm levels, or at individual levels, it's very important to provide right inductions to our team members, trainings to our team members, how to adhere to the AI governance framework. Because if that induction is not there, simply by having a theoretical AI governance at corporate level or at law firm will not going to work. Because ultimately at ground level, our colleagues are going to use the AIs. They are going to use AI and give the output to the senior counsels for further works. So our colleagues should be trained how to use AI in a responsible manner, how to develop the prompting skills, and not just taking the input and copy pasting it and giving it to the senior counsels. So all these will form part of AI governance in the legal departments.
I'd just like to add to that as well. I think what he said is very, very important and critical. But on top of it, just having this governance framework, as he said, I think it has to be extended and has to be very, very detailed. Depending on the kind of AI you're using, whether it's for a corporate in-house team or a law firm, and I think Pranesh should be able to give more detailed work on how the law firm works. Being an in-house counsel, I would talk about the different kind of models that we need to have in place, the accountability models, because it's very, very important, because it's just not lawyers who use this. As an in-house legal team, you have your company that, today the buzz is all about AI, right? You have customer experience, you have your operations that the company is into, or you have a lot of, automation that one is trying to work on. I have known companies where you actually have empathy coaches. So Pranesh, empathy is not very far behind. There are companies that are actually deploying empathy coaches through AI to be able to, coach their own people, especially when they're facing customers. So those are already developing. In cases like this, I think it's extremely, extremely important to have a proper guardrail and a governance structure. So when I say governance structure, maybe an AI steering committee, right, which is cross-functional collaboration of tech, IT, engineering, legal, risk, and probably the respective business people who are coming up with these models that they want to deploy. You need to also have design accountability as to whether the algorithms that are being used, are they explainable? Are they traceable? When there are an audits that are being conducted, are you able to get everything in place? How are you using it responsibly? You have to have the deployment accountability around it, right? The training. What is the training that is being given to people around you? How are they able to ensure that there's a training that's being done, or there is that bias has not creeped into it, especially when there's sensitive sectors like your healthcare, your legal, or your hiring sectors and all. I think those are also very important. Finally is your life cycle management from an accountability model that you need to have in place, wherein this constant monitoring, this constant, auditing that is happening, and there's any incident reporting also involved. Those are extremely important things. And next is your board oversights, right? Because a lot of these models go to your board. Do you have enough people in your board who are able to question the deployment of these models? If it's a high risk AI deployment, then do you have enough people who can question you on these? Who can ask you as to why you're doing this? Is it really important? How are you protecting data? What are the accountability standards that you have? How are you able to protect the data that is being generated through it? Or are you using any confidential data of people around it? What is it that you're taking from the cloud or from probably the website? Is it an open AI thing? Are you developing something in-house? What is it that you're working on, right? And then also on the IP aspect of it. And if you're using vendors, how are you putting it on the vendors? Are you ensuring that you have the vendor audit rights? I think these vendor due diligences, whether it's a law firm or us, it's extremely, extremely important for us to have all these guardrails in place. I think so it has to go way beyond just training, but regular, I think, education, awareness, over communication, but accountability definitely.
And it's important that such AI governance framework remain flexible, because AI is evolving, so we cannot have one rigid AI governance to be there for a year. In fact, AI's versions are changing. Today we are at 5.2. After 3 months, it will be like 6, 7. So our AI governance also needs to remain flexible. Today, we are talking about input, output, validations of the inputs by having a human oversight. But tomorrow, agentic AI will be there, which will be fully autonomous. It will have different agents within itself to carry out your intent and requirements. You would just need to give a command that, okay, review this contract of so-and-so region for so-and-so purpose. It will be agentic enough to give you the autonomous end results. Then the question arises, how do we validate such agentic AIs? How do we have human oversight for such agentic AIs? Because now you can see the input and the output and you can validate, but tomorrow when it becomes autonomous with so many agents giving the end results, how do we have human oversight for validating the agentic outputs? There, the AI governance is required to shift from human in the loop to human over the loop, because there you need to have some guardrails instead of validations. When I say guardrails, like for using agentic AIs, then you need to decide what sort of contracts needs to be reviewed by the agentic AIs. You can set rules and guardrails that, okay, my contracts of value less than $10,000 only needs to be processed through agentic AIs. The contracts belonging to, say, vendor procurement contracts of, say, only for stationary purchases and all should be processed through agentic AIs. So there will be a need to have some guardrails. By having some guardrails, we get into human over the loop rather than human in the loop. So ultimately, our AI governance also needs to remain very flexible to address all of these technological changes in the AI.
And I would like to state that as far as the corporates are concerned, there is already a boardroom level discussions on the AI, and the companies have also started making AI strategy committees, and how to make use of it and how to create a consciousness within the organization for the employees. They can't misuse the AI, or wherever they are using, where they are supposed to inform their seniors and the directors about, where their solutions or advice is coming from the AI. So organization strategy document is also, corporates are thinking towards the AI as long as also the investment outlay, how, because it is going to, change the future. So how much to invest in AI, 5 years plan, 6 years plan, 7 years plan, that is also being thought of. So now I would like to go for a little different question addressed to Pranesh. It's a very interesting question. Now Pranesh, do you think is AI is reducing the learning curve for the young lawyers? I mean, is it eroding their foundational thinking capability?
So I think a lot of this is based on perspective and just individual human inclination as to how technology is perceived, right? Fundamentally speaking, when I went to law school, I still remember there used to be a moot court committee in law school which taught us how to use an SCC, which taught us how to use a Manupatra, which taught us how to use basic Google search parameters. But we weren't particularly taught by the MCC to reference a reference book, because technology had evolved by that time, that as opposed to when my dad was studying, we weren't very great at going through reference books, going through all India reporters, because we knew technology was assisting us in a much better way. Now in terms of learning curves, ideally, in an ideal world, and I've said this before, the entire legal education system also needs to revamp curriculum around AI. We can't fundamentally look at it as a sideline step that particularly, young children still in school should be allowed to individually take on. There has to be an inclusive model of learning where fundamentally how you use AI is also made part of your teachings at school, your teachings in college. Furthermore, even when I was growing up, one consistent line that I've heard is, we're great users of tech, we're not great makers of tech. The fundamental problem is in school we started making great use of Google, but we never understood how Google actually works. We weren't taught SEOs in school, we weren't taught digital marketing in school, we weren't taught how optimization could be done better for different things that you do, how search results could in fact be optimized to what is it that you're exactly looking for now. AI has already helped with that, but I think part of the curriculum needs to be how to use AI, how it can in fact enhance your learning curve. So one perspective to this is that it is eroding the learning curve, where you look at it from the perspective of this is a quick fix, this is an easy fix. Instead of having to go the hard way around research, you can now ask ChatGPT a question, help you answer, an assignment that you've been given at school or college, and that's something that will do just sufficiently enough. And I'm not kidding, this actually happened in my office. I gave one of my interns a task. He came to me with that task about 2 hours later, and it seemed like pretty decent, good work. I said, did you use ChatGPT? He said, yes. I said, can I look at your chat? So he gave ChatGPT a brilliant prompt. It generated a response. The next prompt that my intern gave ChatGPT was, this does not sound like me. This is too good. Tone it down to an intern level job.
Okay.
And I'm not kidding. So this has happened with us. I think this is smart use. I think going forward, smarter use of AI, which actually helps you deliver better work, needs to become part of the learning curve. If at all, the idea begins to seep in that this is just, like I said, a quick and easy fix, the learning curve will indefinitely erode. Also, given that we almost share a generation gap, I think the way that we look at it is hard work isn't always the best work. I've never been a believer in somebody being so great at research that they've spent 6 hours in a library running through reference books to find the right judgment. I don't think if somebody did that through ChatGPT and referenced 5 judgments instead of 50 is bad work. It is good work. I don't think that is something that eroded the learning curve. Yes, the 50 judgments back in the day gave you a lot more knowledge than strict limited reading of 5 judgments would have given you. So it lets you read into lesser context. It only exposes you to pinpointed results. So you're not exposed to the larger realm, not just of the legal world, but anything, by and far that we do today. But if we become so heavily dependent on AI that we're looking for straitjacket answers, I think we will lose out on empathy and strategy that I think today only humans can deliver. When we operate as a law firm, like I said, also patching into the last question, in terms of ethics, accountability, and all of that, I think one accountability in data confidentiality is you don't reveal a client's confidential data when you're taking the assistance of an AI model in generating a result. But I also think because we're heavily dependent on the data giving us that response, I think it is also the responsibility of us as members of an academia circle that we begin to publish final results when they're outside the scope of confidentiality. So later AI can help someone deliver a better result on a strategy that was created and has delivered a result in. So I think, this need to learn and this willingness to keep exploring with the use of AI and having someone answer your questions in real time as opposed to just reading a book should enhance the learning curve. I think we just need formal education around and training around how it is to be used and how greater productivity can be achieved from the technology that is very rapidly growing.
Okay.
I think
So, carry on.
I think AI certainly helps the young lawyers and the Gen Zs because it helps them quickly get research results. Earlier, young lawyers have to approach to the seniors. The seniors did not have much time in clearing the doubts, asking questions. Now, that need is not there because, okay, fine, even if you want to approach seniors for some strategic planning, understanding, but for other questions, you can just ask ChatGPT's your questions, doubts, and you can get the results very quickly. So certainly ChatGPTs are going to help you to learn about the research aspects, to help you learn more new dimensions and new laws. At the same time, if the young lawyers who are expert because young lawyers are Gen Z people. They are expert in how to use chat GPTs, how to put right prompts. They have good prompting skills. So the young lawyers having good prompting skills as well as legal instinct, a combination of these two are going to be assets for the law firms and the legal departments, because this is what the legal departments and the law firms are looking at, a combination of good prompting skills as well as a legal instinct.
Take one shot this thing. See, I have a son who is currently pursuing his law, so the generation gap definitely. And today morning, interestingly, I was having a chat with him on, he just got his internals and he'd got his marks, and we were just discussing that. And he was talking about the other students in his class and how for them, he'd scored well, but this other section who hadn't really scored well, so there was a big venting session that was happening. We were just talking about AI and how he was talking about these students, and I'll take younger generation than him also. Again, I have my daughter who's in grade 10. So the way they use ChatGPT or AI for that matter is they do not want to apply their mind. Everybody wants shortcuts. Everybody does not, because they want more time to spend on other things. They really don't concentrate on the basic principles. So I'm just going to differ from the two of them. So they're just using AI left, right, and center, whether he has a Gemini subscription, someone has this ChatGPT subscription, someone has this Harvey subscriptions in law firms. There are a lot of these subscriptions that are there. So people are just not applying their minds. They're overtly dependent on them. And resultantly, what is happening is the basic principles, or probably their IQ level, is really coming down because there's heavy dependence. I think what we really need to probably tutor our kids or mentor them, or even from a law firm perspective, when you have new interns coming in or just associate levels, is to at least apply basic principles, even from the prompts that you talked about. Unless until you don't understand the basics, the principles of what you're working on, the fundamentals, there is no way that you can give it too much of a prompt. So if the very first instant you're going to use AI for the purposes of gaining knowledge, I don't think so AI is helping you there. You want to research after you've given the principle, it's fine, because if you don't, if you make mistakes, what AI will do is it will never ever enhance your strength. It will only enhance mistakes. I think so one needs to be very careful about those.
So if I have to ask all three of you one very short question, do you think young lawyers or young corporate executives using AI constantly, will it impact their creative thinking, innovative thinking?
I would say for using AI, chat GPTs, as I talked about the prompting skills, that itself required creativity, because we should be creative enough to provide proper prompts to the chat GPTs to extract the right informations, right set of informations which we need for a specific purpose. That requires creativity itself, because prompting skills requires intelligence, requires creativity. Anybody can put a prompt and get the output, but a person who is creative enough, intelligent enough, and knows how to put the right set of questions to get the right set of informations which can be helpful for the right purpose, for the required purpose, that is the right thing which we need at this point of time.
What do you think, Hiranmay?
I slightly beg to differ with him there, because that's very subjective. As I said, at least kids today, maybe our generation is different. I hardly use AI unless until I've already done the whole thing and I just want to redraft it. For me, it's a different case. But otherwise, I have seen children, again, I said because of age, they just use AI left, right, and center, and just to get answers. Let me not even go towards the legal aspect of it. I will give you one more thing that happened recently, and it just caught me off guard when my team came to me. So you have your performance appraisals, and some is technical, some part of it is your typical value systems and all. There are people who use that AI for even filling those performance appraisals. So where is the creativity? I think unless until, he said, if there are prompts that you're really using, which is, again, intelligent enough and you have the right things to do it, great. But the dependence is so much these days that I think the creativity is really, and your WhatsApp university, your Google university, your internet, whatever that you want to call it, is so much that people don't want to. They're so heavily dependent that it's very difficult to reason out with any of them. You want to brainstorm with people, even within my teams, or when I do it individually with children, again, my daughter's friends or my son's friends. It's just curated, or their answers are very, very curated from what they've picked up from the internet. Right? So it's very different. They don't want to listen to logic. So you don't know how to argue with them in cases like this. So I feel it's too much of interdependence, or sorry, not interdependence, too much of dependence on AI and or ChatGPT or wherever. And it's just killing everything. I mean, I think there needs to be some kind of a mentoring there.
So I think in terms of what you said, fundamentally it comes back to training. And I will give you a live example of, once again, my firm. So one thing that we do very often, and these are called war room meetings, is that on the same issue, we will have everyone, say, draft something or research something, which needs to be diametrically opposite. We get all of the team members to play devil's advocate against each other in that war room meeting. So just like everybody else, I'm also trying that my team does not lose that creativity, and their first point of action or their first bullet is not a ChatGPT prompt. Let's assume that it is. Let's assume that the world evolves in a way where because of the ease that it gives us, and because of how fast it is and how empathetic it is and how accurate it can be with growing data availability, that happens to be the case. Then I think fundamentally, in terms of formal education and training, why can't, say for instance, I come up to ChatGPT with a particular problem and ask it to generate that specific result which it does. You know, ChatGPT can also be a great reasoning buddy. You can also speak with ChatGPT in the absence of another colleague or an employee or a friend. Why did you come up with this result? Have you considered this possibility? Tell me 10 other possibilities that could potentially go wrong. If there is no formal training, and like you said, if there is a single point of dependence, and after that single point of dependence there is no discussion, there is no logic enhancement, there is no looking at a parallel viewpoint, then there is absolutely no doubt we will live in a world where ChatGPT will define how ideologies are shaped in due course of time, with where power will wail in the hands of those who have the data or who have access to defining these large language models. But fundamentally said, I think because using AI itself is a skill today, how well you use it in terms of enhancing your creativity, looking at multiple viewpoints, and then of course building systems within organizations or within schools or within colleges to even keep that creativity alive because of the multiple viewpoints that you get on a particular issue is something that, you know, could keep this zeal for creativity alive in the world.
Yeah, I said it. As you rightly said, I think totally depends on training at the end of the day.
Yeah, it's just that I have dealt with some Gen Z people. They do come to us, and when I say that, okay, can you do this? They say that if ChatGPT can do this, why do I need that skill set? I need some different set of skill sets. So they say, okay, I have creativity. I need to transform my creativity from a traditional purpose to some innovative purpose for putting right prompts to the ChatGPTs and getting the right results. Because at the end of the day, results matters to the law firms. End of the day, the result matters to the legal departments. So for the Gen Z people, they are now adopting new skill sets to handle the ChatGPTs.
Thank you. So now my next question is again, Zoeb, to you only. So, you know, AI systems can inherit bias from training data. That is what we briefly touched base. So in a justice system that relies on fairness and integrity, how do we actually mitigate this risk?
Okay. There are technology available in the market to deal with biasness, certainly, because there are technologies like having golden data set validations. There are technologies like prompt engineering and so on. But apart from technologies, primarily we need to handle biasness by adhering to the discipline and legal instinct of the lawyers. That we should not forget. When I talk about legal instinct, it includes like fact-finding approach, asking questions, not assuming things easily. So when we deal with the clients, we ask a lot of questions to the clients, right? We remain interrogative with the clients. We don't believe clients very easily. Even if the client comes to our chambers, we ask certain set of questions and the client goes away, we tell to our colleagues, okay, he has not disclosed everything to us. Let's do a pulse checks tomorrow again with the client. So when we deal with the AI systems, why do we forget that we are lawyers? Why do we forget the legal instinct? Why don't we ask questions, the right set of questions to see whether the output given by the AI is biased or not? Because if we continue with the legal discipline, legal instinct, then certainly we'll be able to remove biasness, flaws in the AI systems, and even we can do away with the hallucinated case laws, because after getting the case laws, if we continue to adhere to the legal instinct, certainly we'll find that this case law is hallucinated. So when we say about the legal instinct and compared to the AI governance golden principles, even in fact this legal instinct by default includes the golden principles of AI governance which we are talking about. Legal instinct includes fact-finding approach, asking questions, remaining interrogative. And AI governance also talks about human oversight, biasness, and these can also be handled through the legal instinct. So that's the beauty of the law profession, that the legal instinct by default includes the golden principles of the AI governance. It's just a question of we always remembering that we are lawyers, whether we interact with the clients or we interact with the technologies. We should not forget that. It's about the behavior. We should never change our behavior. We should never give up the legal instinct. I'll give you one example related to this. A layman would put a prompt to the ChatGPT asking that, okay, this is the liability clause. Is this okay and valid? The ChatGPT would say, okay, this is more or less okay. You can make some modifications and then you're done. The layman would be very happy. But the lawyer would go a step forward. They would ask a second question to ChatGPT. They would ask that, okay, will this liability clause withstand the judicial scrutiny? And this second question, which the lawyer can ask, that makes a whole difference. Because then the ChatGPT will surely provide a response. Okay, good question, good catch. And then it will revamp its answers. So that second question comes from the legal instinct. To correlate this more, I would like to give you an example. I was watching web series on Netflix. It's related to Taskari, where it deals with custom officers catching these smugglers, right? So there it shows that even if the scanning system fails to detect the golds in certain materials, but still the custom officers are able to catch the smugglers based on their observation skills, based on their instinct, based on their sixth sense. So that is the same thing applies to the lawyers as well. So if we continue with our legal instinct, we will be able to resolve the problems related to biasness, problems related to hallucinations, and will remain accountable to our clients and will be able to provide expert opinions and qualitative opinions to our clients.
Okay, now see, all of us know that AI is evolving and it will take another 2 to 3 years or more than that before full-fledged, advantages of AI, pitfalls of AI is known. But so from that perspective, do you believe that India should have a AI, regulatory architecture in place, or existing laws would suffice? Yeah, Hiranmai.
I think as you rightly said, and other co-panelists have already shared, that AI is just evolving, right? It's all about innovation. And to put it, if I have to put it in a single line, I would say that we should regulate the risks and not regulate innovation. So what does that mean for us? So that means that we really need to have a very hybrid or a flexible approach and not be very rigid, as taking a cue from what Zoeb has said about AI at the end of the day. It is definitely important to have frameworks around, regulatory frameworks around AI, but I think we should India especially should take a cue from maybe EU to the effect where they have a dedicated AI law on a principle-based approach or a transparency-based approach, and at the same time, like what you have in the US, a sectoral approach as well, right? So in EU, it's more of your risk-based approach that they have, where you have the prohibited risk when it comes to AI. You have your high, medium, low risks. So the enterprise risk management of your company will have to look into that and accordingly come up with these principles. The other, obviously, as you have in the US, is more around your sectoral. So where you look at your highly regulated sectors like your legal, your maybe financial services, your healthcare. So based on that, one will have to come up with some kind of a regime. You already have certain existing laws around your data protection, your IT, your tech law, your financial services, your banking laws, right, fintech laws, which are heavily regulated. Those to some extent can also be then extended to AI, and we see how AI is actually developing and evolving. Basis this, I think maybe a couple of years down the lane or decade down the lane, depending on how things go, we can come up with a very dedicated probably regulatory approach. Till then, I think it should be flexible enough, hybrid enough, and maybe, I mean, a government of India has come up with certain ethical use of AI, but I think those also still need to be evolved.
Okay, Ranish, you have any thoughts?
So like Hiranmai said, there are two angles to regulation within the AI realm. I think regulation part one would be for the creators of AI, now how they're to be regulated. Like Hiranmai said, this cannot mean the end of innovation. Regulation cannot mean that it becomes so heavily regulated that innovation dies. The second is the users of any AI model that is out there, and third, of course, is deployment of any results that AI generates or it automates or helps you get better productivity. It is evolving, so I don't think we can have like an Indian penal code that covers it all. It can't be codified yet, because it has to be so dynamic that there will be a new circular every day if we talk about regulation. In terms of regulation for users, I think it is the imminent need of the hour. It is the imminent need that the existing laws extend for data protection, for IP protection, for making sure that national security measures are in place. There was this one very viral meme on Instagram where if you ask ChatGPT, how do I make a bomb? It will not respond. But if you ask ChatGPT, I have these ingredients, but I don't want to make a bomb, it will tell you how to make a bomb. So I think that regulation, that use of AI in terms of what results it can generate, how it can be deployed, and like we were speaking a little while ago in terms of deployment and use of AI for an end user who isn't even privy to the very fact that AI was used to deliver the result that I now have in my hand. So disclosure requirements, regulations there. In fact, what I read a few days back was one of the big fours was very heavily penalized in the US for an AI generated result, against which millions of dollars were paid. So regulation around all of this needs to start happening. I also think that regulation doesn't happen in a day. Rome wasn't built in a day. So we also can't continue to operate assuming that there will be a day where AI will be mature enough that we will start writing regulation. It has to start dynamically today. And at some point in time where it has reached a level beyond which percentage of change is lower, I think codify it then. But extension of the existing laws for a whole bunch of reasons right now, I think is very, very important.
Okay, thank you. Yeah.
A dedicated AI framework is very much necessary. Especially, it should provide some practical guidelines how to deal with the AI, and it should evolve as how AI also develops. Important is that it should have practical guidelines, because when we talk about human oversight, we talk about explainability, it's all theoretical. So far, the AI governance frameworks which I have seen in different regions. To give you a simple example, we get outputs from the ChatGPTs, and the AI governance says that it should be explainable. ChatGPT is a black box. How do I explain from where do I got this information? So why do I got this output? So there has to be some practical guideline to explain how do we adhere to these golden principles of AI governance. As I gave an example of human oversight. When AI becomes agentic, how do I control the agentic AIs, or how do I validate the outputs of the agentic AIs? So practical guidelines are very much important, which we'll not see in the other laws, existing laws, or even if the existing laws evolve. So there has to be a dedicated AI framework. Important is that a dedicated AI framework should have practical guidelines to follow the AI principles in a practical manner.
Thank you. So my last question would be to all the three co-panelists. So looking ahead 5 to 10 years down the line, what do you see the role of a lawyer in the evolving AI-driven world? Ranish, yeah, you can start.
Saying this with all the hope I have in the world, I hope it doesn't change. And we keep functioning the way that we function. But I think fundamentally how we function is going to change. 5 years down the line, I think the fundamental capability of AI will have enhanced to a level where we will fear replacement, because it will, I think, one, it will become even more affordable than it already is today. It will become more accurate than it already is today. It will become more empathetic and sympathetic, and will have so much context that it will be. So let's just assume this, right? Even organizations with in-house legal teams say they've fundamentally started using AI, and they continue to do this for the next 5 years. If the IT team and, for instance, the legal team's just good enough in that organization, it wouldn't even take 5 years. 2 years down the line, AI would be able to replicate a decision that a board would have taken, purely given the context that it now has. So AI, of course, has the capability to understand the very process of decision making. So I think the role of lawyers will fundamentally change, but so will strategy as a construct and a concept. So will ethics as a construct and concept. And I think in terms of how it is regulated and how use is limited and what you can and cannot do either in a litigation practice or in an M&A practice or a general corporate practice, a lot of that regulation will also define how that role changes. Fundamentally, up until the time that there were no motor vehicles in the world, there wasn't a Motor Vehicles Act. Now that there are motor vehicles, and personal injury happens to be the biggest practice area in the entire United States of America. Similarly, now that AI has evolved, AI will also become a line of practice for lawyers. So I don't think we will be out of a job, but yes, the way that we function today, or the way that we have functioned in the last 25 odd years, will fundamentally change in the next 5 years. Coming back to that line, there are decades when days don't happen, and there are days when decades happen. I think we're in the latter part of the world.
Good thoughts, actually. I would request Hiranmai if you have any inputs here.
I'll just probably layer what Pranesh said. I totally agree with him here. So I think, again, lawyers will become translators going forward, translators between law, business, IT, tech. That's what we'll be interpreting that for them, and we'll be strategic decision makers. And as he rightly said, it's not that AI will replace us, but I think it will redefine lawyers, right? That's who we are. And we will be collaborating with AI rather than AI replacing us. I think that's what we will do at the end of the day, maybe 5 years or 10 years down the lane. And we'll fundamentally be using more of AI, and people who don't, or lawyers who don't use AI will be replaced by lawyers who use AI rather than AI replacing us completely.
Yeah, that is a crux, actually. It's not that AI is going to replace anybody, but one who has a knowledge of AI, he will definitely replace his fellow colleague or subordinate who is ignorant on the AI. Yeah, what do you?
With the development of AI, we can expect to have some enhanced roles of lawyers. We can expect young lawyers, senior lawyers to be more strategic, providing expert opinions, providing value-added opinions. because clients are also going to become very smarter. They will get some results from the chat GPTs and will walk down to your chambers expecting that, okay, what value addition you can add over and above these chat GPT outputs. So there, it will throw more challenges to the lawyers, but we should remain confident by adhering to the basic disciplines and legal instinct. Because if we are strong on our observation skills, we are strong on our legal instincts, we are strong on our sixth sense, then AI cannot replace the lawyers, and we will be able to handle the challenging work, we'll be able to handle more strategic work.
Okay, thank you. So I would leave to the audience to ask any one or two questions to the co-panelists here. Yeah. Be loud.
I would like to ask you guys that you gave grateful insights on the user of AI and all. But my question is, you all might have. Hello. You might all have a great experience in legal field. So can you give some insights from the parlance of judges and their judgments? I don't think only lawyers or the clients use chat GPT. I think there might be some judges and other counsels who might be using AI. So what do you think? How their judgments can be nudged by the use of AI, and do you think there needs some any framework, or like you told about in law firms should have dedicated framework? So do there any need of any framework for their use and all?
Okay. Yeah. Would you like to give your thoughts?
I mean, I'll just say that in one line, right? AI always needs to be used as an input and not as an output. So any person, whether it's judges or otherwise, who's using AI is only for the purposes of, it's an entry point. It cannot be something where you just take that as an output and you come up with everything. You still have to use your own professional judgment.
Thank you, ma'am.
Yeah, I think that's right, because whether AI is being used by the lawyers or AI is being used by the judges, if they adhere to the basic disciplines, legal instinct, and most importantly, responsible use of AI, adhering to the golden principles of AI frameworks, then there will be no issues. Because whether the judges use AI, if they can ask the right questions and ensure that the biasness is not there in the outputs, there is no harm in using the outputs. So it's the question of how responsible we are in using the AI.
Okay. Pranish, you have any thoughts?
So, just adding on to what they said, and adding on to what I said earlier, it's about how many functions does a judge have, right? He will want to automate workflow. He will want to do quicker discovery. He will want to read precedent. He will want at least the facts of the matter to be written in a faster fashion, which already LRs do for judges. Will judge take the help of AI to write the obiter? Let's hope to God, no. Will judges take the help of AI to do everything else? Or for instance, right before a hearing, in matters that have dragged on for ages and they've just taken the seat, yes, AI will help them summarize it, which I don't think is an incorrect use of AI. But if that means stopping the application of the mind of a judge, I think then we just have robots listening to matters.
Okay. Okay, we can, the last question.
Hi, my name is Ganesh Natarajan. So I have two questions. One is to ma'am, and the second one will be a general question. Anybody or everyone can take it. So first question, like I'll follow my question with an observation. Like my grandfather at 88 or 89, he still remembers his friend's landline number from 60, 70 years ago. And today I don't even remember my parents or my best friend's number. So you had an observation on this topic. So I don't feel that it's a reduction in cognitive ability. I think after a certain point of time when technology evolves, like the society stops rewarding certain things. So today nobody is rewarded for remembering a phone number. So do you think that it is with the seniors' mindset, things might start to evolve a little faster. Because when the seniors encourage the juniors and say, hey, see, you can use this technology, there might be a lapse, but I'm here to cover you up. So that is my first question. Second, after your answer, I'll ask the second.
Yeah, sure. Again, being a mother of a Gen Z and a Gen Alpha, nearly, I'm totally with you. So when I talked about my observations around over-dependence on AI, it was more like when people don't apply their mind. See, and if you see the very first thing I said, see, AI at the end of the day is a productivity enhancer. It helps us deliver value, whether it's through scale, whether it's through speed, whatever we can. And if certain things can be automated, which is just administrative in nature, why not? I would rather use my lawyers, and we use a lot of, by the way, technology in our teams at WeWork, because we want to free up the space of our lawyers so that they can be more creative, as he rightly said, and start using their skills for something more productive, which as of now maybe AI cannot help, or if AI can help, how can AI enhance that further? So from our perspective, definitely yes, I don't need to remember a phone number when I have that stored, right? I still do, I am good at memory, so I still do, and I said I use AI to the minimum that I can, but where I think I need to use AI to enhance my skills, I will, and that's definitely rewarded because those skills can be used otherwise.
Yeah, I would like to add to that. Yes, for motivating young lawyers for using AI, we need to support them, we need to stand by them, because that's the role of manager, that's the role of leaders, that okay, if anything goes wrong, we will remain accountable, because that connects to the accountability, because we'll have to motivate young lawyers and colleagues to carry on with the work, to give us the end results. But if anything goes wrong, as leaders, we should be able to shoulder that thing and motivate our young lawyers to continue using the chat GPTs without worrying about the flawed results or anything. But before we do that, it's also very important that as leaders, we induct them how to use AI in a responsible manner.
So, in fact, just adding to what he said, at least for my team, I have something called an innovation goal as a part of their OKRs. So it is 20% of their weightage, where they're actually supposed to come up with tech-enabled solutions. And as a team, we sit down, we brainstorm, and again, we talk about responsible use, and we ask them to come to us as to why they want to use that goal and what is it going to serve. And we have questions around what is the kind of data that you're using, how can we use this, how does it enhance or how does it speed up efficiencies, how is it beneficial, what are you going to use, how do I trace it, how do I explain it. And once it's done, we actually have that idea into action. It's presented to the management. So it's something that we really encourage. It's a part of our goal system.
Thank you. I'll follow it up with my second question. So the second question is there's a lot of reference to ChatGPT. So 2 years ago, when I was in an IB, I had seen in front of my eyes how the AI strategy was evolving and how we were creating certain things in-house. So I'm pretty sure that you guys are from top companies. So I'm very sure also that you would have moved beyond ChatGPT. And I'm aware of the fact that you cannot disclose or you cannot talk about specific aspects. But in general, how are the companies, the top ones, how are they equipping? Are they creating certain tools in-house, or how is it shaping?
Yes, certainly. The IT tech companies, they have agenda that all departments should start using customized ChatGPTs, create bots within their departments to reduce the monotonous task, to reduce the team size as well. Even in legal departments, there is an agenda to use customized ChatGPTs. There is an option in ChatGPT to make your customized bots. There you can provide a workflow and blueprint of creating a bot. Like we have created bots for NDA reviews. We put NDAs now in this customized bots, and it reviews NDAs in just 2 minutes time versus 30 minutes. And how we have created that blueprint, it depends upon the blockers which we try and see in the NDAs. We train those blockers to the customized bots so that it can identify the blockers and do the same thing, replicate the same thing as how a human being does. We have created bots for drafting board resolutions. We have created bots for even first level review of the contracts by putting the blueprints into the customized chat GPTs. Now, when I talk about customized chat GPTs, you will have to do it in a very secured manner while dealing with the client's data. So we have Microsoft Azure as a technological system where the entire data remains within the organizations at a dedicated instance. And that's how the organization motivates us to create more and more bots to do the works in a fast manner and reduce the team size. So it's a very interesting exercise which we have been doing in our legal departments as well.
Okay, Pranesh,
So, just in addition to that, and I heard this from a banker, banks are no longer banking companies, they're IT companies providing banking solutions. The same will come true for lawyers as well. And in line of that, like you said, as a law firm ourselves, we've developed a product called Suit Up. It's a technological product. We developed it in-house. It's a large language model we've trained ourselves. It has automated about 60% of our workflows. A lot of the functions, there is a chat bot. My client can now go to that app and, just with a chat bot ask, what has happened in my matter? What is the latest update? What is my billing cycle? When should I expect the next hearing date or draft or whatever, So I think all of us are driven towards developing better technology even in-house to be able to deliver better quality of work. And like I said, we will become IT companies delivering legal solutions.
Okay, so we'll conclude this session. And my concluding observations would be like after hearing the conversations, we all know that AI is going to transform the way we are all working. So are we really ready for this transformation? And if we are ready, we should leverage it. And if we are not ready, we should we should be gearing up for taking the benefits for the future. Thank you all of you for your valuable inputs. Thanks. Thank you.
Thank you so much to all our esteemed panelists. I'm going to request you all to just stay with us for 2 more minutes. And that was a fantastic conversation on the topic AI governance and ethics in the practice of law. To felicitate our panelists, I'd like to invite on stage Mr. Anupam Ashish, Head of Marketing, Fortune India and Open Media, so that we can give this token of thanks to all our panelists for participating in that wonderful conversation. First, can we please bring it here for Mr. Zohaib Amin? Thank you, sir. For Ms. Hiranmai Ralabandi as well, thank you, ma'am, for sharing your insights and, of course, your personal experiences with dealing with Gen Z and Gen Alpha in this age of AI. And for Mr. Pranesh Goyal, bringing in the perspective of the young lawyers in this industry, of course, how they aspire to integrate technology in their work in the coming times. Also, many thanks to Mr. Tushar Gunderia for wonderfully moderating this session. Thank you, sir. Can we have you all for a group photo? Just if you can come to the center of the stage. Thank you so much. Anupam, please join. Well, ladies and gentlemen, a big round of applause for having a superb session. This panel discussion really sets the tone for the rest of the day as well. And I'm sure there were some questions that could not be answered because of the paucity of time. But I have good news for all of you. We are breaking for a networking lunch now. You can use this opportunity to connect with each other and put forth your questions even to our panelists. We hope to see you back sharp in about 60 minutes. It will be great if you could join us in 55 minutes so that we can start with the rest of the day on time. Thank you so much.
For nearly a century, Fortune has been the gold standard in business journalism. Trusted, insightful, influential. Fortune India carries forward this legacy, delivering editorial excellence and sharp insight into the people and the ideas shaping business in India and beyond. Every day, across platforms, Fortune India offers exclusive interviews, in-depth analysis, and reporting that goes beyond the headlines. It doesn't follow the news. It sets the agenda. Its flagship lists and rankings. Fortune India 500, Most Powerful Women, 40 Under 40, and Best CEOs are industry benchmarks driving conversations in boardrooms and beyond. It is no surprise then that it's the trusted read of CEOs, policymakers and entrepreneurs powering India's economic growth. This legacy of influence extends powerfully into the digital space. With surging web traffic and a fast-growing base of engaged readers, its digital footprint is expanding rapidly. Fortune India is more than a publication. It's a platform where brands connect with influence. Through curated events, tailored content, and strategic partnerships, it offers brands the opportunity to engage with the right audience, credibly and powerfully. With Fortune India, brands don't just advertise. They become part of the conversations, shaping the future of business. Fortune India, the final word on business. For nearly a century, Fortune has been the gold standard in business journalism. Trusted,
Lexa 2025. Now, our second panel discussion this afternoon will examine the enduring importance of human judgment in investigations and risk assessment, even as AI and data analytics redefine forensic methodologies. Now, before we move forward and invite our panelists for the second session on stage, I'm going to request all of you to please do use the hashtag, which you can see, Lexa 2025. It's also displayed on other panels. To use this for your social media engagements, we do encourage you to post your pictures, your opinions, your thoughts about this event on social media. And when you do that, please use the hashtag Lexa2025 and keep the conversations going both online as well as offline. Now, with that, it's my honor to tell you all the theme for the second panel discussion of the day. It's investigations, forensics, and corporate risk, why human judgment still matters in the age of AI. And this is a very logical extension of what we all discussed in the first panel discussion as well that happened before lunch break. Now, for our panelists, let me introduce them one by one to you. And as I take your name, I'll request you all to please join us on the stage. Let me begin by inviting on stage Ms. Aditi Mittal, Managing Director, Full Circle Risk Consulting, a specialist in forensic investigations and risk advisory. Can we please welcome her with a round of applause? Thank you so much. Welcome, ma'am. Joining her on the panel will be Mr. Ashish Chandra, Chief Legal and Risk Officer, Junglee Games, with extensive expertise in corporate risk management. Welcome, sir. Also joining us on this panel is Mr. Sanjay Kaushik, Managing Director, Netrika Consulting, a veteran in investigative and compliance services. Welcome, sir. Thank you for joining us this afternoon. Also on this panel, Mr. Surat Mukherjee, Head of Internal Audit, Times of India. He brings with him deep insights into governance and audit frameworks. Welcome, sir. And now to moderate this session, I'd like to invite on stage Mr. Nikhil Varshney, partner at Cyril Amarchand Mangaldas, specializing in disputes, white-collar crime, and investigations. So let's get ready for another insightful panel discussion. For that, I'm going to hand over the stage to Mr. Nikhil Varshney.
Thank you. Thank you. I know this is a session right after lunch, so many might have either just done with their lunch or maybe on the verge of sleeping, if I may say so. But I'll try to make it interesting. My panelists are already before you, and the speaker has helped me in introducing you to them. The topic that we are going to discuss now is, in the age of AI, why the human judgment still matters in investigation, forensics, and consulting and corporate risks assessment. AI, as we all understand, is now no more a specialized tool. It has made its entry into all our day-to-day lives in whichever shape and form it has been. Now, one important and critical space, I mean, of course, before lunch, as the speaker was also mentioning, we have discussed the role of AI in the legal market, in the legal circuit for lawyers. Now, there's another part to it, which is the investigations, which takes you to the boardrooms and the corporate drama that unfolds. And of course, lawyers again have a role to play there, and therefore I am here before you to moderate the session. What is happening is, and that's where we'll speak to our distinguished panel about it. In the field of investigations, forensics, again, AI has made its entry, like I stated. This is now no more a specialized tool, we all understand. What is happening is, when we talk about investigations is a very serious and a very critical part for any organization, because it may have ramifications or consequences which may be something which we may not have foreseen. We all today, as we speak, are seeing what is unfolding at HDFC in relation to the resignation of a very senior person that happened very recently. Now, all of this is something that, which again, and therefore there were in that letter of resignation, you would have noted that there were certain allegations in relation to how, why it was not happening per his expectations. And, there were few things which were, which were off for him. Now, be that as it may, the human element in investigations is a very important piece. In my personal view, my distinguished panel, I believe that, this is one such field wherein, you cannot wholly rely on AI. I mean, of course, AI can help you sift through unstructured and structured data. It can help you, make things a lot quicker. There may be thousands and thousands of emails which as an investigation agency you are required to perhaps, sift through. It may make things a lot more structured, quicker, faster. But then the ultimate question that arises is the algorithm that we have developed or the AI has developed, is it efficient enough to even foresee or, even respond to finer nuances like how the organization otherwise works, what are the behavioral tendencies of a particular organization. And therefore, in my personal view, and I'll be guided by what my distinguished panel has to say, I believe that this is one such practice or this is one such sector of field wherein an excessive reliance may lead to a disaster. So I would start with Mr. Surat Mukherjee, who is the head of internal audit at Times. Mr. Mukherjee, how do you, of course, as we have been talking that AI is no more a specialized tool. How much do you think would AI be able to replace human in the specific field that we all are in? Do you think that it would in few years from now it may perhaps demolish our role completely, or do you think that this is one field which would continue while algorithms and AI is good, but this is not something. This is something wherein human involvement would necessarily be required at all levels.
Yeah. Thank you, Nikhil. Good afternoon to everyone. I know it's a very, very difficult session, and in class when we were studying, we never used to sit close to the teacher. So if you're sitting close to the teacher, you get the first question, right? So before you understand, you get. So I was just thinking whether he will start from that side or this side. So I am, lo behold, whatever it may be. So let me start. So it's a very interesting question, and I think the whole world is grappling with this. Be a lawyer, be a doctor, every profession is thinking me or AI. And that's a question which is swinging every morning and evening like a T20 match. Every over you feel that they have an upper hand and then they make some blemish and then we have an upper hand. But the fact is that just like any other technology, because I am, you can say, outdated professional starting career in early 90s. So we were doing all our balance sheets and all the stuff manually. From there, computer came. And I remember when computer came, we were told, now we don't need you, right? So we got over that. Then another big giant or a demon like ERP came. So we were again told that now we don't need accountants because ERP can do everything. So ERP is there. SAP 4.0 now become HANA 6, but we are still there. Now there is AI, and the way I know AI is what we used to call analytics or data analytics. Then came a term called bot. Bot is automated, backend. Now we have AI, which is doing one step further. What it is doing for me as an auditor or as an investigator is that it is allowing me to move beyond sampling. So when we were starting our work, we used to take 5 samples, 10 samples, 15 samples, and the population was also much lower at that point of time. So maybe 30 years back, a 500 crore company is a huge company, big company, right? And we used to write ledgers with our hand. Now imagine today you can't do so, right? So the volume of transaction have gone by, the intricacies of those transactions have gone too much. So you need help, you need support. So today if I go to the board and say your controls are working fine, they ask what data set have you checked? And if I tell them I have checked 25 vouchers, 25 samples, 25 sales invoices, they'll stare at me and stare at me. So they want assurance around the entire database, right? And then they are telling that your sampling process has to be by scrutinizing the entire database. So the logic which is built behind the AI, how to intelligently pick sample, how to intelligently read the samples, how to find out what the data is talking, because every data talks. So specifically when we do investigation, Sanjay ji will be knowing very well that we later find out that the data was standing on the roof and was shouting, look at me, look at me, look at me. Right? People are doing something wrong around me. But if you don't have data to say where there are unnecessary spikes, where the raw material price is going completely north and the margin is going completely south, where suddenly in certain vendors, in certain customers, you see that the margins are shrinking, or there is concentration of transactions in a particular time, how data entry is being done, how, whether people are working on a Saturday or a holiday, a late night, after work and passing transactions, who is downloading information, who is uploading information. So when you look at all that spectrum, there are multiple risks which come in front of you, but you cannot take that output and run to a board or run to any platform to say, look, I have found this and I have found that. You need to stitch the story. So the storyteller has to be either the forensic accountant or the auditor or the investigator. So when you stitch the story, this data needs to be also double checked, triple checked, because as you said, in litigation, people will not look at emotion, the judge will not look at stories, judge will not look at hypothesis, judge will only look at hardcore data, which can stand the test of time over multiple rounds. So what AI is doing to us is it is helping us to do things faster, quicker, but we have to have the reins of that software in our hands at all the times. Whatever it gives, whatever we tell it to do and it does back for us, we need to cross-check. Specifically, if you have to take people action, or you have to go for a litigation, or we have to suspend a vendor or blacklist a vendor, whatever the case may be.
Thank you, Mr. Mukherjee. I think it's a good, I mean, it's a good start to the session. And why so? Because you at the right start of the session, you have put forth the importance of data, which has to speak loud, and which is what data becomes more investigation in this investigation space. And that takes me to Mr. Kaushik, who is a very seasoned and perhaps a veteran and also a veteran in this industry of investigations and corporate risks, etc., etc. Mr. Kaushik, my question to you would be, and because we all have been seeing AI for quite some time now, where do you see the biggest advantage that AI is bringing to the table for you and your team at Netrika? Or how are you guys developing or grappling perhaps with this advent of AI in our industry?
So thanks, Nikhil, and a good afternoon to everyone. So I think AI, everyone is talking about, and it's become the buzzword today. But before even moving forward, let me just give you a real case scenario. We are in midst of developing some products with AI. Because everybody is doing it, we thought why not we as well, right? Though we think that when it comes to investigations or intelligence, it's divided in two parts. One is human end and another is tech end. The kind of information which you can get, or something, I think everybody would have seen Dhurandhar 2 by now, or at least Dhurandhar 1. What the guy Hamza has done there, can any AI do that? So human end will always remain there. Human end will never change. It is only the one part which is tech end which is changing. And coming back to what we are developing right now, so while we were developing, we have observed a couple of things. One, hallucination is a big thing with the AI. You start developing something and it will hallucinate and it will take you something where. And then you will have to tell the AI, no, hold on. We were not doing this, we were doing this. Pick it from there and then start working. AI is just like any of your other team member who can forget, who can miss, who can pick up things from a different thread at all. And it's so funny when I sit with my developing team and understand and hear their thoughts and their real case scenarios. It becomes like, oh, it's like I'm talking to one of my team members who will miss, who will be probably absent, who's absent-minded, his mind is somewhere else, and picks up from somewhere else. And then it comes a very, very absurd kind of a thing when the AI says, this is beyond my capabilities. I am referring it to my human engineering team. I said, hold on, we thought AI is everything. No, but it says, I'm referring it to my human engineering team. And then we asked AI, how much time will it take? And the answer is, I'm sorry, I do not have visibility on the workload they have, and we will check and let you back. So it's like we're far away from where AI is going to take away all the jobs and everything. It's not happening soon. Like what Suraj said, that when computers came, things changed, but the capability sets, the job opportunities actually increased. There were multiple increase which happened into multiple job opportunities, coders, different kind of job skill sets. The typewriters were gone. The fax gone after email came in. So things will keep changing. It will not remain the same. But will we be obsolete? No. But what AI can do for us is, again, in investigations, one of the most important area after everything you've done is an interview, investigative interview. When you're doing an investigative interview, it is said that 80% of the time it is the observation or it is the non-verbal clues which speaks about. It is the body language, the posture which talks about, right? Can AI read your body language? And can it be, so while in an interview, an interviewee on a question starts scratching his nose and AI will say, oh, this is a red flag. He is a culprit. Doesn't happen. Not any single point of your action decides that whether you're telling truth or you're telling a lie. It has to be 360 degree. Can AI do that? No. What AI can do? Like what Nikhil started with, AI can do is when you're doing a digital forensic of a laptop, there are thousands of emails which comes in. With the keyword searches, you have those keyword searches throwing still few hundred emails to you. Can AI summarize that for you? Yes, AI can do that. Anything which is a routine job, anything in routine, AI can definitely do it for you. But if you think that AI can take on, at least on the investigation side, I'm very confident. It's way, way far away. And yeah, there are some tags, there are some kind of APIs which are available. So earlier in investigation, when we used to find out, say, I have to find out, I only have a mobile number of a person. We'll go online, we'll try to find whom it is associated with, what PAN number it is, and from the PAN number you start digging multiple other information. Now there are certain APIs which can give you just with mobile number multiple informations. That is more of aggregation of the data sets and putting it into, and again, another thought which I always tell my people is, do not confuse AI with automation. Lot of time, people are automating their processes and saying it is AI. No, it is not AI. It is just the automation of the process. Thank you.
Thank you, Mr. Kaushik. I think because we are in this space, so we understand that AI is definitely not equal. Is much more than automation, and and that's where that takes me to Mr. Chandra, because he comes from the GC space. He's a chief legal and risk officer. From your standpoint, Mr. Chandra, if I may ask this, what concerns do you feel arise for an organization like yours or others that you have been part of, if you think that that the organization, that the AI output is something is purely being relied upon for an investigation or for a corporate risk assessment? So your thoughts on if AI output is solely dependent on solely dependent on your AI output being solely dependent on your, not the AI output, sorry, my apologies. Point being, if the AI is, for your organization's perspective, what are the concerns do you see that may arise in a situation where, the AI output is being solely relied upon in an investigation or a corporate risk assessment?
Yeah, thanks. So my answer will be based on the hands-on experience of personally building AI, both for my corporate, okay, as well as something which I think that, being a lawyer, I'm not practicing, so I cannot fight pro bono cases for the poor people, but I have really put my experience of tech law and building the legal AI for the poor people, that's called as equaljustice.ai, that just solving their common legal problem for the common people in 10 Indian languages, and consultation is free. If they choose to get output, they just have to pay 10 rupees. But anyway, so I think all these things which I've been building over last about 18 months, what I'll say is actually a practical experience. So I think let's first bust the myth. AI is definitely going to impact us as professional. Whether we are lawyers or risk professional or accountants or tax professional, it is going to impact us a lot, okay? It's not a bit, a lot. Now, let's put some number into it and how I think you all can participate more gainfully and not being impacted by the AI, and your client will get the best output both of actual intelligence and artificial intelligence, right? Now, it's a rule of 80-20, and you can implement it in your own AI journey, whether it is for risk or for legal, and where you think that there is an involvement of human being. Now, the 80% job that we are doing as a human being, because we come from an intellectual profession, we eat food because of our brain power, okay? AI is what? It is a neural network, right? So it is going to complement or supplement our intellectual power. So the 80% work is going to be taken over by AI. But yes, the 20% work, which is the judgment part, right? Where your Sanjay Bhai said that, when AI fail, it says that I cannot go beyond it. You have to go and check with some sort of an expert. That 20% would forever remain with a human being, right? Because that is where you have to take a judgment, right? You have to take a final judgment to really do a particular activity or not do a particular activity. Now, the important part is that the long tail of 80%, okay, wherein the 80% of task which is currently being done by youngest professional to a senior profession in our profession, right? How can they participate in building the AI to perform their task? I have just one slide. If somebody can put that slide. I've just made it for, not for this one. I gave this kind of presentation when I was there in London, and just explaining lawyers that how they can participate in building AI, not being afraid of losing their job. So can somebody please put this one slide, please? And if the slide gets put, I would encourage that everyone should take out their mobile phone and please take a picture of that, okay? And please put that picture as your desktop wallpaper for next 6 months. Okay, if you want to make sure that your professional life is not impacted by AI, okay, and you want to be part of that 80%, please take that picture, okay. Forget about taking picture of any Bollywood star and all. Take this picture, put it as your wallpaper, either on your laptop or on your phone for next 6 months. Every day in the morning, you wake up, you look at it, and whenever you are using AI, whether it is ChatGPT or whatever, right? So this is the entire journey, entire end-to-end landscape of how the legal AI is built. And I'm not talking about ChatGPT, I'm talking about Harvey, I'm talking about Legora, I'm talking about anything which you may want to build specific agent on the legal AI. Left hand side is all the 12 steps that is required for any legal AI agent to be built. On the right hand side, it is where the involvement of a lawyer is. And I have been very meticulous and intentionally putting in the bracket that at what step what stage of experience of a lawyer will be required. Now you would see that out of 12, only in 2 instances, we don't need lawyers. We need hardcore engineers. Now, if a lawyer can be engineer through vibe coding, you can also take over that. The world is open for you. But for 10 elements, okay, lawyer is required, right from the junior most to the senior most. I'm not going to spend much time on this. Please take a picture. You can connect with me offline to get more understanding. But please take a picture, save. Now, if you do this, right, you would need the human element on 2 aspects. One is to build. कि भाई आपको AI build भी तो करना है ना. अब आप अपना वो PDF लेके, वो data ले, Excel sheet लेके chat GPT में डालोगे. You have to build your backend agent, right? Now, for you to building that backend agent, you need the relevant professional, like who are sitting over here, that how to read the data, how to sanitize the data, how to build a system from how the data should be talking to each other, what is the persona of the AI that it should be behaving, triangulating with the user question. You have to preempt the user question to build a persona of the user. So I think if you do that, I personally feel that Sanjay bhai, the issue of hallucination, right? I think you will get 99% accurate kind of answer because this AI is built by human being. It's just not, uploading. Now coming from a risk standpoint, so like both of them said that the AI interprets the data in a more meaningful way and present the data to us in a more actionable way. But the judgment which action to take would always lie with a human being, right? But I am sure that being part of the AI development, okay, myself, I believe if not in 2-3 years, but maybe in 10 years, only love at first sight will belong to human being. Otherwise, everything will belong to AI. I don't think AI can fall in love at the first sight. Yeah.
No, that was a good one, Mr. Chandra. That takes me to Aditi. Aditi, you have been in this industry, for a very long time. And of course, now with the advent of AI, at least for the past 1.5 year or 2 years, if I may say so, it has come up like anything. Now, would you, of course, there is some experience which you would have built over a period of years, and connecting to what Mr. Kaushik had stated that, when we conduct these interviews, a significant, stress has to be also put on the, on the body language of a person being interviewed. Now, my question to you would be, how do you draw a balance between, let's say, an AI-led red flag report versus, and the experience or the intuition that you would have developed over a course of, years, over the course of decades? So, where do you see this going?
So I think we have spoken about data processing, data analysis till now. We haven't touched upon data collection, which is still, outside AI domain. In the field of investigation, we collect data. That is our primary job, to collect data, collect evidence which is relevant for legal teams. And that's basically the evidence that we are producing for them, right? And that involves both structured and unstructured data. And at this point, at least, there is no AI tool which can cover 360 degrees of, angles and dimensions of data collection. It can only find out information which is available in the public domain, open source. It doesn't even have access to, databases which are locked behind login passwords, or even, the newspapers which are behind the paywall. So it doesn't have access to those resources which are available in public domain, but not are freely available. This is only the structured data. And then there is a whole sea of unstructured data, which has a huge dependence on human intervention, where we required field operatives, social engineering, human element to get that information, which is not there in public domain. So whatever the AI will generate, the red flag report, firstly, I will not take it as a comprehensive information. It will not cover the entire, based on the entirety of that information. Even if it kind of flags some sort of, risk, for instance, let's say credit defaults, right? The human element now comes to, at how material are these red flags. So for instance, we were doing a project where, we identified a credit default on a person in India, and there was a lookout circular because he was a willful defaulter against him. Now, my client sitting in Europe is panicking, because they want to deal with this person, and they want to understand how material is this information. But only when you probe further, you'll identify that you'll have to go through layers of data, again, maybe CIBIL databases, what was the history of this credit default. And what we identified was that the default, firstly, the amount involved was not material. He was only associated as the director of the company, so the liability of paying back was not upon him. Secondly, the second layer of identification, what we found was that he had his own company and he had accessed a loan recently, which kind of indicates that he's already been kind of, passed by the mainstream banks. He has accessed credit in India despite all the red flag. And even, when we read further into the lookout circular requirement, you kind of, make sense of it, that it is more of an administrative requirement rather than having a more criminal implication to it. So when we gave all that analysis and, subtext to the findings, that's when, the client kind of gets you the whole picture that, yes, it is some sort of a red signal, but it may not be as material to kill the deal. So I think those aspects are very important, the human element, to explain what's behind that red flag.
Thank you, Aditi. Mr. Mukherjee, because you head the internal audit team at Times Group, which is such a large group, and of course, given your vast experience, why don't you, share some thoughts on how do you see that, while the professional skepticism and independent judgment is kept intact, and, and it is happily, perhaps, getting married to AI-led results, so that, the auditing, the internal auditing, or, the corporate risks associated to it are, are carefully being, looked into by an organization like yours, or, multiple organizations across the country. So your thoughts on that, please.
See, in our case, in audit or in investigation, we cannot solely depend on any output which is coming from AI. Correct. Because we have our own AI tools which are used, whether in the editorial, in fact checking, in report checking, in our anything which get published on the paper. But that's a very, very strong mechanism which is there. So we, as of now, we use a very, very secure environment AI tool, because there are multiple information archives, confidential documents which are there, which we cannot afford to be leaked into a public domain. So we'll have to be very mindful. So when we use AI in our ecosystem, it has to be a licensed tool in a very secure environment where we keep the training tab of the AI off, and then only we can use it. So it's a very, very, I would say, secure environment in which we need to act on it. And anything and everything which comes out of it, we are also not fully, in a way, willing to put both our feet in the water at the same time. So anything which comes out, we appreciate the new insights, the new angles which the AI tools bring to us, but at the same time we almost, you can say in certain cases, do a parallel run of the whole activity to see how authentic they are. Specifically when it is about giving some core insights to the management or to give some data which can then lead to some serious investigation or some outcome which can lead to significant change in process or even people action. So we are working on it and we feel it will be always a work in progress and it will be a tool in our hand which we can intelligently use to cut down time, to get more pointed outputs, but in the end, till we become completely sure about its outcome, that the outcome generated automatically will be perfect. Like for example, we can do a duplicate search to stop a transaction, or in case we find that there are maybe splitting of purchase order happening or too much concentration of work going to one particular zone or a vendor, you can always put a stop and put a red flag to say that this transaction cannot go forward. So instead of an individual trying to look into it in a high volume transaction world, you can stop the transaction from going through. You can block the transaction, make people get a warning then for somebody to come in. So we'll have to understand all of us are working in a live business environment. So you cannot go back and tell a customer that this is what my AI has done, so your high value check has not gone through or your LC payment has been stuck down, because everything has a ramification on the back end. Somebody can come back and tell you, okay, give me $10 million because your transfer didn't go through, so my contract fell off or my deal fell off or I was not able to do. So wherever there are customer facing interactions or decisions, we'll have to be mindful that there is a check out there, unless and until the other guy knows there is an AI which is deciding it. Like for example, today most of the bots we know when we deal with, they have a standard set of answers and questions which they can give. But I know I am dealing with a bot. I can ask the bot to escalate it to a next level so that a human comes in case I need it. So that option we have to always give to that platform.
So basically, I think we are then, perhaps one thing which I can say basis what all I have heard thus far is the fact that, we are moving towards an age wherein there would be a premium to be paid for human intervention. While everything may be AI, generated, but ultimately if you would come to a lawyer or a investigator or a risk analyst for, for that to bring in that human intervention on the table. Mr. Kaushik, my question to you would be, because you are very active in the investigation space. Now, of course, AI is very helpful. Aditi also spoke about it, that there are 2-3 parts: data collection, data processing, data analysis. AI, of course, is I do not deny the fact that AI is not helpful when it comes to investigation space. But do you see how can organizations make use of AI in your view from the standpoint of proactive risk measures that the organizations may want to take? Do you think the AI can be helpful in that regard? And what do you think are the practical limitations strictly related to this?
So I was in one of the other forum. The GC of, not the GC actually, the CTO of Visa cards was sitting next to me. And he was talking about the kind of email threats, phishing threats, and the attacks on their systems, what the AI is actually stopping every single second is into few hundred thousands. That is AI for you. Human beings, how many teams you require, what kind of systems, and there's still a chance of missing that one. So definitely AI plays a very important role when there is routine job, when there are set parameters. When you have A, B, C, D very clearly defined, AI will work on that. Right? We are working with a bank right now, a very big, private bank in India, one of the biggest. We're working with them. We're developing their SOP. Of course, they have a very defined SOP for frauds and cyber frauds and multiple other things. But we are in the process of defining their entire processes. But with that, they want that my teams sitting in Calcutta, Mumbai, Delhi,
and multiple other cities. On the same case, the decision of X versus Y is totally different. And then we have to explain that why this decision was taken. Can we put everything into the automated version or an AI version where the AI reads the report, basis on the facts put into that report, the decisions can come out. However, as we all know, English is a very funny language, which Amitabh Bachchan said many, many years back. Even the full stops or the commas at the wrong place while you're typing in, or your typo mistakes into your reports can give a wrong prompt to AI to give you the wrong decision. So it is all about what is your inputting it and what is the output you're getting it. Can AI be used for proactive approach? Yes, definitely. It's one of the best technology we have right now, but also we need to understand one more thing. And again, a very funny example comes to my mind, because whatever we are inputting into the system, it is also going into the servers and it is used for machine learning. Now AI is learning from where? All the data which we are inputting into it, right? Now one of the case, a guy having 4 or 5 different girlfriends asked AI how to keep them happy and what gifts I should give them. And the other guy, and he's a celebrity guy, the other guy just wanted to have the name of the girlfriends of that guy, ask the AI, and AI throws back from the same input which was put in by this guy, AI puts it back. So while we are investigating, we are also doing a lot of input of our very confidential and high stake information into the system. Are we actually mindful of that? Most of the time when I am using AI, and I generally use it for when I don't want to spend too much of time drafting the emails, I will actually use and remove the most important parts like name, the designations or certain things. I will just remove it from it and let it throw, and then you write it. So human intervention is very important and you have to be very carefully using it. But to answer your question, can it be used for proactive approach? 100% yes. It has, like I said, routine jobs. Like even Suraj said, throwing up the red flags. Can a human being look at the entire data set which is present into your ERP system, SAP systems or whatever it is? It's practically impossible. We used to work with samples, right? Now, with AI and the technology, it can actually check every single word which is there into that. So that is somewhere which can be picked up. But in the investigations again, I think when we talk about, when you have to identify a fraudsters, the first thing comes is, even before the data starts speaking, like Suraj said, data speaks very loud. But even before the data started, the behavior of the fraudsters starts speaking. The behavior immediately changes. He will either start changing, taking leaves abruptly, or be available on the weekends, or dressing sense changes, or the way he talks, the expenses. These are certain things which AI is still way beyond to reach that level.
Perhaps it may be, when we speak next year or a year after, maybe we would have reached a stage where it has, reached that. So, Mr. Kaushik, before I move to Mr. Chandra, I have one more question. Because, of course, in litigation side, we all speak of hallucinations. The Supreme Court has talked about it. The courts are talking about it. The lawyers are talking about it. And it is, natural when you see cases being made up which do not even exist, or maybe the cases exist, but the paras cited therein are not part of the ultimate judgment that is there. Have you witnessed hallucination being an issue when it comes to processing of data or collection of data from the AI standpoint in investigation space? Is it something that you have come across, or this is not something? The hallucination is not a problem, at least in this part of the world.
Fortunately, the kind of tools which we are using, they are very mature tools, and they are world renowned, and most of the tools which you must be also using for
email discovery or,
Yeah,
you know,
relativity, etc.
relativity or in case or some of those. They're very mature tools, and we haven't seen that kind of hallucination or other things with those kind of tools.
Which is a very good thing, I think, at least in this, which is a good thing. Mr. Chandra, given your experience, and because you have been part of corporates for a very, very long time, my question to you would be what do you think?
Can you bring the mic?
Yeah,
Please.
my question to you would be, do you think that board, how does, AI you think could be the best, could bring in the biggest advantage on the table when it comes to boards and corporate risks? What is it? Of course, we have not spoken enough and more about the negative side of it, and the necessity of human intervention which is required. Perhaps a premium, which I say perhaps would have to be paid in times to come, only because of that the human, because most of it would be done by AI, but the human intervention would require a premium to be paid. Now, insofar as organizations are concerned, corporates are concerned, what is your takeaway, or what is your take on how boards or corporate can make most of AI from the risk perspective?
Yeah, so before I answer this, just to go back to your question of, let's say, hallucination in terms of court pleadings and judgments and all. Look, one way to look at it is that like Ms. Sanjay Bhai said, that their AI is very professionally evolved. They are sophisticated. Now, if as a lawyer you are using a free version of ChatGPT or a Gemini or a Claude, they are as good trained as even a first year law student, right? You are expecting a first year law student to understand your fact and give you the right, accurate Supreme Court jurisprudence. I think this is a disservice that we as lawyers are doing to our profession, and few of those bad judgments bad activities are being called out by Supreme Court, and it gives a very bad name to our profession. I think it's good to use AI. You are earning money from your clients to help them by using AI. What stops you to pay for a better AI? What stops you to pay for a legal specific AI? I think it's more about the maturity of the lawyers, which is bringing this kind of negative aura around it. But I'm sure that a firm like yours, very, very big and respectful, your firm lawyers will never bring in those kind of stupid judgments. So it's not a fault of AI. It's a fault of the lawyer not knowing how to use AI. So coming to the question on the impact of the AI in terms of board decisions and the company risk, I will give you, and I can take the names because these names are in the public domain, 3 examples of extreme or the entire shareholder wealth gone down the drain. Most of the Indian startups and your big corporate don't fail because they lose a Supreme Court judgment or they lose a tender. They fail because of the corporate governance, right? And let's take recent example, your Fino Payments Bank, such a great bank. I have a lot of respect for them, but I think the way they dropped the ball on the corporate governance. We all know the case of Blue Smart cab. I used to love that cab. No surge fare, very clean, on time. I'd fallen in love with that brand. But just because of corporate governance issue, it became zero. We all know about Go Mechanic. We all know about a few crypto exchanges. They all have fallen because of the bad corporate governance. Now, if AI is intelligently deployed into the day-to-day operations of the company, for example, a very sophisticated engineer, very experienced engineer, working along with risk professional and lawyers and accountants, build an AI which triangulates the financial data, which triangulates the employment data, which triangulates your tax filing, which triangulates your board minutes, which triangulates your MCA filing, which triangulates the various litigations you have, which triangulates the background check of the vendors you have done, right? Like, you know, like in risk parameters, you have, let's say, 10, 15 kind of parameters. A very intelligently built, okay, AI, if it triangulates, and let's say at every morning at 8 a.m., it refreshes, you know, and sends out a report to the chairman or to the board or to the key investor. And the same thing is done at 8 p.m. every day. And in between, if there's a major risk happening because the AI is working 24/7, it will be expensive to deploy because your I mean, tokens and cloud will keep on running 24/7. But here we are talking about saving of multi-billion-dollar worth of shareholders' value. I can bet my career on it, right, that these companies would have been saved. It is just basically maybe the intent was not there to bring in the best practices, or maybe most of the companies, I mean, in my experience, I was fortunate enough to work with the world's best companies. So, but I have seen other side of the world. I think it is most of the investors and the board and the founders feel that risk and compliance and legal is a bug in the business. मुझे time spend नहीं करना, ये क्या बकवास की चीज़ है, क्या चीज़ है, risk governance compliance. They 99 out of 100 would fail. But those founders, those investors, those chairman board, they believe that this is a feature of my business. Unless and until I address the risk and legal and the compliance parameter, I should not be building any business model. Those are the companies come out very big, Tatas and Birlas and Reliance of the world, right? So to answer you, sir, I think AI is a magical wand right now to ensure that the extreme level of shareholder wealth, destruction is being avoided. And I think that's what the people at the board level are looking at. They're not looking at the legal AI tools to compare to NDAs, right? That's important for the legal team. Yes, your law firms, and the legal team also have to build in their kind of efficiencies and all to churn out the contracts fast and NDAs fast and all the proofreading and all. But at a board level, I think a lot of triangulation has to be done. And also to complement Sanjay's point is that what is a secure environment that you are giving? You know, if my extremely confidential information is being fed into an AI tool, the backend architecture is very important. You cannot afford to save few lakh rupees here and there just to make your backend architecture weak. You cannot use an OpenAI or a Gemini or a Claude and a Grok. You need to get a self-hosted model which you can host in your Amazon workspace, whether it could be Mistral, it could be DeepSeek, it could be Llama. So I think a lot of architectural time has to be spent to build it so that when AI is helping you to give you the insight to protect your company, it's not being used by your competitors or the others. So it's a magical wand. I think it is like a Ferrari car. You just need to have the right driver to take you to your destination in the fastest possible time.
I just have to make one point on hallucination. I think everybody would remember the Deloitte case of Australia, where the ChatGPT, the report was made by ChatGPT, and ChatGPT further made up the cases which were never there. And that report had the examples put into of those cases which never happened. So I think hallucination and making up by this AI is something which has to be, human intervention is a very, very important aspect there. If you do not read and put your time and analyze what the output is by the AI, I think you're going to be a little bit into a problem area.
I completely agree, Mr. Kaushik, because compliance and corporate governance, while they may be underrated, but Mr. Chandra was talking about Gensol and then your Blue Smart and then now HDFC. I think one thing, while this may be underrated, but this is definitely something which which when becomes prominent, it can perhaps lead to major things shattering purely because of the fact that this continue to be an unseen or unwanted part of the industry, which is perhaps not something which is money making for an organization, but definitely, you know, when all hell breaks loose, then, you know, this is one part, one serious and critical part which becomes very prominent. That takes me to Aditi. Aditi, I'll just take your quick thoughts on the issue that, you know, in my experience of conducting, you know, internal investigations, of course, we conduct it together with, you know, organizations like Netrika or the other forensic analysts. And, you know, I believe, and in my experience at least, I've seen that, you know, context is very important. Hallucination is one part and then context is another. At least in my experience, what I have seen is that, you know, AI at times, while may not be hallucinating, but in this piece of the sector that we are in, there can be instances of missed contexts, okay? And over-reliance on technology or AI can, you know, lead to missed context, which may perhaps, you know, which may be very, very relevant from the corporate standpoint. In your experience, have you come across any instances wherein, you know, the over-reliance on AI or over-reliance on technology has led to missed contexts, or, you know, has led to unwelcome or undesired decisions?
So, so like Mr. Sanjay said, that as an investigative firm, we try not to use too much of AI in our work, because the reason why clients hire us is because of that human intervention anyway, right? But anyway, sometimes we are doing, you know, simple background searches on the subjects. And for myself, like, I deal with a lot of cross-border engagements which involve non-English jurisdictions, and sometimes we are dealing with, you know, PDFs or documents which are not in English. So this has happened to us actually quite recently, and only once, where we were dealing with a Bangladeshi subject, and we found a document, open source, which basically had a list of awardees of a tender released by Bangladesh government, and it was in Bengali, of course. So the initial instinct is always to, like, dump it on AI and just get an initial sense of what is this document is about, right? And it kind of translated in English, and like you said, it hallucinated the name of our subject, and it gave us something else. So we sort of discarded that PDF, we kind of like passed it. But I make a point that with all our non-English jurisdiction, we have a local language researcher deployed on the project. And on this one, we had one local Bangladeshi researcher, and he kind of pointed out that the name of the subject is in this document. But I wasn't sure, so I reconfirmed again with another Bengali speaker in India, and he also confirmed that the name is there. So that kind of was an eye-opener, that you know, and that particular point kind of added to the credibility of the vendor, you know, of the subject. So it could have added value, you know, in our final report. So had it been, you know, we had missed the point, it would have been and I'm sure because our client was they were European, so they wouldn't have found it otherwise if we hadn't put in the report. But the point is that this idea of hallucination is definitely there, especially in simple tasks like, you know, translations and, you know, identifying the context of let's say, of an interview. Sometimes I have also seen, sometimes it extrapolates the interviews on its own, you know. So what has not been said, it kind of adds into the interviews. So it's again, like, you know, that human intervention again reinforces that there is all sorts of intervention, not in just terms of language speakers, but also subject matter expertise when it comes to, let's say, accounting or whether it's forensics, that has to be deployed on a project when it demands it.
Thank you, Aditi, for that. I think we are moving towards, you know, closure of the session, and therefore I would now open the house of questions Guys, happy to take questions if anybody has questions for the for the panelists here. Sure, please.
Simple example, if you can just tell us if the AI can be used proactively when the human intervention, because you made both the points that human intervention is also positive or imperative, and then we just need to draw the line.
So like similar example which I use for Deloitte ChatGPT Australia report, if that person would have read that report, he would have understood that there is something wrong and this needs to change. The AI will actually throw up a lot of red flags. And generally in investigations, what we say is, it's always a red flag. So like what Surat does in his organization is internal audit, IA. It's opposite of AI actually, internal audit. They picks up the red flags. So the AI will certainly throw up the red flags. Human intervention is required to check those red flags to see that whether that requires a further investigation, further analysis, further inspection, or they are good to go. So those are important things to look at when it comes to AI versus human intervention. I think one question was that.
Sorry, I just have one thing to add here. I have sometimes used it, with the proactive question. I have sometimes used it to brainstorm ideas on how to launch an investigation. For instance, like we were dealing with an anti-competition matter. We supported a Malaysian firm who wanted evidence of dumping practices across Korea, Vietnam, and other jurisdictions, which was one of its, kind for, which came to, when it came to me. And there were various directions that we could go, when launching the investigation. But I think in this case, like, how I used AI was to give it a scenario that this is what the scenario is and what could be the ways to launch an investigation on how to design the strategy, So I don't think, like, I'm not sure if, I don't even remember whether I took it 100%, the suggestions that were given, but it could be a good partner, especially when you are an independent worker, when you don't have a huge teams. It could be a good partner to brainstorm ideas, whether it's investigation strategy or whether it is setting a litigation strategy.
No, Aditi, I would like to add to this. Sorry, I'm just taking a minute there. I think it also helps you if there is it's a fairly large investigation, let's say. It helps you identify the subjects whom you would want to interview. Okay, yeah. Point number one. And point number two, in what fashion you would want to interview them, in the sense who would you want to interview first, and then how you would want to place play it out. So that's also something wherein AI could be does help significantly. You talked about the launch of the investigation, even in this part of the interviews and the what questions, what answers you would get from this, which would be relevant for somebody whom you would be interviewing later, is also something wherein and of course it's not for a small investigation, but in a fairly large and complex investigation, this comes in handy. Thank you. Anybody else, guys?
I have a question.
Yes.
Is it working? Yeah. So good afternoon. I'm Aryan Jain. I'm working as an associate in the corporate and M&A space. My question is that we talked about the use of AI. So do you foresee in the near future that companies may put restrictions on the use of company data on the AI tools from the perspective of confidentiality and data protection? And what kind of restrictions can we see?
So, I mean, companies are concerned about what kind of data is being fed by their employees into the AI tools. It's not only about the legal risk compliance, it's also about the coding, right? The what code, what kind of business requirement document, BRD, PRDs. I think there is a mature way of handling things, okay, already in place. So when you purchase an enterprise version of a hosted AI, let's say Gemini, OpenAI, Claude, whatever. So they actually build in a feature where it says that we'll not use your data to train our model, right? And they also have some settings, right? So you could really okay, toggle yes and no that okay, do not use my data for. But how much do you want to trust those companies that they are actually walking the talk, that only some sort of a lawsuit filed against them either in India or US will come to know, right? But the real safeguard comes when you do not use hosted AI solution, you self-host it. And there are multiple 70 billion to $7 trillion kind of data sets, okay, model which are Mistral and Llamas of the world available, where you have to download it into your own server and can firewall it. वो थोड़ा expensive होता है, but you have to invest to safeguard. अब घर के लिए महंगा ताला लोगे ना जब आप बाहर जाओगे. So there are models okay available. It depends upon what is your budget, what's the maturity level of the tech team okay building AI. So things are already available now. Ma'am, you had a question.
Yeah. So my question is for you, Chandraji. When we are talking about corporate risk assessment, where do you think in the current area, like the current era of AI hallucinations, the legal due diligence stands? Because earlier it was very much buried down, but right now it is total hype right now. Yeah.
I think we have already embraced technology in the legal due diligence. For example, when you are doing an M&A transaction, you create a data room, right? You ask your investee company or target company to upload their entire data in the data room. And there were, I mean, legacy software of Big 4 and Big 10 who used to scrape through the various elements in the data room and create the report. Now that has increased by 100 times, right? So, I mean, there is less level. So I am going back to the 80-20 part, right? The AI suite or agent that you have built to conduct the due diligence of the data room, if it is built with all those principles, lawyers are involved, those who have a computational thinking lawyers, right? So, and then the last 20% is given to the senior lawyers to have a human in the loop and a review. 99.99% there will not be hallucination. And I can guarantee you that the decision that will come out of that combination will be at least 10 times better than 2 or 3 human beings seeing all the data, your minutes file and all. They may still fail, but this type of AI ka process, 80-20 and all, will not fail.
Thanks. So thank you everybody for this session, and thank you this distinguished panel that that I had a pleasure of moderating, who are veterans in their own respective fields, and bringing all of them together to discuss about something which is an important topic purely from the standpoint of corporate risks, investigations, and forensics. It was very good, and I hope you guys enjoyed the session. One thing which I'll just like to say as a closing remark is, I think we all agree sitting in this room that it will always have to be a mix of two. It can never be one completely overshadowing the another. And at least in this space, compliance, corporate governance, investigations, forensic space, I think human intervention is something which will always, have a far more significant role to play, because ultimately we are dealing with people at the end of the day. Thank you, everybody.
Thank you so much, Mr. Vashne, and to all our panelists for another insightful session. And once again, to felicitate our speakers for this session, I'd like to invite on stage Mr. Anupam Ashish, Head of Marketing, Fortune India and Open Media. And this is just a token of our thanks and appreciation to all our panelists for joining us here. Can we begin by giving the memento to Ms. Aditi Mittal? Thank you for sharing with us your insights. For Mr. Ashish Chandra, please. Thank you, sir. For Mr. Sanjay Kaushik now. Thank you once again, sir, for taking our time this afternoon and joining us here for the panel discussion. Mr. Surat Mukherjee. Was a pleasure hosting you, sir. Thank you very much. And for Mr. Nikhil Vashne for once again wonderfully moderating the session with our panelists. I'll request all of you to please come forward for a group photo. Thank you once again, ladies and gentlemen, for that session. Now, that really wraps up the discussion around the AI matter of things as we've been discussing for the last two panel discussions, one that happened before lunch and the first one after lunch as well. Ladies and gentlemen, it's now our turn to move towards a highly specialized and evolving area of law, which is what we are going to be discussing in the third panel discussion of the day. Let me first tell you about the theme of this panel discussion that we have lined up for you. Arbitration in energy sector, emerging jurisprudence in the electricity regulatory industry. Now, like I said, this is a highly specialized and evolving area of law, and we have our esteemed panelists joining us for the discussion on this subject as well. I'm sure there will be a lot that you will take away from the next panel discussion. Just a quick word to our moderator as well. I'll be shortly introducing all of them to you, but since we are opening the floor for questions, and there are young members from the fraternity who are very keen on putting these questions to our experts on the panel. It'll be really helpful if you could take 10 minutes of the allotted 60-minute time for that question-answer session so that everyone can get a chance to speak directly to the panelists. In case you miss out on that, please do feel free to continue the networking off stage as well, and I think you can take your questions at that level as well. We'll just quickly wait for the name tags to be put up here, and then we will begin introducing our panelists to all the members of the audience. We need to move the chairs inside. There are going to be two back-to-back panel discussions as we line them up for you. All right, I think we are all set now to introduce our panelists to the audience. Just requires a bit of time for the cameraman to get settled with his frames. If they are happy, then we are happy. All right, so let's move on now. And first of all, joining us on this panel will be Mr. Manish Kharbanda, Group Legal Head and Advisor, Jindal Steel. And he brings with him extensive experience in infrastructure and regulatory law. Sir, can I please invite you on stage to join us here for the panel? Please extend a warm welcome to all our panelists as I take their names and they come up on stage to take their seats. Next, joining him on the panel would be Mr. Mridul Chakravarti, Senior Partner, Charter Law Chamber. He is recognized for his arbitration expertise and he is joining us on the panel next now. Also on this panel, we have the pleasure of inviting Mr. Suraj Das Guru, Senior General Manager, Green Course. He specializes in renewable energy legal frameworks. Sir, if you could please join us on the stage. Ladies and gentlemen, can I please hear some applause for all our panelists? I'm sure the discussions are something that you are taking away a lot from. So for these insightful sessions, let's begin on a positive note. Moderating this session would be Mr. Lakshay Bagdwal, Senior Partner and also an expert in dispute resolution and arbitration. Thank you so much, gentlemen, for joining us for this session. With that, I'm going to hand it over to Mr. Lakshay Bagdwal.
Thank you so much. Good evening, gentlemen. So I'll start with giving a brief background of what the issue is involved in today's discussion. So as we are aware that Electricity Act was enacted in 2003. One of the major reasons why it was enacted was one, to decentralize or de-license the private entities to participate in the electricity sector. And apart from that, there were various complexities involved in the sector, which required the parliament to pass a legislation and enact this. One of the factors basis which the act was promulgated was to create sector-specific quasi-judicial bodies in order to adjudicate and see the regulatory framework of the sector. Basis that, as you're aware, the Central Electricity Regulatory Commission and the State Electricity Regulatory Commission were constituted. They were given certain powers. One of the powers is the adjudicatory powers vis-a-vis disputes involved in the sector. Apart from that, from the very instance of the promulgation of the Act, the commissions, the regulatory commissions were also given the power. Either they could adjudicate the disputes or they could refer the matters to arbitration. However, from 2003, we have seen that over the years, be it the private generating companies or the distribution licensees, they have not been so keen on going for arbitrations, or even the regulatory commissions for that matter over the years have not been keen on referring the matters to arbitration. So majorly one of the reasons why they did not do so was with respect to the non-clarity of the issue as to what is arbitrable and what is not arbitrable. However, recently, as we are aware, there has been a recent set of judgments passed by the Honorable Appellate Tribunal for Electricity as well as by the High Court of Delhi, clarifying this aspect as to what is an arbitrable issue and what is non-arbitrable issue and what is the jurisdiction of the regulatory commissions vis-a-vis the reference to arbitration. So in that light, I would ask Mr. Chakravarti to first shed some light on it in terms of the recent judicial developments.
Thank you, Laksh. Evening, everybody. So yes, you have basically put the cart before the bull, but the thing is, there was not a lot of impetus on going for arbitrations when the act came in. And if you remember the Honorable Supreme Court Justice Kardju's judgment in GOVNL's case, where Justice Kardju had emancipated the Mimamsa principles, etc., but ultimately held that the power to refer exclusively lies in the domain of the regulatory commissions in terms of 86 and in terms of 79, and thereafter that section 11 or any courts going for section 11 parallelly to the act was not permissible. So we come from those days where there was not a lot of impetus or not a lot of interest in going for resolution by way of arbitration. From there, yes, we see the DVC judgment now, where we have got some sort of clarity on what is an arbitrable dispute and what is not an arbitrable dispute. I will still say there's a lot of gray area, because for me, any dispute which comes before the commissions, whether central or state commissions, will have an element which will affect the tariff under recovery or no recovery. But taking from what it is, DVC gives us a basic idea, where disputes which pertain to, let's say, termination of a PPA, termination of a contract, there they have held or so that if it does not directly or indirectly affect tariff, it should go before an arbitral tribunal. Then thereafter, I will also refer to the Renew judgment of the Delhi High Court. But again, Renew judgment, if you read it in some clarity, Renew says that whether if the commissions feel that they are overburdened, or if the commissions as regulators, which I feel is a little dicey to follow, if the commissions feel that there is some subject before them which requires sector-specific expertise, then they may refer it to arbitration. for me, that reasoning may not be completely correct, because we see why we go for the regulators. And then thereafter, yes, and of course on the issue, now that I see that once you go for an arbitration, I don't know how far the clients would be willing to take that route again, because first is the issue of overlap between tariff and non-tariff. And secondly, once you get an award in your favor, the real battle starts thereafter, where you have to go for execution. You have to face 34, you have to face 37, you have to face all sorts of, delays. So I will keep my opening remarks to that.
Thank you so much. I'll come to Mr. Kharbanda. Mr. Kharbanda, as you're aware, there was a recent judgment of Aptel, Justice Ranganathan, on the juvenile versus startup hour judgment, where they have discussed the DVC judgment and the Delhi High Court renew judgment, and have come to a clarity in terms of what is the framework. Can you just enlighten us on that, and what are your actually views as to whether this approach or whether this judgment is maybe correct or not? Though we are no one to, say anything in terms of it's a court's judgment, but what are your views, personally, your views on that?
Thanks, Laksh. I think that's a difficult one to comment on judgments, but so, of course, it's my personal views completely, whatever I say here. So I'll start with a little differently for you guys to look at how arbitration has developed in the electricity sector. Now, we all understand that the Electricity Act, this has been completely regulated. And in a regulated act, how do you come on arbitration, and where do you get arbitration in the act? So we start with and you can correct me if the sections go wrong here and there. So we start with section 79, where the Commission Central CERC has certain powers. And if you guys are familiar with the regulatory powers, so they are powers from, I think, 79, 1A to D, and then E is for licensing. And F is a very pertinent section, the 79, 1F of the Electricity Act, a very pertinent section, which says, and which is something which I'm going to talk about, which says that the Commission has powers, the Central Commission has powers to decide the disputes in A to D, 79 A to D, which are more to do with tariffs, regulations, grid codes. That is what it says. And it says, and refer to arbitration. Now the word and, so it means that certain powers have been given by the Act, and yet the word and is added. And why this was important is for you to understand is that this and word in the GUNL judgment is something where I will have a different opinion, right? Other than that, I'll explain the judgment to you so that you get the concept right. Second is that arbitration, most of you may be doing arbitrations or will be doing arbitrations, was thought to be an easier and expedited mechanism for dispute resolution. And there is a concept called arbitrability. And you have to think arbitrability in the context of Electricity Act. So arbitrability is something which is linked to public interest, public policy, fundamental. That is something which is not arbitrable amongst others, basically where there is a public involvement or people are involved into that. So basically earlier in the Electricity Act, you keep this in mind because this will be important to understand the nuances of the judgment. So earlier it started with Gujarat Urja, where it was said that, listen, everything in the Electricity Act is a special act. Arbitration Act has no relevance. Even if the Power Purchase Agreement, which is a PPA, says that it's arbitrable, it said, no, it's not. Everything has to be decided. And that went on for a few years. And then, of course, came a series of judgments as were referred here. I think DVC was the most compelling judgment, where it was, I think, was concerned with the Madhya Pradesh government cancelling PPAs with DVC, Damodar Valley Corporation, I guess. And then it was a cancelled PPA, and it went for dispute resolution to CERC, and they said, no, I think this is something we should be going to arbitration, because this is a contractual dispute. Now I'll pause all of you here. Now look at this. There is something in the PPA which said that the disputes will be resolved by arbitration. Now arbitration, we understand, is a different agreement, right? It is severable from the main contract, but it still draws its power from the main contract. So that's the difference we have to see. Now, in this context, it was said that fair enough, it has to go to arbitration, and it was being opposed, but anyway, it went to arbitration, upheld by the Supreme Court, where two principles emerged. If something is linked to the tariff determination, grid code, sustainability, directly or indirectly, please mark the word, directly or indirectly, in that case, it's a regulator who decides, it is non-arbitrable. But anything which is a contractual dispute or liquidated damages or maybe some other thing which comes out of a contractual dispute can go to arbitration. And that is where it said that the word and in 79(1)(f, which I spoke to you about, came into picture. Because all the others from A to D are something which have public interest because it relates to grid security or it relates to tariff determination of government companies or tariff determination of non-government companies, transmission licenses and so on. So basically these were something which are always impacting the public, consumers, because whatever you do will go into the tariff of either the generator or the distributor and ultimately the consumer pays. So the courts are very cognizant of the fact what can go to arbitration and what cannot go to arbitration. That is the jurisprudence behind it. Now let's come to GUNL. I'm sorry, you can stop me if I take too much time, okay? So then let's come to GUNL. Now this is something which APTEL has done as of now, right? And APTEL, again a judgment where I'll give you a little bit of a basics. And if I go wrong, Lexa and others can correct me because it's very difficult to remember everything. But I think this was with Tata Power, TDPL, and they had to supply power to 3 companies. One of them was GUNL. And they had a contract demand and they said we will not supply for various reasons. Now GUNL goes to the CERC and the CERC says it is not in my jurisdiction, let's go to arbitration. Now there the APTEL, Justice Ranganathan, has given a very detailed order on 4 counts, not on 1 or 2 counts. And I think the 4 counts become very important. One, it says that if the CERC does not have jurisdiction on this case, they have no jurisdiction to send it to arbitration also. So they read the 79(1)(a) to D in congruence with 71(1)(f), right? They said they're absolutely fair enough. Second, they said that it is completely harmonious with DVC because this was a live PPA and that was a PPA which has actually extinguished. If it's a live PPA, then still there are certain charges being imposed on TDPL which will ultimately go to the consumer, hence not arbitrable. Point number 3, they said that, and I think they quoted a judgment of Sukanya and Vijay Drunia, where they said that if there is a dispute, the entire dispute has to go to arbitration. You cannot have one part of the dispute going to arbitration, which is what the CERC said, and not the other part, one part being decided by the commission because it involved a grid code, which was, I think, the Western grid code or something, which is WDRDL, something like this. So basically it said that, and that's why it said that Section 8 is not attracted. It also went ahead and said that TDPL waived off its right, and that's very important for arbitration professionals also, because they say when you have to file a Section 8 of the Arbitration Act, you should file it ASAP. If you delay it, then it will be taken as a waiver of your rights. So they have also commented on the waiver of the rights, and up to this point, I completely agree with them. The last point in the judgment, which I think this should be appealed, maybe just a very recent judgment, so we are still in the limitation. I think it's February 2026. Yeah. So in this, I think they have said that if they said the word and in 79(1)(f) should be or. Now that is something which I don't agree. Because anything in between 79(1)(a) to D deals with issues which impact the public, right? And if you say or, that is something which is distinguishable. I understand that the CERC has powers to refer disputes to arbitration. I will go with the DVC argument, that if it is a non-public interest, hence arbitrable, CERC has powers to send it to arbitration. It will go via CERC, and if the CERC says I don't have jurisdiction, then of course they also don't have jurisdiction on F also. But here and or is getting a little, I think, ambiguous to me, because the CERC does not have powers to send A and D to arbitration. It cannot, it's non-arbitrable. To say in 79(1)(f that either you decide the dispute yourselves or you send it to arbitration is ambiguous. You cannot say or. And was fine. I'm okay with the present extant law which says and referring to arbitration. I'm fine with that argument. But on the or, I'm absolutely not there because I think that is where the learned appeal has gone wrong. Of course, the other part of the judgment is mainly sustained. I'm sure if it goes to the Supreme Court, this point may be clarified. Otherwise, it's a very validly written judgment.
Thank you so much, sir. That was indeed a very insightful and a detailed examination of the judgment. Now I'll come to Mr. Suraj Dasguru, sir. So, looking at these developments and considering that you have vast expertise in the commercial side of things in various companies across the electricity sector, do you think this clarity or maybe this the arbitration in the sector is a welcoming aspect, or is it something which, you know, the private companies or the government public PSU distribution licensees would want to avoid it?
Thank you, Lexa. As my colleagues have already said, whatever the judgment, the recent judgment passed by the APTEL on 18th of February, it is not final, it is subject to challenge. But in any case, in this judgment also there are many things which has been missed that has to be crystallized because there is no exhaustive list given that what would be the tariff and what would be the non-tariff matter. And the important aspect that Mr. Kharbanda was talking, that APTEL has sent it back to the CRC to decide whether you can adjudicate or not, whether it is in your jurisdiction or not. Obviously, if it is not in your jurisdiction, you cannot refer to the arbitration. So the question would arise that what would happen in such a scenario? If the CRC do not have a jurisdiction and at the same time CRC cannot refer it to arbitration, then what will happen to those cases? Whether it will go to the normal civil court, then what would be the purpose of the Electricity Act, which has been enacted especially to cater to the electricity sector? So now, as far as I've said, because it is still growing, reforming, lots of things needs to be changed. Yes, we do have arbitration clause in all the PPAs, say about in 2010-12 onwards, but none of the parties have, say about approximately 10 years, who choose to go for arbitration. So now the things have been changing, now parties are interested in getting it resolved. It's my personal view that the reason being is that the delay that is happening in resolving one issue with the help of under the Electricity Act, every case that is taking not less than 7 years will come to the final conclusion, all big cases I'm talking about. So now, generator, I've started thinking that since there is a provision to sort for the alternate remedy, and people are seeing it as a viable, cost-effective, alternate process to resolve their disputes. So now they have started moving to go for an arbitration. Yes, Justice Ranganathan has very categorically said and crystallized that whatever the issue that is pending before any of the forum, any of the SCRC or CERC, that cannot go into the arbitration. Because as Mr. Kharbanda has rightly said, that Section 8 application has to be filed at the very first instance before filing a defense. So none of the parties have filed Section 8, so those proceedings will not go definitely into the arbitration. But certainly, from now onwards, now people have, this judgment has opened their eyes. People have now, will take a call. The private parties, definitely they'll discuss with their respective management and they'll take a call whether they should go for arbitration or proceed with under the regime of the Electricity Act. This is my personal opinion, that as far as the DISCOMs are concerned, they are not very interested in the arbitration. As we have seen in this matter also, they have fought it with a tooth and nail not to go for an arbitration, and they have their merit in their matter as well. So now it's between private parties and the DISCOMs, state utilities, because private parties, private generators wants to go for an arbitration. At the same time, discoms do not want to go for an arbitration. Reasons are very clear, as Mr. Chakravarti has rightly said. For the arbitration, there is a problem because once you get an award, be it either side, it is very difficult to challenge because the ground of challenge is very limited under 34 and 37 of the Arbitration Act. But yes, after the 21 amendment in the Arbitration Act, the timeline has been reduced for passing an award. That is 12 months, so it looks like lucrative for the generator rather than pursuing their matter for unlimited time before first in the state commission, then the appellate authority, then again the new trend of the remand back the matter, and then again litigation, and up to the Supreme Court. So it takes approximately 10 years, and the private generators are just stuck for their money, which they feel that it is a rightful money, that's why they are fighting. For 10 years, they have supplied their power and still they are waiting for the money. So that is not, so that's why these private generators are looking for an arbitration. But however, I do not know that as far as the as on date power purchase agreement is concerned, yes, there is an arbitration clause. It is my personal opinion that tomorrow it may happen if the discoms are not very keen to go for an arbitration, then definitely they are going to remove that clause from the PPA. Because otherwise they do not have any right to object not to go for an arbitration unless until it is a tariff dispute. And this tariff and non-tariff dispute needs to be evolved because there is no exhaustive list as on date that has been passed by any of the court. Be it DVC or be it Mr. Ranganathan judgment, it is not an exhaustive list, it is just an indicative list. And to an extent, DISCOM will definitely fight that everything is going to be impacted, the tariff. Even if the termination of contract, once the PPA is in force, not like in the case of DVC where is the issue of the foreclosure and the termination. So time will tell that how it is going to involve, but yes, there is definitely two parties, two sides of the coin. One is the private generator and the second is the state utilities. One is interested in moving towards the arbitration. It is a welcoming order passed by the Justice Ranganathan. So let's see how it goes.
Thank you. So thank you so much, sir. So Mr. Chakravarti, I have one question for you. See, after this clarity in terms of what is arbitrable, what is non-arbitrable, even tariff disputes, as Mr. Karbanda pointed out, that section 79(1)(a) to D, wherever the commission has the jurisdiction, APTEL now holds that commission can either adjudicate the dispute or refer these matters, that is A to D, which is tariff, to arbitrations. Now my question to you is that wouldn't that over the years, since there is a discretionary power available with the commission, could this possibly lead to a situation where all private disputes, the commission resorts to sending them to arbitration and only keeps the sectoral or maybe the sectoral disputes, the sectoral issues with them for adjudication? How does this basically solve? The act was encapsulated because they wanted to create specific bodies to deal with these issues. Now after this, giving an autonomy to the commission, can this also lead to a situation where all the matters are referred to arbitrations, private disputes, but only regulated disputes are kept, and how will it basically favor the sector?
That's a good question actually. It's like you've read my mind. What I feel here is that, first of all, if we look at the PTC judgment of the Supreme Court, it says that the act is a code in itself, a complete code. So whatever has to be done under the aegis of the act, number one. Number two, yes, you're right. Ultimately, we are regulating the regulators over here. We are asking or narrowing down their jurisdiction, saying, see, A to D is what befalls you before you. You can't, trespass that. So, in my opinion, if you consider this, if we take these judgments in their, spirit, then one way forward is, and I'll come to the impact later on, one way forward is then, you streamline filings, you streamline disputes, and you don't come before the commission to waste time. You say that this is a dispute which is arbitrable. So because I can't go under Section 8, I come before you, you refer to me, or you refer me before a panel of arbitrators, a panel of experts. Let's not waste time over here. That's one way to look at it. But the other way to look at it is, yes, that we are restricting their roles as regulators. We are constricting their roles where they have to evolve the sector where it is now. The impact, so far as the impact is concerned, I feel, and I agree with Manish sir over here, that the dichotomy between and or. So one place where I say that A to D, if it touches upon the cornerstone of public policy, public function, or what really impacts the sector, and on the same side I say that you can only refer to disputes, such disputes to arbitration which befall A to D. So there is a dichotomy which has to be resolved by the higher courts, and the impact is ultimately, in my opinion, in my personal opinion, we are restricting the roles of the regulators, which may not be in the best of health for the sector, because disputes are evolving, and disputes are, we see all uncanny disputes coming before the commissions. So that is my opinion. Yes, there's a lot of clarity still required, because I don't think so there can be an absolute black and white demarcation between what will be arbitrable or what will not be arbitrable. It's a very technical sector that we are talking about. These are very technical disputes we are talking about.
Yes, thank you so much. So, Mr. Kharbanda, I would have the same question for you. Yes, so you were saying something.
I want to add that if the commission started discretionary power to refer the matter, then the situation may arise, that for the similar matter it is referring for the arbitration, but for other state commission are not referring for the arbitration. Then it would be a complete anarchy. One generator or one set of parties are getting their matter resolved by way of arbitration, and the second party is getting resolved under the regime of the Electricity Act. So it would create certain uncertainty as well. That's why Mr. Chakravarti has rightly said, it has to be decided, a clear-cut black and white, that what matter can be referred to the arbitration as a mandate. Because unless until it is there, it would be very difficult, and it is very difficult to predict for anybody.
And if you see the process, then it's ultimately leading to more expediency so far as time consumption is concerned, because I go for the commission, I spend a year and a half, 2 years, then I get to know this is an arbitrable dispute, please go before the arbitrator. So according to me, the generators, the entities who are yet to receive money or whose commercials are held up, it doesn't really help the sector, it doesn't really help these entities. So either we have a system where we know what is arbitrable, what is non-arbitrable, where disputes are such that, yes, they don't impact my tariff at all. Disputes are such that they don't impact the commercials of the discoms. If we can have such a system, well and good. Otherwise, law has to evolve more from here. It can't be taken as it is right now.
Thank you, sir. Mr. Kharbanda, your views on this?
Well, somewhat in sync, but majorly I may have a little different view. Let's look at it from a perspective that of the current law, we are only talking about thermal power plants. Whatever the jurisprudence of on this area has been also on thermal power plants. Now, let's look at a world scenario now. In world scenario, of the 10 arbitrations, 9 are electricity arbitrations, 9. And that statistics, they are arbitrations which are going in ICSI, it's international arbitrations going on under the BITs and the MITs. There are so many arbitrations happening, and now in India, because I think we are now looking at renewables coming with a great focus, with the government's target by 2030 to get at least 70% of the electricity from renewables. Now how far, and that's going at a very, very big pace. Even my company is almost crossed 3,000 megawatts on renewables, and it will start flowing in with this year end. You will see a lot of things coming up. Now, what with this you will see is that there will be a complete change of scenario. That's one. Second is that let's look at why arbitrate? That's a basic question. Why arbitrate? Now, arbitration came in because people thought that the disputes can be resolved faster. That is somewhat debatable. But the other part was that you will get experts which you can choose between the parties whom you will believe that whatever they say is right. Now that kind of expertise, I understand, at the commission level also is somewhere, commissions are under the state government, we have all kind of people there, some of course them are extremely good, some may be bureaucrats, some may be, so basically, and when it goes to the Supreme Court level, it gets very different, right? Because they are not technical experts, they are legal experts. There's a difference between understanding a huge technicality in an electricity matter than looking at legal, because first you understand the facts and then you apply the law. 70% of the case is facts. That is why arbitration. Now imagine things like renewables, where there are disputes going to come up in a big way on connectivity, because I think there was this GNRE guidelines which said that if you are connected through a transmission line to a grid and you don't commission by such and such date which expires now with the extension in June, I think Suraj will know it better. In that case, the transmission connectivity lapses, right? That is one. Then you are this carbon credit scheme of the government. Then you have things coming like on the ESG. Somebody is going to challenge you on the ESG also. Now all these things are very purely arbitrable. So basically, as Bridul is saying that the arbitration is going to evolve, my view is that the golden line between that is that you look at whether it is direct or indirect. If it involves the public in some way, it will never go to arbitration, because arbitral tribunals on the same point of law can have different decisions. And mind you, under the Arbitration Act, under 34 or 37, you cannot go into facts, right? You cannot. So basically, point number 2, the arbitration decisions are never reported. Now that is something which, that is the confidentiality and secrecy of arbitration. So that point the courts will always be cognizant of, and the jurisprudence will stay there. Where there are contractual issues, there are issues which actually do not impact the general public, those will be made arbitrable and should be made arbitrable. And others, I think, which directly or indirectly impinge on any factor of public interest or public policy will never be arbitrable.
Thank you so much, sir. So I'll just come to the last question for all the panelists here. See, considering as you already pointed out, sir, that there has been a tremendous boom in the renewable sector in this country. We have foreign investment, the scheme of the governments as such, that there has been an invitation of a lot of foreign investments in the country. Keeping them in mind, and the fact that how they in their home countries litigate, arbitration has always been a major factor and a resolutionary dispute for them, which gives them a speedy disposal of the matter. Considering that, don't you think that the emerging arbitrational trend in the sector is beneficial? Sir, I'll ask you, sir, first.
So for this, we need to understand your question. First, we need to see that why the Arbitration Act come into the picture. The genesis and germane of the Arbitration Act is, just as you have rightly said, for the speedy disposal of the matter, which is missing in the electricity sector, which I must say. And now the Arbitration Act is also evolving, because to 2021 amendment and thereafter the grounds of 34, wherein the public policies definition is also changed, because the Supreme Court is also defining by its own way in the SLPs and all. So now, earlier it was too much restricted as far as 34 is concerned, but at present it is little bit relaxed. Little bit. I'm not saying it is a completely relaxed. It is not in the same way that you can challenge your commission order in the APTEL, but definitely yes. But the purpose of this 34 and 37 is that the litigation has to come to an end. It is, I can understand it is good for the lawyers if the litigation ends, but for the generator side, the person who have incurred a huge capital, they obviously want to return out of it. And they obviously they do not want to litigate unnecessarily for the time which is never ending. So that was the genesis of the arbitration, speedy, cost effective, and it's a viable alternative for the normal litigation.
Thank you, sir. Mr. Chakravarti, your views?
See, according to me, whatever changes happen, they happen for a reason. It always, culminate into something positive. But having said that, let's not view the scope of arbitration, let's say what we see before the CAC or bodies like that, to what we see in our country. I'm not undermining the arbitrations we have here. But again, the real challenge begins over here once you have an award in your favor. And that's a real challenge, because as lawyers, we see, how the proceedings just go on and the awards never get executed. So in a dispute, let's say in a dispute like a connectivity dispute which goes before an arbitral tribunal, where you have to, when you come before the commission, you may get an interim award 2 days after filing. But to get an interim award, and I'm not talking about Section 9 here, I'm just purely on a question of law. So you have to, get arbitrators appointed. We have to be in unison. All of us have to, agree upon names, etc. All those technicalities are there. And one more point I feel which we should consider is we should have robust arbitration agreements, robust arbitration clauses, which we don't see in all these PPAs with the discoms. These are very, not even tailor-made. These are very
not drafted clearly.
These are very
recent. I've seen recent drafts, the agreements. The clarity in terms of arbitration is somewhere missing, and these are the drafts which come from the under the guidelines. In terms of the standard bidding guidelines.
I was going through a PPA where one of the clauses said nothing to be arbitrated, and the next clause said yes, you will go and arbitrate. So there was a dichotomy there. So yeah, we need very robust kind of arbitral agreements between the parties, where parties have to agree to a mechanism, the parties have to agree to a timeline. And most importantly, we should ask ourselves whether the sector is, ready to move on from the mindset of coming before the commission and going before the arbitrators. Because that, according to me, not even as lawyers, but even on the point of view from my clients, it's something which will require a major shift. And it will not be that easy. So yes, it's a positive development. There's a lot of things to be done. I think the lawyers have a lot of scope, not from the commercial point of view, but from the point of view of, developing the jurisprudence. But yeah, a long way to go from here.
Thank you. So,
see, I think in terms of the arbitration itself, I think both the points said by Suraj and Mridul are well noted. But arbitration itself is evolving now, right? So basically, you now have a provision of emergency arbitrations, which is ICC, LCIA, wherever you say emergency arbitrations are coming in, which can give you relief of Section 9 maybe instead of going to Section 17 later. You can actually expeditiously do that. So my view is that both the acts have to parallelly evolve, right? To your point on ambiguity and ambiguous arbitration agreements, yes, people are still learning about it, that arbitration agreements, though they get their power from the main contract, but they are separate agreements. So basically, arbitration agreements drafting itself has to undergo a big thrust and big shift, because that's also happening in a big way. In electricity, coming back to what we have been discussing, I believe that a lot of disputes can be resolved by something which has been started in the DIAC, which is the AI-led arbitrations, where you put in the facts right and you get a response, you don't need anyone. And of course, it has to be human in the loop. Obviously, somebody has to check that. That's what human in the loop is. But these things will evolve in India also, because we are a populous country now, and we are now stepping into nuclear also. So electricity segment is bound to grow in leaps and bounds. And if we still keep on relying, and no offense to anybody, I think the Act has performed well, the commissions have performed well, but the idea is that we need to see that if certain disputes can be resolved just because it's the human in the loop, a lot of things, and you see a lot of investor confidence growing into that. Second, arbitration also helps the investors who are coming from outside and investing in India to bring in their own people as one nominee if there's a 3% arbitration clause, if they can keep in. They have confidence in resolution. Now, whether it's a court resolution process, which is judiciary, or the arbitration, both of them take their times, right? So basically, we can't say that, yeah, of course, arbitration, the way it started off and the way it is today, is nothing which, we should be proud of it, but I think there are ways around it, and I think the courts have been actually cognizant, at least the Supreme Court. It's very, very difficult to get to the Supreme Court and get an order against, unless and until it's completely bizarre arbitration. And I think the last point is that in India, the arbitration has to increase, and I would also comment on the integrity of arbitrations, right? That's something which we don't touch upon, because the integrity of arbitration is also a huge, huge issue now, because you sometimes see certain orders, and sometimes when we argue in the Supreme Courts or the High Courts, I think lesser said would be better. So I think that confidence has to go. Certain Electricity Act and the Arbitration Act both may require a little bit of amendments to align to arbitration, but I can very safely say that arbitration is here to stay. Electricity arbitration in India will grow as it is growing worldwide. There is no other way about it. And I think we should get geared for it.
Thank you so much, sir. So I think indeed it was an insightful discussion, and I think we can somewhere say that, one, this still requires clarity. And second, I think there is still a difference of opinion in terms of whether we want arbitration in this electricity sector or not. I think that is it. Thank you so much. Any questions? Anyone?
Am I audible? My question would be, are the arbitral tribunals equipped to meaningfully adjudicate disputes, even contractual or commercial, which have significant impact on the consumers? Are they equipped in that sense? Because state regulators or central regulator keep in mind a lot of factors which affect the consumer, and then only the decisions are taken. But there are contractual disputes which are worded contractually but have significant far-reaching tariff implications and affecting the consumers.
So I think that's a pretty straightaway question that as I said, that the arbitral tribunal should not be given those powers at all, because anything which impacts the public at large, I think the courts will be very cognizant of the fact that it's a matter of public policy, right? It impacts the public at large. And as I said when we were earlier speaking, that arbitration awards are confidential awards, they are not published. Two arbitrators on the same question of law and facts can decide extremely differently, right? So basically, if it is something which will impact directly, and that's what the DVC also says and GUN also says, they catch on the word directly or indirectly. So even if there is a contractual provision in the PPA and it indirectly impacts the public, I think the courts would be cognizant of the fact. I don't see personally the jurisprudence evolving on giving the arbitrators those rights, although in certain areas internationally, certain rights were given which were erstwhile the domain of the courts only, which is if you know the US law, the Competition Act, right? Which was earlier the domain only, they said that only the courts can decide, the arbitrators were left to decide in certain circumstances which were very fact sensitive to that case. So even if I draw that conclusion, if there is something which is very fact specific to the two parties which are disputing, then maybe yes, but if it goes to the public policy, no.
Yeah, and just to add to that, what Manish sir is saying, so taking the question holistically, yes, a lot depends on the arbitrators, the people you get to decide a dispute, which emanates from a very technical field like the electricity sector. So that's one thing, or one subject which has to be touched upon not only graciously but also with an open mind, where integrity, expertise, etc., everything should be, because if we are doing traditional arbitrations again, where we, go before judges, we see how it is. And not to disrespect anybody, but being lawyers, we are very aware of it. So yes, what is arbitrable needs clarity, and on top of that, how it is done, it's more important.
And to add further, see, arbitration is always a private mode of resolving the dispute between the parties, and that is the specific reason why in the Electricity Act it was specifically carved out between the tariff and non-tariff matter. Because tariff matter cannot go to the arbitration, it cannot be referred to the arbitration, because ultimately impact of tariff is being suffered by the consumer, that is public at large. And public issue or dispute cannot be resolved through arbitration. As far as the capability is concerned, we do believe that they are capable, otherwise there is no point of filing their case and litigating before the commission. We cannot doubt, because the moment we start doubting, then the complete anarchy will be there, the complete anarchy. We cannot doubt on the commission or the judges or in the court, because still we believe and we remain in the era, चाहे कुछ भी हो जाए, लड़ाई जब होता है तो हम कहते हैं कि तुम्हें कोर्ट में देख लेंगे. So we do believe the existence and the sanctity of the court.
I'll just add one more thing. I think the complexities for arbitration, in the arbitration sector, I don't think it will matter much, because what I feel is that if there is a reference to arbitration, obviously there will be nominations of the arbitrators. The arbitrator, the nominations would most likely would be someone from the sector, maybe the members of the appellate tribunal or the central commission who have the expertise. So maybe I think there might not be any problem in terms of arbitrations in the sector. So thank you so much. Any more questions, please? Any more questions? Oh, okay. One.
So I have a very basic question. Since Sir talked about technical members being there in arbitration and that holding more value to the whole process, I just want to understand the difference between what you feel is a technical member sitting in a panel in CRC or in the tribunal and versus technical members in arbitration. From your perspective, a general difference. How it impacts the overall
See, it doesn't impact. The idea is that technical member is a technical member. If somebody understands the nuances of electricity, obviously how it flows, the transmission, the grids, and understand the entire things, it doesn't matter, right? Arbitration, the only positive is that it gets very focused. So suppose you go to CERC or you go to APTEL, there are numerous cases after cases, right? So basically, factually, you take a lot of time first to reach a certain stage. Second is that if you give maybe a report which is a technical report or an expert report to a CERC or to a APTEL, it is actually, they may depend on individuals, but the perception is that we know it, right? But if you are in an arbitration, a lot of times, if you all understand, there are a lot of technical and expert opinions are also given. So if suppose you are a respondent or an appellant, you will bring in expert opinions which have a lot of value to these people. People are similar. It's not that there's any difference in the technical capability of members. But when you come to say something like a APTEL where you appeal a CERC order, there you will have a judge who's a civil judge, who's a high court judge or retired judge who understands the legal aspects better. Then possibly, I'm not saying that it happens, this is again I'm just qualifying, then possibly a legal member in a commission. Possibly, I'm not saying it's always the case, because the commissions, as per I think section 86, are controlled by the states. Appointments are, so basically where the appointments are in a very different fashion, sometimes things may take a different turn. Arbitration, you have a choice. You choose what you want. That's the only distinction.
So with this, we conclude this panel discussion. Thank you so much.
Thank you once again to all our panelists and our moderator for this wonderfully conducted session. Once again, I'd like to invite on stage Mr. Anupam Ashish, Head of Marketing, Fortune India and Open Media, to please felicitate our speakers and our moderator for this session. Can we please first begin with Mr. Manish Kharbanda? Just a token of our appreciation, sir, for taking our time today and joining us for this panel discussion. Mr. Mridul Chakravarti, thank you once again for joining us and sharing your insights. Mr. Suraj Dasguru, thank you, sir, for sharing your expertise with us on the panel. And Mr. Lakshya Bagwal for conducting the session and, of course, also sharing your expertise. Once again, thank you, gentlemen. Can we please have you all come to the front side of the stage for a quick group photograph, and a big round of applause for all our panelists for this deeply insightful session, a specialized area of expertise that we all heard from. Thank you very much once again. Okay, with that, ladies and gentlemen, we are going to move towards our final panel discussion of the day. And as we transition to the final panel discussion, let me tell you that in the next session, what we are going to do is that we are going to highlight the growing prominence of arbitration as a preferred mechanism for resolving complex commercial disputes in a globalized economy. Can I request all of you to kindly avoid commotion in the hall as much as possible? There is no break. We are straight away moving towards the next panel discussion. And after that, there will be a break. So I'm just going to request all of you to please be seated. In the meantime, in case you are engaging with conversations online, please do not forget to use the hashtag which is displayed there, as well as on the podium in front of me, hashtag Lexa 2025. If you post your pictures, your opinions, anything, any insights from today, please use the hashtag and then engage with the conversations online as well. So like I said, once again, just to reiterate, the topic that we are going to discuss in the final panel discussion of the day is dispute resolution in a changing world, the growing role of arbitration in commercial conflicts. Once again, a very interesting topic that our panel of experts is going to discuss in front of you. We have an esteemed panel lined up to discuss this very important and specific topic. I will be introducing all of them to you one by one, and as I take the names, I'm going to request our panelists to join us on the stage. For your reference, your name tags are placed next to your seats, so please come and join us. So let me now begin with the introduction of our speakers for all of you. Are we happy with the stage setting? Okay. So our first speaker for this session is Dr. Mukul Shastri, General Counsel, Cube Highways. He comes here with deep expertise in infrastructure disputes. Can we please extend a warm welcome to him? Welcome, sir. Thank you. Joining him would be Mr. Sachin Mishra, General Counsel and Company Secretary, Tata Consulting Engineers. He's a seasoned corporate legal leader. Welcome, sir. Thank you for joining us. And Mr. Samit Gambhir, Senior Vice President and Group Head Legal UFlex Limited. He comes with extensive arbitration experience as well, sir. Thank you very much for joining us this afternoon for the panel discussion. This session would be moderated by Mr. Rajdat Shekhar Singh, Partner, SNA Law Offices, specializing in dispute resolution. Thank you very much, sir, for joining us. And I will be handing over the stage to you. Just a quick word, Mr. Shekhar, if I can tell you, last 10 minutes perhaps we can keep for the audience to put their questions for the members of the panel. With that, I'll hand it over to you. Thank you.
Thank you. So very interesting topic about growing role of arbitration in commercial conflicts. So just before starting, I just want to give little bit highlight about the litigation or the matter civil suits pending before the court and why there is a requirement of to discuss or about the arbitration in India. So as per National Judicial Data Grid, presently civil cases pending in district courts of India are 1.11 crore. And when it comes to civil courts pending at the High Court level, 44.69 lakhs. So it itself shows that yes, there is requirement of any alternative dispute resolution mechanism. Undoubtedly, the role of arbitration in commercial conflict is growing. Therefore, there is a need to ascertain areas which can enhance dispute resolution through arbitration. And arbitration need should be started from the initial stage, not at the time of when the disputes has arisen. Even when you are forming or when you are dealing with commercial dealing are at the initial stage. So, Mr. Gambhir, as you are Senior Vice President and legal head, so would you like to share your views regarding the practical aspect of arbitration as per in-house perspective? So we can
good afternoon everyone and thank you very much. I think arbitration जो हमने सोचा था अभी उस तरीके से नहीं चल रहा है, but I think we are moving towards that direction very quickly. India has been always kind of a ad hoc arbitration, you know, we have always been preferring that kind of a thing, but keeping in view the multi-jurisdictional arbitration and also the big stake disputes and all, we are, you know, moving towards the institutional arbitration. That's a good thing, I think. But you know, in my view, actually, the disputes or the outcome starts the time when you're drafting the clause for arbitration, and that's very important role GC has to really see. You know, while drafting the arbitration clause, you have to keep in mind various things. For example, whether you want to do it ad hoc or institutional, it depends on the size of disputes, kind of disputes. It also, you know, the venue, the seat, other things. So it's not, we can't take it as a boilerplate clause according to me. You know, there was a time when we think a arbitration clause be boilerplate mein nikal do. No, but this is something which we have to review it very critically nowadays because a lot of stake is, you know, very high stakes are, high disputes or high amount is at stake. So I think instead of making it, you know, this is an alternate dispute resolution as we say, instead of making it alternate dispute resolution, हम उसको alternate courtroom ना बना दें. This is what the objective is. So basically, India के अंदर जैसे हम देख रहे हैं, arbitration also becomes very lengthy nowadays, very costly nowadays. So objective was not that. Objective was to quickly resolve the dispute so that the court time is not wasted or, you know, you are actually spending less amount of money. But I think, you know, slowly what we see is kind of a particularly arbitrary appointment के बाद, procedural things, adjournments, timings, etc. Everything सब होने के बाद कुछ ऐसा लगता है कि हम इसको alternate courtroom तो नहीं बना रहे हैं. So I think we have to be very careful in that. And the other thing what we have realized in that, you know, we really have to see arbitration is not a legal process, it's a business decision actually. So एक time पे ये ज़रूर देखना है कि whether settling it or negotiating it is better than the arbitration or not. Though we have critically examined the arbitration clause, but still at the time of arbitration, initiating arbitration, we really have to really see the outcome kya hai, because outcome is very important. Winning the case is not important, your outcome winning is very important according to me. So आपको हमें ये सब चीज़ें बड़े critically और बहुत ही ध्यान से देखना है. And in many cases I have seen कि आप एक escalation clause और बना दो जो internally negotiation से कुछ decide हो सकता है तो बहुत ही अच्छी बात है. Otherwise, you know, if you have to do it, we have to do it.
So you want to chip in, Mukul, if you have any input on that?
No, this is rightly summarized by Mr. Gambhir, and what he said is very, very, very true. So there's a purpose for arbitration, that why we want to have arbitration and why not normal courts. Because ultimately what we think is that specialized cases can be held by a specialist arbitrator, a specialist dispute resolver, and therefore this party autonomy and the entire concept has come. But fortunately, unfortunately, in India, in the past 20, 30 years of experience, we have made arbitration very similar to a court litigation. We have judges as arbitrators, we have lawyers with the mentality of fighting it as if it's a court case. We follow the entire CPC and evidence as if it is a pure courtroom battle, though ironically arbitration says that CPC and evidence is not applicable, but we have all the petitions and all the applications very similar to that. And therefore, it is a duty which is incumbent on all of us, including the litigants and our lawyers and the arbitrators, that we should not make arbitration very similar to what court litigation is. And I totally echo what Mr. Gambhir has said. So I'll rest here.
I think I echo what Samit and Mukul had said. One practical aspect which from a consulting engineering point of view I can tell you, in the arbitration clauses, we always tend to prefer single bench arbitration. I think वो बंद हो जाना चाहिए. You should have at least 3 arbitrators, because one person cannot know the technical, commercial and legal, all the 3 aspects. So it's very important that while, as Samit has rightly mentioned, and Mukul also said, that while drafting itself, we should have this provision. Ki boss, it will be 3-person arbitration where someone should have authority on responsibility to appoint technical arbitrator. Somebody should have the responsibility to nominate the financial aspect or the commercial arbitrator, and both of them should have a common guy. I mean, just from a practical point of view.
Yeah, I think that's a very important thing actually. We have been facing this difficulty for, always since decades that arbitration, and with all due respect to the profession, the arbiters are generally judges, and the single arbitrators are appointed. And ये हमेशा से एक बड़ा problem और हमेशा से एक बड़ा concern area रहा है कि because when we're talking about it's a business decision, it's something which relates to the business disputes, commercial disputes. तब एक legal का arbitrator होना काफ़ी नहीं है आपके लिए, unless you know someone who is a legally, commercially sound, technically sound person. So I think either a panel of arbitrator or someone who actually is well versed in all these things, maybe someone who is an experienced industry leader or something. But yes, this has been a problem we have been facing always. True.
I think Samit, that's right. We choose single arbitrator because of cost, but we don't see that if you have a single bench arbitration versus the panel of 3 arbitrators, the cost could be high at upfront, but your time and your actual cost for the entire dispute resolution would be much lesser as compared to single bench. So it's very important that should be decided.
Mr. Gambhir, you have rightly mentioned about, clauses should not be boilerplate clauses. That time has gone because various things are there which you need to keep in mind, like seat of arbitration. Some of the, like what we earlier discussing, that original jurisdiction is not always with High Court, it's a commercial court, and when you go for 34, challenge the award, then it goes to the commercial court which are at the district level. And the things which are there is not easy to move there, right? So yes, you are right. So whenever we are thinking about the drafting of arbitration clause, we should be mindful that the seat should be of that place, like which are more convenient and where the process can go very easily.
I've seen many cases, seat को decide करने में 2-3 साल की arbitration और 2-3 साल की disputes हो जाते हैं उसमें. So I think very clarity has to be there while drafting the arbitration clauses, and you have to keep in mind कि भैया अगर ये बहुत ज़्यादा linger on हो रहा है तो और कोई तरीका है या नहीं है, because I think initially when you're starting, I still feel that that is the time when you are actually thinking about the scenario, that if there is going to be a dispute, what is to be done now. So it's very critical. Seat हो गया, arbitrator हो गया, और कोई अगर escalation clause डालनी है उसके अंदर वो डाल लिया आपने, या any other thing basically. So all these things critically examine होनी चाहिए drafting के time पे. I agree.
Right. Mukul, you come from infrastructure sector, right? So your view, very specific related to infrastructure disputes, how important arbitration clause or arbitration as far as your industry is concerned?
Yeah. So infrastructure arbitration is very, very crucial. So I'll explain it in 2 ways. One is, so I am right now in a private equity fund, which is into infrastructure, and I've been in experience in both Indian corporates and a PE fund in infrastructure. So see, infrastructure per se is always a very high capital intensive investment and a long payback period investment. Like right now we are into road sector, so we have to construct road, or there's a road has been constructed for 3-4 years, and then you collect toll for next 25 years, and that's how you make money. So this means a person who has invested in constructing a road of say 1,000 crores, 1,200 crores, 1,500 crore rupees. This 1,500 crore rupees, this person will get back in 10 years, 12 years, 13 years, and then this person is making some money in next 5, 7, 8, 10 years. Therefore, this is a very crucial piece. And our concessions generally are time bound. You get a concession of 25 years in which you have to get your return back. Now see, if a dispute arises and then the dispute takes 8 years to settle, you think how much impact it will do on my IRR. Suppose there's a construction dispute going on, and my 1,000 crores or 500 crores is stuck, and they are stuck for 7 years. My entire calculation has gone for a toss. And as an investor, then that doesn't make a good investment for me. And that's why most of the companies have failed in India who have invested into infrastructure initially. So that's why now, as Samit has rightly said, that now arbitration, or even in fact legal per se, is no more purely a judicial function or a sovereign function. It is more a commercial function for corporates. So arbitration is a commercial decision. It is no more a judicial or legal decision. It is not a criminal matter in which you have to take a criminal or a judicial decision. So it's a commercial thing. So if it's going to take me 7 years to get my money back, I'll better go and settle even if I have to do it at half the cost. Or I will let my right go, or I will not invest. So therefore, arbitration has to be more fast, more quick and expeditious. That is one. Number two, in infrastructure, the second problem is what I feel, and they're talking about arbitrators and 1 or 3. One is maybe the specialist arbitrators also not there. We have good specialist lawyers now, fortunately, but we do not have the specialist arbitrators right now who understand those nuances that well. They don't understand the infrastructure nuances because there are a lot of calculation involved, the delay claims, the quantum computation. They don't understand the mechanisms that well. And you add private equity into that, so all this valuation, IRR, and those kind of calculation, financial jargons, it's even more difficult for the arbitrators to comprehend them, that what kind of loss it can do to the valuation and the overall impact of that to that project. So therefore, I feel that is something where we should now go for specialist arbitrators, if possible. Maybe GCs like Samit, like Sachin. Why can't we have them as arbitrators? Maybe post their retirements, or if they're not working with the company, because that is the need of the hour. And third thing I feel is a regulatory flip-flop. That somehow has really has caused a lot of pain points to the industry, both to Indian players and to the foreign players. You may see the various amendments, like the amendment of including fraud in Section 36. Now, fraud is such a thing which cannot be decided easily. It is a statement, it is a question of fact to be decided, and that may delay the entire enforcement of a person. Likewise, recently infrastructure, in 2026, we have a circular which says that any dispute more than 10 crores should not be arbitrable. It has to go necessarily in civil court. You said that civil courts are overburdened, some 1.1 crore cases and 46 lakh cases. So almost civil courts are overburdened. Now see, if and infrastructure, as I said, my one road is 1,500 crore, 2,000 crore road, where every single dispute will be more than at least 5-7% of that cost, which will be 70, 80, 100 crore dispute. And talking about the smaller disputes, the bigger disputes are 500 crore, 700 crore, 1,000 crores, sometimes more than that. So for the smallest of the dispute, I do not have arbitration. I have to go to a civil court, and they are log jammed. Then in civil court, I cannot choose seat. In arbitration, at least I can choose seat, as you are discussing. Civil court, I have to go where the jurisdiction has arisen. Now I have a toll road. The jurisdiction may arise in some village in Odisha. I have to go to a civil court there. Now understand the plight of a litigant there. So it's so difficult when you bring out such circulars without applying mind properly. Because so therefore these are the three issues that right now the infrastructure industry is facing.
Very well said. And I just have a follow-up question to that. So are we ready, or India is ready as an arbitration hub in light of recent, policy shift of the government? Yes.
So two things I've always, I think Indians dream of. One is that we should become the permanent member of Security Council, and we should become an arbitration hub. And I've been hearing it a lot about these things. And both these things are very achievable. The problem is, because of these regulatory flip-flops, on the second part, the arbitration part, is why it is achievable, because see the talent. Right now we have only SIAC clauses. We being a Singapore-based company, we generally keep SIAC as a preferred clause, unless in negotiations we have to give it away. But SIAC is a preferred clause. But in SIAC also, who are the lawyers who represent us? They are mostly Indian lawyers. It is Indian talent. Even I have done arbitrations in London, I have done arbitration in ICC Paris, I have done it in Africa, I have done it in Canada. And most of the people whom we have more trust is the Indian talent. And they are cheap, their work ethics are absolutely spot on, and they understand the business realities. And therefore, it is the Indian talent. So when it is Indian talent which we are utilizing, even in foreign jurisdiction, why can't we use them in India? It will be more cost effective for us. But the problem is, again, as I said, is a regulatory flip-flop and that mindset. The mindset that I need to have arbitrator only as a retired Supreme Court judge or retired Chief Justice. I should file delay applications. I should use CPC and evidence as a process for arbitration. It is the mindset of people. Us also, others also, the lawyers also, everybody. So we have to come out of that mindset very, very, very soon. And that will only come when we have better lawyers, we have better arbitrators, and we ourselves also think out of the box. That is where I think so the solution lies. Otherwise, India has all the right things that are there for making it an arbitration hub. A lot of institutions are coming up, a lot of institutional arbitrations are coming up. Mumbai arbitration is coming up, Delhi is coming up, Hyderabad was there. In India also a few more others are coming. So hopefully, and this is a very good business model. I really wish good entrepreneurs come, they leverage AI better and can make these institutions, Indian institutions, really a center where we can have expeditious, speedy, and with certainty we can get some solutions there. So there is a possibility of India becoming an arbitration hub. I feel so.
So, Mr. Gambhir, in your experience, like you have come across like stage of arbitration or the reputation of arbitration vis-a-vis litigation, in your experience, like is growing or in light of recent notification or policy shift, how do you see, or your investors are more keen to go for still arbitration when the government is opposing this policy?
I think we have to encourage the arbitration. There's no doubt in that. And collectively, we have to do that. We have been always trying India to make a hub of arbitration. And we actually deserve that also, as he rightly said, that all the talent, Indian talent is everywhere but the India. And here we are dependent on, few people to do this arbitration and all. So I think idea is that and the mindset is very important actually. Even if we're talking about the mediation in that or something in that, mindset of doing it is very, very important. That the idea is that we have to resolve the dispute rather than, getting into a lot of procedure, making it more complex, more costly for the people. I still remember हमारे पास एक arbitration था, I think 4-5 साल तो वो ऐसे ही चलता रहा कि यार ये adjournment हो गई, वो available नहीं है arbitrator, वो शाम को बुलाया, शाम को हम available नहीं है, this and that. And suddenly, after 4-5 years, we are under a fix, we have spent so much of the cost, and then after that, what happens is, there were employees who were witness there, they have left the organization. Now, उस employees को जाकर ढूंढो, वो बोलता है मुझे इतने पैसे दो, इतना खर्चा है मेरा, and then there is a lack of witnesses. So, ultimately हमने क्या किया? उसको court room की तरह बना दिया. Whereas the mindset, अगर शुरू से ये होता है कि भाई इसको quickly arbitration की तरह खत्म करना है. Rather, that's the reason I prefer mediation, because, to me, mediation is something which is very best course of alternate dispute resolution. But the problem again comes is the mindset. The mindset of the people is very important in India to resolve this.
You want to add something in
that? No, I think to be honest, what Samit is saying is right. I mean, in both the alternate dispute resolution mechanism, whether it is mediation or whether it is ODR, both the things are like that. But again, boss, I'm telling you, it is the mindset of a person or the parties. It's very important whether they really want to settle or they want to drag it for just like your CRPC procedure, what Mukul was mentioning. And that's where the role of both mediator and I really emphasize that point again. Single bench arbitration versus the panel of arbitration. You will incur cost more upfront, but peace of mind, quick dispute resolution, and chances of challenges is also less versus dragging the time and all.
So, in your organization, you are responsible for ensuring legal compliance. Compliance is both domestic and international, right? And you also look for contract drafting and negotiation. You are part of the team. So, when you negotiate a contract and keeping in view the nature and scope of the work, so where do you see putting, in your dispute resolution clause, mediation, arbitration, or litigation? Keep it litigation.
So in a consulting engineering domain, I can say our contract is 99% driven by the client. So we really don't have any chance of, negotiating that piece, because consulting engineer is like a project of 100 consulting engineering fees is one. Okay. But when it comes to negotiating a contract for a EPC player or a turnkey player, there are standards across the globe, whether it is you have got FIDIC guideline, you got World Bank guideline, you got JICA guideline, you got your own Indian guideline on the dispute redressal mechanism. So those guidelines are available, but at the same time it is important whether parties are willing to accept those guidelines. In an infra sector, as my friend was saying, Mukul was saying, in infra sector, dispute resolution framework guideline is very well defined by CBC, by the finance department and everybody. But when it comes to the table, people always, tend to differ. Even if you have got a standard clause at a time of RFP, parties always want to have a dispute redressal mechanism as per the convenience or as per the experience of their own. That point of time, it is very important that the industry should have a common framework. Okay, like if you go to the petroleum or I can say oil and gas industry, their dispute redressal mechanism across the globe remain the same. They have their own standard, they go as per that standard. Similarly, if I come to the infra sector, dispute redressal mechanism is not standard. It is different than one sector to other sector. In the industry also you have got different sector. You got roadways, you got bridges, you got tunnels, you got so many sectors. So every sector will say that I need this mechanism. So it's important that as an industry, and it is benefit to the industry as well as to the country as well, because today India has got $1.9 trillion of infra pipeline. And as Mukul was mentioning, he was mentioning small value of 50 crore. Somewhere we should come to the table as an industry that, okay, below 100 crore dispute, we will follow this mechanism. 100 to 1000 crore dispute, we will follow this mechanism. Or above 1000 crore, let's not go to any alternate dispute mechanism, let's go to the court, because that's what the right mechanism. So somewhere as an industry as a whole should come and discuss and decide what mechanism they want for their industry, just like our oil and gas industry. And I can understand oil and gas industry has this standard because crude oil price is the international price. It's driven by the international market. But in infra, you don't have any pricing mechanism which is internationally accepted. So it is difficult, but at least in India we can have such forum where this can be discussed and agreed that, okay, in India, in industry of infra, we will follow this mechanism. So that's very important.
Just add one small point. One very interesting thing, when I see all this Vivad se Vishwas scheme, the circular that less than 10 crore should be only arbitrable, somehow I feel that even the government feels that arbitration is only for smaller things, for petty things, and it is not something which can really handle big ticket items. So I feel that is why, as you said, why arbitration is not in India, is not a hub, is because that feeling is, we ourselves are thinking that this is not the right dispute resolution mechanism. So maybe that thought process is there. We have to change that also, I guess.
That's why, Mukul, you see that 10 crore circular when Finance Ministry bought in, that was the only reason, because, okay, without naming, it is my personal view, it is not the view of my company, I want to give that disclaimer. When you have any recovery pending in the bureaucracy or in the government department, nobody want to, even if the highest authority knows it's the right thing,
I totally agree.
But they will not sign the paper because of whatever fear they have. So they will say, okay, you go to the arbitration and you get the order.
Totally agree, totally agree.
So that's what the challenge, that's what...
No, totally. We have to have this bureaucracy also which has to be entrepreneurial, but then they have a lot of things. So it's a mindset change, and we have to at least allow our bureaucrats also to fail, and we should not question their integrity just because they have failed in certain things. Like as a GC, I also fail. 10 litigation I fight, I may win 5, I may lose 5. It's a part of the game. Indian cricket team can win 1, lose 1. So it doesn't mean if they are losing a match, the integrity is under question, or integrity is doubtful. So that mindset also has to change, I feel so.
Mukul, when it comes to mediation, like mediation, ARB and MedLab, so what is your take on that? Like if you are dealing or discussing anything about dispute resolution with your PE funds, right? So what is how do you propose them that mediation and arbitration, two different angles or same of the same coin?
Yeah, so there's this famous quote from Einstein, that there are two things which are infinite. One is universe and the second is human stupidity. And he was not sure about the former. So human stupidity can have no bounds. So that is the problem with mediation, that once a person has decided that I want to fight, then you see no sane voices are heard. Like even our this Mahabharata and all that, even Lord Krishna failed to mediate between Kauravas and Pandavas. So that is where the problem is, that once you have decided that no, I have to now fight, I have to teach you a lesson, and you have decided that you will teach me a lesson, then whatever sane voice is there in between, the impact is slightly lesser because we are always charged with that kind of mindset. So maybe only once we're in the war, and in between the war, after seeing that yes, we have lost a lot of money and a lot of bloodshed, maybe then people can realize the kind of mistake that they have committed, and then maybe mediation may help in between. Therefore, this mediate, arbitrate, med-arb, this concept is there. So, but now Indian the law is that now we have mediation law. The law says it's a mandatory mediation. The MCI was supposed to be there. It may come, and it's still not fully functional. The Mediation Council of India, but law says that before going for arbitration, you have to have a mediation. 120 days is the basic time, 60 days extendable. So in that 180 days, if the parties can really sort out their difference, they can settle. And if they do not, then ultimately they have to go for arbitration or litigation or whatever the dispute resolution is. Then they have to go and then they have to fight it out. One small thing is, so I feel that it is a good beginning, but as I said, once people are charged up, I have not seen, at least in my career of 2.5 decades, that any parties have settled before at least testing the waters, and once they feel that the cost is heavy, maybe they can come to a settlement terms, but not before that. I've not seen in my personal experience, but then I feel in the concept it is a decent concept, because arbitration also suggests, the data suggests that 27% of arbitration they ultimately parties they settle. So there is a possibility of some kind of a settlement. So if we have really good trained mediators, if that trained voice is there, who can really make people understand that this is where your cases are weak and this is where your cases are strong, and at least talk to the parties properly, there is a possibility of mediation being successful. But as on date, how it stands today, mediation is nothing but a 6 months delay in the entire process. This is what I feel.
Just a follow-up, when you say mediation, like good mediator should be there, so anything which you'd like to advise, like what kind of qualification should be there possessed by mediators?
Most of software systems, so as a lawyer, and we all are lawyers here, at least sitting here, so we are always trained to argue, I feel. Our training is very adversarial. The first thing we see is, okay, we have this beast-like thinking, the predatory thinking, and that is what we all are built, I guess, like that. If I see something, I will always see dispute, and I like to fight to win that piece of pie. That's what we are trained for. This is how our instinctive are. The people who are generally who become the GC or who are in-house counsel, they slowly and gradually also develop the business acumen. So they don't want to fight initially. They want to just see and settle business. So they are like they are wolf who are like trained a bit, half trained wolf, half dog, something, whatever you can call them, a different species altogether. But then that is what the mindset is. But the mediator is someone who is very different, who don't see dispute as something of win or loss. Somebody who can really think through that what is the right path, what can be there. Because obviously in whatever mediation you do, very rarely it can be 50-50. You cannot if there is a partition, you cannot make 50-50 that easily. Someone will be winning something, someone will be losing something, and the person will be feeling that I am losing something, will not like to mediate, will not to settle it. Because why should I take the lesser piece of pie? And very difficult times to just do every single thing equally. But that is where the training comes to. The mediator is someone who can really, who can talk through well, who can explain these things well, and who can really put this thing across very rightly. That if you go on for a fight, this is what the ultimate cost is. And even if you win the battle at this cost, whether it is worth the winning. And therefore, so that training is there. So what kind of adversarial training that we have to unlearn that training. As an arbitration lawyer, what training you have to unlearn that training a bit and develop this training of resolving dispute. That is what I feel, that is where the skill set is. Not only about education qualification, it is the mindset. So maybe those who have that mindset of bringing people together and who can really talk them through and can get things settled, they will be a better mediators than anybody else.
I'll just add what Mukul has just mentioned, and recently we were experiencing the same thing. So we were supposed to choose the mediator, Mukul, and it's a consulting dispute. But the CVs of mediator which we got from the lawyers, they were all like judges and those things. First I was surprised. I said, why you are giving the judges CV? I know somebody should be from the industry who knows what the problem is and how to come out of it. But that's what it is. Even if you go for a CV searching, you get CVs of judges, retired judges, or even sitting judges. And when you see their history, their background, they are not matching to the requirement what you have on the table. So it's very difficult actually.
So we have to understand the industry also. So if I have to settle certain things between two people, I have to understand the industry. And that's why I feel even for arbitration also, I don't know why they don't consider the GC pool at all. And it's my fault also. I also always go for judges, and that's how the mindset is. And because there are good GCs in the industry, but somehow we don't go for them. Somehow, I do not know why, it's just a mind block, and including myself. I'm not saying for others. So that mindset has changed. Or a young, good lawyer who is really expert, a lawyer who has spent 10 years in a particular dispute. Maybe that person will be a better arbitrator of an infra dispute. Say a road lawyer who has done 10, 12 years of road infrastructure arbitration. That person will be a better arbitrator than maybe someone who doesn't understand the sector better. So maybe that mindset also has to change. And I hope with AIs and all that stuff, things will change in our mindset maybe. And we'll see.
Yeah, I just remind about that technical expert and financial witness. So thing is that when you say that it's not always retired judges should be there as an arbitrator, but thing is that vacuum I think can be filled if the parties they appoint their own technical expert or financial witness. So as a GC, like at what stage of the dispute you feel that there is a need or urgency to appoint your independent financial expert or technical expert? Yeah.
No, it is. So in infrastructure, things are complicated. So you see in dispute, what kind of disputes are there? So one in infrastructure is there will be some quantum delay, there will be some time delay, cost quantum, that is where the dispute will lie. And then in a private equity space, there will be some kind of financial implications of that, valuations and IRR impact and all that stuff. So for that, obviously, you need that expert. Like for example, if there's a road to be constructed, for example, and I'm saying that the road is not constructed properly by the EPC contractor. I'm saying the bitumen content that this person has mixed in this road is bad. Because road is basically just like a sandwich. There's a bread in between, a patty, and then there's another bread. So what is the bitumen content? That patty is the main thing in the sandwich. Like with the road, it is that patty, it is that mix that you put between the two layers. That is the mix where people make a lot of money. It is the bitumen content which is generally there. Bitumen is an expensive product. So therefore, the dispute is that whether you have you laid the bitumen as per the specification or not. Now that I'll need a technical person to come and explain things. That yes, this is not the right country. I've done this survey. I've done some sample surveys, or it is there at some places, not there at some places, or whatever it may be actually. So that is there we need the expert to come in. Just one example. Likewise, whether it is solar energy or any other things, likewise you need expertise to come and explain to the arbitral tribunal. Similarly, for financial expert also, because see if that cost is there. So suppose that cost, the kind of loss he has committed was only 5 lakh rupees, example. But because of that, because of the delay, I may have been some penalty have been slapped to me of 5 crores, or because of that thing, I might have delayed the entire thing by say 2 years, and that may have impacted my valuation a lot. So that conduct of his is not only a 5 lakh rupees cost; it is a cost of 50 crores. Because of this, I have said a penalty is there. For that penalty, I have to do it again. I have not only do this road, my traffic was stopped, my entire project was delayed. I got my approval got delayed because of these things, and therefore my entire project got delayed by 2 years, and therefore my cost is say 50 crores. Some example. So therefore, to prove those things, again I have to bring in a financial expert, and then an expert is to explain that why it is, how it is not a notional loss or a remote loss, and how it is all connected, how it is a direct loss. So even an expertise therein. So to bring in all these people, the technical person, the financial expert, to bring in within the framework of the Contract Act, you need some experts to come in. Obviously, the last part is the legal part, which the lawyer will take care of. But the first initial 2 parts, we need a technical expert, we need a financial expert who have to come and testify before the tribunal.
Sajin, about your take on designing of contract with the intention that disputes are unavoidable, right? So how do you see, like what are the things should be there in the contract draft?
No, I mean, it's designing a contract, understanding that dispute is unavoidable, it's a very common thing. I mean, see, we are all coming from a GC fraternity, whether we see in which industry what kind of disputes are there. And if you see the dispute data, just to give you some number, I was just searching it out. In commercial court in India, after 2015, only Delhi, Mumbai, Chennai and Bangalore, they got over 7,08,000 cases. And that cases were only in JV infra related arbitration. Ideally, they should have taken 1 year to settle these disputes. it took more than 4 years if you average out from 2015 to 2025. 4 years is the average time they take to settle the dispute. If you see NCLT and IBC, since 2015 again, they got more than 7,500 CRPC, CRIP related cases, in which 1,000 were resolved. Statutory timeline was 330 days and actual timeline is 600 days. So, you know, when we draft our contract or when we design our contract, we know all this fact is going to be there on the dispute, which is the worst case. But as a GC, specifically from a GC community and not coming from a wolf community, which Mukul said, that we are half wolf and half dog. So we have to take care of that aspect, that time as and cost, both has been taken care, and business must go. We are in a company where our business is not to fight the cases, but to do the business. And when that mindset is there in the GC's head, he or she will definitely try to prolong any dispute going to the arbitration or going to the litigation. How it will happen? It will just happen with the advocacy, which is not written in a piece of contract. But at the same time, it is also important that you keep your communication expressly between the party. That it should not happen that you are waiving your legal right of the contract just to maintain the relationship. So maintaining relationship is important, but maintaining your contractual rights is also equally important. So that's the navigation which a GC has to do. So while designing the contract, arbitration clauses are the last resort. But before that, the communication and notices channel is one thing where we keep our engagement on the negotiation always open on any open dispute. So that's very important that somebody should draft accordingly.
You're absolutely right, and I think, you know, as I already told you, that arbitration basically, when you're talking about the dispute resolution, it's just a commercial decision now. So मैंने कभी PSU में इंफ्रा के तो हैंडल नहीं किया, बिकॉज असली मजा वही है arbitration हैंडल करने का, मैंने सुना है. But I think for the commercial disputes also, it becomes a strategy for you, you know, कि आपको arbitration को invoke करना है या सामने वाले से करवाना है या किस तरीके से आपने चलना है, negotiation में जाना है, time gain करना है. So I think it depends upon case to case, depends upon party to party. Normally what happens is, आइडिया ऑर्गेनाइजेशन में तो यही रहता है कि यार इसको किस तरीके से हमने स्ट्रैटेजिकली डील करना है. इज इट द राइट टाइम टू इन्वोक नाउ? इज द राइट टाइम टू, you know, keep negotiating first, or is it the right time for me, or, you know, let them invoke the arbitration first and then see what happens, you know, how do we take it further? So everything depends on a strategy. मेरे को लगता है कि ये it's not a black and white way. Simple नहीं है कि आपके साथ dispute हो और आपने arbitration में घुस गए. So it's a lot of strategy which goes into that, and as a GC and as a lawyer also, you know, one has to really think, and that's where I say that you really have to very closely work with the business people to understand the impact, to understand the future issues. कहीं एक बार कोई insurance issue आ गया, पता लगा किसी insurance वाले ने एक बार blacklist कर दिया किसी और वजह से because of only things season. तो बहुत सारी चीज़ें इसके साथ involved होती हैं. तो I think it's basically, you're right, जहाँ तक हमारा आर्बिट्रेटर का इशू है वो हम थोड़ा सा चैलेंज फेस करते हैं कि खाली लीगल माइंडसेट वाला या कमर्शियल या टेक्निकल वाले नहीं होते, बट एट द सेम टाइम मोस्ट ऑफ द टाइम फॉर द जीसीज गोज इनटू मेकिंग अ स्ट्रैटेजी कि किस तरीके से इस आर्बिट्रेशन को कहाँ ले जाना है, कैसे करना है, क्लोज करना है. क्योंकि इंटेंशन अगर सेटल करने की है तो करो और फटाफट खत्म करो, बट सेटल करने के लिए भी आपको दोनों पार्टी का माइंडसेट चाहिए ना. जब तक नहीं होगा तब तक कैसे होगा? आई थिंक दीज आर चैलेंजेस वी रियली फेस डे टू डे.
स्मॉल थिंग जो सचिन ने बहुत सही बोला, and he is very right. See, and very interesting statistic that statutory IBC says 330 days, but practically takes more than 2 years. Okay. Now, see, as a private equity investor, somebody who wants to invest into India and wants to acquire, say, an asset through IBC. Okay, they say, okay, this commercial value is there, and law says 330 days. So obviously, in your notes, in your board notes, you'll write 330 at max. So they will make their calculation that, okay, if I get that at worst in 330 days also, okay, this is my IRR making some sense, whatever, say 10% IRR I will make. Now, as a thumb rule, generally if you generally delay things by a quarter, you generally lose 1.5% of IRR, generally, though it is a complex thing, I'm just saying in a very crude manner. So if entire thing is delayed by 4 quarters, because that is the average, 330 to 660 is just an average, 1 year to 2 years. So if you are losing 4 quarters, almost your IRR from 12 has gone to say 4%. And 6 is just an average. It can go to 900 also, who knows? So that is just an average number which Sachin has just said. So if it's going to some 700 or 800 days, my IRR becomes 0. So a private equity investor who wants to invest in India through an IBC route, and once you are into it, you are into it. If you're an RA, you are an RA. And then now you are a registered applicant. Now your skin is in the game. And you simply cannot walk out also because it has its own consequences. Now you see, this person got the asset after say 700 days or say 750 days, and that asset is of no value to this person. So what kind of solution we have given to the bankruptcy then? So this timing is not only defeating or not only causing harm just because of the delay or the cost associated, but it is ending the fundamental existence of that law itself. It is an existential crisis for that law. Well, then that law is of no use to me. Though I said I believe that IBC is a very good law and it is doing wonders, but still that is something that delayed times cause a bigger harms. So the same thing, why India could not become an arbitration hub, why arbitration is failing in India, simply because this delay has caused harm to this arbitration. If I'm hungry today, I need food today or tomorrow. You cannot give me food after 10 days or 15 days. Even if you give me the best of the meals after 15 days, that has of no value to me. Better you give me today something which is of, even if it is a bread or something. So idea is this delay may cause existential crisis. And the reason why arbitration is not doing that great in India, why IB sometimes is not doing that great in India, why our dispute resolution per se is that clogged, is somehow our mindset of delaying things. And that is where we have to really come out of this Indian standard time mentality that everywhere I'll reach after half an hour. Somehow we have to be very punctual if we have to become a very Vishwaguru global economy.
No, absolutely fine. So just last for everybody about the enforcement. I know this is one of the pain points, of corporates about the enforcement of award. So anything just briefly if you want to touch upon this thing.
No. So, no. Enforcement, I feel, is see what happens in any contract. Whatever you do, there's always one party who will you will be asking some money to me. So one party who is always want to delay things. So obviously one litigant will always like to delay because that is the strategy. If I want to delay and it is making sense to me to delay things, I will always delay. I will use best of the lawyers to delay things. So that is where it is the duty of the judge or arbitrator, whosoever is that mediator, whosoever is who's an independent person in that adversarial system. It is a duty incumbent on that person to ensure that this party does not delay things. And therefore it is more so for the judges, for the arbitrators, and that is their specialization should be, that they should ensure if the timeline is 330 days, they should end things in 330 days. If it is in 18 months, they should end things in 18 months more often than not. That is what the main skill set is. And once we have achieved those skill sets in our lawyers and arbitrators, in our judges and arbitrators, I feel you will see a sea change in enforcement of contract also.
I mean, enforcement, to be honest, other part is that enforcing the arbitration order itself. Taking the order and going to some place and getting executed, it's very difficult. It's not so easy.
The trouble of arbitration starts after you have an award.
Yeah, that's right. So I think we can now open for the questions from the audience. If any questions there.
Hello, sir. It was a wonderful panel, and there was great clarity in the thoughts that you guys expressed. So my thing is you have discussed about this policy aspect, like everybody have touched in about this policy aspect. So do you think the government policies right now in terms of arbitration, dispute resolution does not incentivize a quick resolution? And what do you think the steps should be? Because I'm a little sick to keep listening that India is emerging. I'm like, when will it finally emerge? So what do you think as a young person, like in terms of interested in working on policy, like what suggestions would you like to add?
So policy-wise, I feel at least our intent has always been to emerge That is what the intent has always been. Our arbitration, you also see the law is reasonably okay. We have all things in place. Of late, even the intent of the judges and the judiciary is also pro-arbitration. We'll see a lot of judgments whereby they are not interfering stuff. But there is one thing we have to be, so the balance that we have to maintain. One is in the garb of arbitration, there should not be a case that you are denying a justice also. So it should not be a case that one party, which is a dominant party, is really sweeping over other parties. So that balance has to be maintained. That is what the judiciary has to ensure. Well, see, if they are not equal parties, one party is dominant and one is not the dominant, and the dominant party will have the better of the arbitrators, will have better of the lawyers, better of the resources. Other party may not have that. Just think about like IOCL having a petrol pump and a dispute between a petrol pump owner and IOCL. Okay, so petrol pump owner has no wherewithal to fight IOCL. Just an example. Okay, or likewise, any other company. Now, for arbitration, and that's what the court has to see under Section 34, etc., that is whether this person got the right opportunity. So sometimes they have to go beyond the letter that is there in Section 34 to do a complete justice. That is also a duty of the court. So as policy is concerned, so as the intent is concerned, we have been in the right, our minds have been right, our things have been right, our policies have been right. But the problem is whenever you do something good, there's always a flip side. And the flip side is this, that because of this, because the court has to be ultra cautious, there is a possibility that person can delay things. So obviously it is in the scheme of things itself, there will always be delays or will be part and parcel of it. So scheme is right. Only thing is, as I said, it is all the intent of the party, and therefore it is an incumbent on that arbitrator, on that judge. That is a very crucial role. He is a very economic kind of person. He can really change and shape the Indian economy, because better arbitration, better dispute resolution means better investment coming into India. India becoming a hub for arbitration, for economy-wise economic activities. So dispute plays a very important role. Dispute resolution plays a very important role, and therefore it is incumbent on that arbitrator, on that judge, to really do things right, to see it through. That is the specialization should be of that individual. So it's more about the skill set that we all have to develop, more on the policy. I feel policy more or less is on the right track. It is in my limited opinion.
Can you the question?
Yes.
Okay. Thank you, everyone. Thanks. Thanks,
you.
Mukul. Thanks. Thanks so much.
Thank you to all our panelists for another insightful session, and that really wraps up the panel discussions of the day. Once again, I'm going to invite Mr. Anupam Ashish on the stage to felicitate all our speakers for this session. Let's get the mementos for all of them. Beginning with Dr. Mukul Shastri. Thank you so much for taking our time this afternoon and joining us for this discussion. Mr. Sachin Mishra, thank you once again for joining us, sir. Mr. Sameet Gambhir, thank you, sir, for sharing your expertise on the topic. And our moderator for the session, Mr. Rajdat Shekhar Singh, for wonderfully conducting this session. Of course, highlighting the growing prominence of arbitration as a preferred mechanism for resolving complex commercial disputes. Let's just get all of you together for a group photograph. Anupam, would you like to join? Can we please have a big round of applause? That was our final panel discussion of the day. I'm sure there are a lot of takeaways for the young audience here from that panel discussion with our experts. Thank you once again to all of you for joining us and getting us that insightful exchange of ideas and points of discussion that we all will be taking with us from this session. Now, ladies and gentlemen, with that, we are going to take a short break before we reconvene for the awards ceremony, which is going to be the highlight of the evening. A quick reminder to all of you, please do use the hashtag Lexa2025 whenever you are engaging in social media conversations about this event today. Let's take a quick break. Thank you, and do join us after that. Thanks. award we've all been waiting for throughout the day. Can we please encourage you to join the party, so to say? Because we are beginning now with Lexa 2025. Now, Lexa 2025 is divided into awards and excellence list. The list has 6 categories: top individual lawyer, top managing partner, top general counsel, top law firm, top in-house lawyer, and top law firm management professionals. These are the 6 categories under which the awards will be given tonight. The winners were shortlisted through a rigorous evaluation process conducted by our esteemed jury. The comprehensive assessment criteria included evaluating members of the legal fraternity on their outstanding work in the year 2025. The qualities that distinguish them from their peers, their growth and experience, and above all, their unwavering dedication to upholding the law. Now, I would first like to invite on stage Fortune's Deputy Editor and Chief of Delhi Bureau, Fortune India, Mr. Ashutosh Kumar, to deliver the opening remarks and extend a warm welcome to our guest of honor, keynote speakers, and the award winners. Can we please extend a warm welcome to Mr. Ashutosh Kumar.
A very good evening to all of you, ladies and gentlemen. It's a pleasure to welcome all of you to the inaugural Fortune India Legal Excellence Awards and List of 2025. As you all are aware, Fortune India magazine is extremely well revered for its Fortune 500 list of companies and the other proprietary lists that we bring that includes most powerful women list, 40 under 40 list of entrepreneurs, and also some of the other lists like Fortune India Best MNCs that we have recently started. So going forward, we are especially honored by the presence of our of our guest of honors for the evening, Mr. R. Venkatramani, Attorney General of India. A huge round of applause for you, sir. Thanks a lot for gracing the event, sir. So at Fortune India, we engage very closely with the world of business and institutions where the contribution of legal profession is both significant and often understated. It shapes decisions, strengthens governance, and helps institutions navigate complexity with clarity and confidence. For us, then, this becomes a natural extension of the larger conversation around leadership, institutions, and excellence. And that, ladies and gentlemen, is what gives an evening like this the all meaning that it deserves. Lexa is an opportunity to recognize excellence across the legal fraternity, a platform which reflects both the depth and the diversity of legal talent in India. And the response to this first edition has made one thing clear: there is both room and resonance for a platform such as this. But this evening, above all, is a celebration of the ability, rigor, judgment, and professional excellence. To all the winners, I extend on behalf of Fortune India team a very hearty congratulations, and this recognition reflects the quality of your work and standards that you uphold. Thank you all for joining us and for making this first edition so special. Have a wonderful evening. Thank you.
Thank you very much, Ashutosh, for setting the tone for this evening. And I'm going to request you to please join us at the center of the stage so that we can felicitate our dignitaries who are present amongst us in the audience. Ashutosh, can I invite you to please join us there? And I'll be calling on stage first and foremost Shri R. Venkatramani, learned Attorney General of India, whose unwavering commitment to ethics and integrity sets the highest benchmark for the nation. A stalwart of the legal profession, he has been a constant and invaluable pillar of strength for legit quest. Thank you so much, sir, for joining us this evening. Thank you, sir, once again. Now, I'd like to invite on stage Ms. Pratibha Jain, Head of Strategy and General Counsel, Everstone Group. Welcome, ma'am. Thank you so much for joining us here. extend a warm welcome to all our distinguished guests as they are joining us on the stage. And we extend a token of appreciation to all of them for joining us this evening. I know you all have a very busy schedule. Next on stage, can I please invite Professor Dr. Pradeep Kulshrestha, Dean, School of Law at Bennett University. Thank you so much, sir, for taking out time this evening. We would also like to invite on stage Shri Sudhanshu Mittal, well-known political figure and also President Kho-Kho Federation of India. Thank you, sir, for taking out time for us and joining us here at Lexa 2025. Thank you so much to all of you. And with that, sir, I'm going to request you, Mr. Venkatramani, to please be with us because you are not just our guest of honor for the evening, you are also our first keynote speaker as we move towards the awards ceremony. It is a great honor for all of us that Mr. R. Venkatramani, Learned Attorney General for India, has agreed to start the proceedings with his keynote address. So I'm going to hand over the stage to you, sir. Please, if we can have your keynote address.
Fine. How do we acknowledge talents and particularly hidden talents? And how do we acknowledge talents which are not advertised? Because those who are here don't have a platform where you can advertise yourself. You don't have a place where you can engage in self-glorification. Many of us do that. In the legal profession, we have all the opportunities to advertise ourselves, even though we do not advertise in the formal sense. Long ago, the US Supreme Court said advertising was not bad for lawyers. But then I'm not talking about that kind of an advertisement. We need a social space, particularly in the legal fraternity, where on an institutionalized basis, and a basis where one can legitimately look forward for acknowledgement of what we give to within inverted commas, the rule of law principles. And an evening like this, when you're gathered to be acknowledged and then graciously picking up your awards, not a good time to talk about dense subjects of law, jurisprudence and things like that. But I suppose, given the trajectory of India's growth in the past 25 to 30 years, and the fact that for capital to grow anywhere, you need a code. Capital does not grow by itself, like a tree does not grow by itself, or a plant does not grow by itself unless you water it. So a legal framework which facilitates economy is more important for every country. The West got hold of it for a long time. We came into it a little late in point of time. Nevertheless, we are able to catch up with the rest of the world. But in the race, the catching up with the rest of the world, we encounter all those issues which always come like a relay race, right? You don't start well and you don't end well. So it's like a relay race which is happening at a global level when use of economic ideas. I don't think economic ideas are frozen in point of time. Every generation of right-thinking people who believe in values of liberty, equality and human welfare nourish and bring forth important ideas both in economics and public life, particularly political life. I suppose therefore economic ideas are not frozen in point of time, nor they belong to any particular country or civilization. They belong to common humanity. So in that point of view, when India is able to march slowly but steadily, we have this need for new economic thinking. And what do you mean by new economic thinking? I think all of you, we are part of the new economic thinking, I would call that. The new economic thinking is not like Adam Smith or early 20th century or 19th century thoughts on economic ideas. We have gone far beyond Samuel Paulson and all those Chicago School of Economics and so on and so forth. So we have on the race for new economic ideas, which will be laced with principles of fairness, equity, sharing, and common goods. Somewhere in 1973, before all we had GATT and WTO, there was some discussion about the new economic order. United Nations was talking about it. But that was in the shadow of the still warring fight between two ideologies, socialism and capitalism. I think for good we have gone beyond those clash of ideologies. We are in a different framework of global understanding. It's in that context I think that India's role is going to be very important. And all of you who have been playing what called the invisible role in making the ideas of economic and economic transaction and all that goes with it, I think deserve a great applause. I would certainly applaud and every one of you gathered here. And I wish that I can be a chronicler of each and every one of your life, and probably beyond a chronicler, if possible, a biographer. And that will give me a great pleasure to say that I've been part of this great journey of many of you who have been able to do the invisible part of it. That's why even in Adam Smith they call the invisible hand. All of you are the invisible hand which moves the clock 24 hours non-stop. So I am very glad to be here today. And as times change, I find more and more women in becoming leaders, and then it's a very great sign. It's an important sign for a country. While we have all kinds of thoughts about the shackles which women face in public life, in private life at home, and more particularly in professions. And it's so heartening to see so many of you. And I would probably like to read a bit of poetry I wrote on women in professions. We had a week or 2 weeks ago, the Supreme Court had a conference on women in law. And a lot of questions were asked to me as to what an Attorney General can do for making women's life in law better. I said, I don't hold a portfolio of the promises, but I am sure I can think more and then more good enough and all that. And then soon thereafter, we were in a conference in Bangalore and SCBA, and began a large number of women gathered, lawyers and students. It's so beautiful to see such congregations, and I have the same feeling today evening that I'm able to see many of you who are tall enough in your own contributions, as I said, invisibly, and so on and so forth. So I thank Karan, the old friend of mine. He's got a brilliant brain somewhere deep inside, and he doesn't show it so much. Way back in 2015 or 16, he came one day along with one of our friend, Niklesh, and started thinking about a new thought process of what you call artificial intelligence. Something which will assist courts, lawyers, and people like us in being able to comprehend what is there in store as a matter of data in law and things like that. So I know he has traveled quite a long distance. As I was looking at this, a thought came to my mind. Suppose I have an artificial intelligence machine on my hand. The only thing I would like to wish is make all these books real. Will they become real? Karan is trying to make many of your lives real, and they should be acknowledged, really. I congratulate you, Karan, for having this. And I don't think I'm going to even ask artificial intelligence to make this library real, because we all have our own. So let me conclude my little exchange with you today evening by, with your permission, I may read this little piece which I wrote on women. I titled it The Weary Traveler. How do I share the stress I bear on many friends with smiles on my face? To be a woman is being more than a man. All attachments that I carry or stories that I marry. No task of human care is alien to my mental wear. In hospitals, I am your homely care. In schools, I am your mindful care. In cleaning roads, I am your social care. In TV chats, I am a daring chair. In creches, I am a motherly care. In armed forces, I am an equal dare. As a pilot in sky, I take due care with my gentle teams and smiles they wear. In making garments, I am of talent rare. Any task I hold is no great deal. At home, I am an all-tool wearer. From morn till night, all duties done, in courts to plead or judge. In all I do, a weary traveler should I be, and wait for justice to land in whim. All I need is the weeds of minds to be cut and trimmed, that I walk with shoulders burdened less and beg not for what is due. And the caravan of my life is lit more bright, its wheels too carry many smiles. Thank you, Karan, for calling me today evening. Are we done? Okay. So you can stay here. Stay on? Okay.
Thank you so much, sir, for those deeply thoughtful words. And I'm sure amongst the women folk in the audience and also those who are seeing us online, you have many new fans now, not just all of us who are in attendance here. Big round of applause, I think, for that wonderful speech from our first keynote speaker of the night. And sir, with that, I'm going to request you to please remain on stage with us because we are now starting to felicitate our awardees. So ladies and gentlemen, it is now time for the most anticipated part of the evening, Fortune India Legal Excellence Awards and Lists 2025, honoring the luminaries from the Indian legal fraternity. So ladies and gentlemen, we begin with the most distinguished honors, In-House Teams of the Year Awards, along with the Best Forensic and Investigation Company. These recognitions celebrate individuals and teams who have demonstrated exceptional leadership, impact, and excellence, setting new benchmarks within the legal fraternity. Without further ado, let's begin. And the first award goes to in the in-house team category. Before I name, all the awards are going to be listed in the alphabetical order. No other criteria. So the first award, in-house team, goes to Adani Power Limited in the category Energy In-House Team of the Year. Please join us on the stage to take your award. Can we cheer for our first awardees here? Thank you for joining us. Adani Power Limited in the Energy In-House Team of the Year category. I just want to mention here that on stage we are giving the dummy certificates, but you can collect all your certificates from the registration counter just outside this hall. So please make sure that you collect them before you leave tonight. Thank you so much. Let's invite now the second winners in this category. We have Contagious Online Media Network Private Limited for Media In-House Team of the Year. It's a power-packed all-women team, and let's cheer them as they come on stage to take their award and certificate. Congratulations. Next, I'd like to announce the third name in this category. It's ITW for Sports and Gaming In-House Team of the Year. Okay, if someone is not with us, we'll quickly move on to the next name. Patanjali Foods Limited in the FMCG In-House Team of the Year category. Can we please have you on stage? We have just started. The claps should not die down. The evening has just started. There's a long list to go. It's Patanjali Foods Limited in the FMCG In-House Team of the Year category. Congratulations to the team. Next, I'd like to invite on stage Resilient Innovations Private Limited Bharat Pay in the FinTech In-House Team of the Year. Members of the team, please join us on stage. Congratulations to all of you. Thank you so much. Right, with that, let's move on to the next winners in this category, and it's Sterlite, Resonia, and Serentica in Manufacturing In-House Team of the Year. Request you to please quickly join us on stage to take your award and certificate. Congratulations, Sterlite, Resonia, and Serentica in Manufacturing In-House Team of the Year. All right, let's now announce the next winners. It's Tata Consulting Engineers in Real Estate, Construction and Infrastructure In-House Team of the Year. All the members of the team, please join us on the stage to take your awards. And once again, you can collect your certificates from the registration counter just outside this hall before you leave tonight. Congratulations, Tata Consulting Engineers, for getting that award. Thank you so much. Well, I'm just going to give a few seconds to our cameraman for fixing that light. It's going to be extremely important that the light is on you tonight. And I'm going to... Yes, I think we should announce a category for that as well. Right, let's now move on. Next winners are Zycus Infotech Private Limited in Technology In-House Team of the Year. Can we please have you on stage? Thank you so much. Congratulations, Zycus Infotech Private Limited. Our next winners are Netrika, Forensic and Investigation Consulting. Request the team to please join us on the stage to take their awards. So we are seeing many members of the team join us on the stage, and it's always good to have all of you with us to take your awards and certificates. The original certificates, of course, can be collected from the registration desk outside. Congratulations, everyone in this category. With that, we are moving forward, and now we will turn our attention to a broader celebration of excellence with the Fortune India Legal Excellence List, recognizing an exceptional pool of legal professionals who continue to make a significant impact across the industry. Our first category of winners is Top General Counsel, with the significant responsibilities of acting as the legal representative and providing legal and commercial advice on a host of wide-ranging issues. A general counsel or legal head adds a lot of value to an organization. Lexa 2025 recognizes the best in-house performance and leadership of general counsels, legal heads, and chief legal officers. So let me invite the winners on stage once again, starting in an alphabetical order. Let me call out first for Ajay Kapoor, Chief Regulatory Policy Advocacy and Legal, Tata Power Company Limited. Congratulations. Thank you so much. Next, I'd like to call on stage Amit Thareja, General Manager, Head of Legal Department, Patanjali Foods Limited. Please join us on stage, Mr. Amit Thareja. Congratulations. Moving on now to announce the name of the next winner in this category, Anubrat Saha, General Counsel and Vice President Legal, Eastman Auto and Power Limited. Next, we'd like to call on stage Binu NS Puri, General Counsel, Bajaj Electricals Limited. Congratulations. Our next winner in this category, Chetan Chopra, Group General Counsel and Head, Legal, Public Policy and Corporate Affairs, Ola Electric Mobility Limited. Okay, I think we'll move on to our next winner then. Devjeet Ghosh, General Counsel and Chief Compliance Officer, Sustainable Energy Infrastructure Trust. Please join us on stage. Congratulations. Now for the next award, I'd like to call on stage Garima Saxena, Whole-Time Director cum Legal Counsel and Company Secretary, TUI India Private Limited. Congratulations. Thank you very much. Let's move on to our next winner in this category. And for that, I'd like to call on stage Hiranmay Ralabandi, General Counsel and Chief Governance Officer, We Work India Management Limited. Congratulations, ma'am. Our next winner in this category is Joy Lashmi Das, General Counsel, ITW Universe. Okay, we'll move on now. Madan Mohan KR, Director, Legal and Compliance and member of the Executive Board, Air Liquid Global ENC Solutions India. Congratulations and please join us on the stage. All right, moving on now to announce our next winner in this category, Manish Kharbanda, Group Legal Head, Advisor, Jindal Steel Limited. Congratulations, sir. Thank you so much. Our next winner in this category, Manoj Bhargav, Executive Director and Group General Counsel, India Mart Intermesh Limited. Congratulations, Mr. Bhargav. Our next winner in the category, Megha Sharma, General Counsel, Contagious Online Media Network Private Limited. Can we please have you on stage? We have a company representative taking it on behalf of Megha Sharma. Thank you for joining us. Next winner, Dr. Mukul Shastri, Group General Counsel, Cube Highways. Congratulations, Dr. Mukul Shastri. Our next winner in this category our next winner in this category, Neeta Sangvi, CLSA India Private Limited, Head of Legal and Compliance. Okay, we move on to the next winner. It's Nishtha Sikroria, Head of Legal and Business Affairs India, Virgin Music Group. Congratulations. Our next winner in the category, Puneet Parihar, Head Legal, AI Tasneem Enterprise LLC. Moving on now, our next winner, Qazi Riaz Masood, Legal Director, Johnson Controls. Can we please have you on stage, sir? Congratulations. Next, I'd like to call on stage Dr. Rajiv Chopra, Managing Director, Legal, Accenture. Thank you very much. I'd like to call on stage Sachin Mishra, General Counsel and Company Secretary, Head Compliance, Tata Consulting Engineers. Please take a cue from the learned Attorney General of India. He's standing here and you are not even clapping loudly enough. Thank you very much. Next, I'd like to call on stage Saikat Sarkar, Group Chief Legal Officer and General Counsel, TAFE Tractors and Farm Equipment Limited, to take his award. Congratulations, Mr. Sarkar, and thank you. Next, I'd like to call on stage Sameer Chugh, General Counsel and Chief Legal Officer, Play Games 24/7. Congratulations to you. Next award winner in the category, Sameet Gambhir, Senior Vice President and Legal Head, Uflex Limited. Please join us on stage, sir. Congratulations, Mr. Gambhir. Let's announce the next winner then. It's Sameer Singh, Head Legal and Compliance, Birla Opus Paints, Aditya Birla Group. Please join us on stage, sir. Congratulations, Mr. Singh. Our next winner in this category, Saurabh Malhotra, Head Legal, Risk and Compliance, South Asia, Intertech India Private Limited. Saurabh Malhotra. Okay, let's move on then. Shalini Kulshrestha, Outgoing General Counsel, South Asia, Dentsu India. Please join us on stage, ma'am. Congratulations, ma'am. Let's announce the next winner. Shruti Jain, Group Chief Legal and Compliance Officer, Sterlite, Rezonia and Serentica. Please join us on stage to take your award and certificate. A quick reminder to all the award winners here, your original certificates are available at the registration desk. Please do remember to collect them. Next, I'd like to call on stage Sonia Bharaj, sole in-house legal counsel, General Counsel of the Square Limited. Congratulations, ma'am. The next award winner, Sumit Singh, Executive Director and General Counsel and Head Corporate Affairs, Resilient Innovations Private Limited, Bharat Pay. Let's hear it once again for our winners here. Next, I'd like to invite on stage Tushar Gunderia, Senior VP, Head, Legal and Compliance and Company Secretary, Blue Dart Express Limited. Please take your award, sir. Congratulations, Mr. Gunderia. Next, I'd like to invite on stage Vandana Bhatia, Vice President, Head of Legal and Compliance, DBS Technology Services India Private Limited. Please come and take your award. And we are wrapping up this category with our next awardee. I'd like to call on stage Zohaib Amin, General Counsel, Zycus Infotech Private Limited. Thank you very much and congratulations. Congratulations to all the winners in that category. We are wrapping up with that. And the next category that we are going to announce is the top managing partners. Leaders of their firms, they combine deep legal expertise with strategic leadership, driving both client success and organizational growth. As practitioners and decision makers, they shape the direction of their firms and the legal industry at large. Today, we honor their dual impact as lawyers and leaders. So let's reveal the top managing partners in the above 10 years experience category first. For that, I'm going to invite winners on stage once again in alphabetical order, beginning with Amit Meharia, NCO Legals. Can we have you here on stage? Thank you. Africa. Amit Meharia, NCO Legals. This is top managing partners in the above 10 years experience category. Next, I'd like to call on stage Asmita A. Nayak, SM Legal Advocates and Consultants. Africa. Congratulations. Let's call on stage our next winner in this category, Jayant Mohan, Silk Court Chambers. Thank you. Please join us, Mr. Jayant Mohan, Silk Court Chambers. I'd like to call on stage Dr. Joshita Dawar Khimani, LS Dawar & Co. Congratulations, ma'am. Thank you for joining us. Next award winner in this category, Karan Nagarath of SPN Legal. Okay, moving on then, Dr. Kshitija Wadatkar Wankhede, MS Kshitija Wadatkar and Associates. Can we please have you? Okay, I'm going to move on to the next winner then, Mukesh Bhutani, BMR Legal. Prem Rajani, Rajani Associates. Rahul Hingmayer with Legis Law Practice Advocates. Congratulations. Next award winner in the category, Rajesh Bhardwaj, IILC. Congratulations, sir. For the next award, may I please call on stage Rohit Kochar of Kochar & Co. Okay, we have someone receiving it on his behalf.
Africa.
Thank you very much. The next award winner in this category, Dr. Sachin Sharma, KSV Tax Consultants.
Africa. Africa.
Congratulations, Dr. Sharma. Our next winner in the category, Saurav Ghosh, S. Jalan and Company. Okay, we'll move on now. Sujitra Chitale of Chitale and Chitale Partners. Thank you and congratulations. Next award winner in the category, Sudhir Mishra, Trust Legal. And our last winner in the top managing partners in the above 10 years experience category, Mr. Vivek from J. Sagar Associates. Okay, so with that, we are now moving on to top managing partners in the below 10 years experience category. And for that, I'd like to call on stage Gaurav Nair, Saga Legal. Please join us on stage. We have started with the top managing partners below 10 years experience category. And with that, let's announce the next award winner here. I'd like to call on stage Hemant Singh, Charter Law. Next, I'd like to call on stage Pranish Goyal, MG CEO Legal. Pranish Goyal, MG CEO Legal. Congratulations. Next, I'd like to call on stage Rahul Pandey of Vidigya Associates. Please join us on the stage. All right, we have someone receiving it on his behalf here from Vidigya Associates. It's the top managing partners below 10 years experience category. I'm going to request Venkatramani sir for an extended stay on the stage, but we are moving to the next award category as well. Can we first acknowledge the effort that sir is putting for all of us here? He's been on stage for the last 20 minutes or more, including his keynote address. We really appreciate that, sir. We are starting with the next award category right away. So right now, let's move on now. And the next category of awards is Top Law Firms Above 10 Years Experience. This category recognizes the top law firms that set benchmarks in excellence, expertise, and client service. These firms have consistently delivered high-quality legal solutions across complex and evolving matters. Their strength lies in deep domain knowledge, collaborative teams, and a commitment to excellence. Today, we honor their outstanding contribution to the legal ecosystem. So, top law firms above 10 years experience in alphabetical order. I'm going to name the organization, starting with Alticid Global. Do we have a representative in-house? Okay, our next award winner, ASP Advocates. Please join us on the stage, and can we welcome them? This is the fresh category that we are starting. ASP Advocates. Next on stage, I'd like to invite Bhuller Law Firm. Can we please have you here with us to receive the award and the certificate? I'd like to once again tell all the award winners that you can collect your original certificate from the registration counter. Please do that before you leave tonight. All right, our next winner in the top law firms above 10 years experience category, BMR Legal. BMR Legal coming on stage to take their award. Congratulations. Next, I'd like to call on stage Chitale and Chitale Partners to take their awards. Top law firms above 10 years experience. Congratulations. The next winner in this category, KNM and Partners Law Offices. For the next award in this category, I'd like to call on stage Kocher and Co. Please take your awards. Top law firms above 10 years experience category. Congratulations. Next, I'd like to call on stage LS Dower and Co. It's great to see faces being repeated across categories. Congratulations to the team. With that, let me announce the next award winners. The next award award winners in this category. Lex Favius, can we please have you on stage? Congratulations to you. Our next winners in this category, NDB Law. Okay. Next, Probus Legal. Can we please have you on stage? The next award winners in this category, ProSol Law. Can we please invite you on stage? Our next award winners in this category, Rajani Associates, S. Jalan and Company. Anyone from the team here? Okay, then we'd like to invite on stage our next award winners, SNA Law Offices. SNA Law Offices. Thank you. Congratulations. Let's now invite on stage our next winners, Srivastava Law Associates. Please join us on stage, sir. Congratulations. Let me now call on stage our next winners, SM Legal, Advocates and Consultants. And our last awardee in the above 10 years experience category, SPN Legal. Anyone from the team here? Okay, so with that, we are now moving on to top law firms in the below 10 years experience category. And for that, I'd like to first call on stage Aecom Legal. Can we please have you with us? Please join us. This is top law firms in the below 10 years experience category. Congratulations. Congratulations. I'd like to now invite on stage our next winners in the category. For that, can I please invite Charter Law Chambers? Charter Law Chambers, please come on stage to take your award and certificates. Congratulations, Charter Law Chambers. Our next award winners, Circle of Counsels. Can we please have you on stage? Circle of Counsels. Okay, we move on to Law Net Partners. Next, Lawman and White. Okay, this is top law firms below 10 years experience. Lawman and White coming on stage to take their award. Congratulations. Next, I'd like to call on stage Legum Solis. Can we please have you join us? Anyone from the team coming? Congratulations. Our next award winners in this category, MGCO. It's turning out to be a good day. Congratulations. Our next award winners, NM Law Chambers. Anyone from the team? I'm moving on now. Then Raval and Trivedi Associates LLP. Please join us on stage. Thank you and congratulations. Next, I'd like to invite on stage Red Street. Okay, I think we don't have someone from Reg Street here. Shepherd Law Associates, if we could have someone. Then the last award in this category, Vidigya Associates. Please join us on stage to take your award and certificate. All right, so congratulations to all the winners, and it's our great honor that joining us for the evening also is Honorable Justice A.K. Sikri, former Judge, Supreme Court of India and International Judge at the Singapore International Commercial Court, SICC. Sir, can I please invite you on stage? I'm going to request Sri R. Venkatramani to please felicitate Justice Sikri as he has joined us for the evening. And of course, I'd like to reiterate that he's not just a stalwart of the legal profession, but he has been a constant and invaluable pillar of strength for Legit Quest as well. So we'd like to first felicitate you as you join us for this award ceremony this evening. Can we please have a big round of applause for our special guest here, Honorable Justice A.K. Sikri. I would also like to invite on stage Senior Advocate Dr. Pradeep Rai as he joins us for the evening, and Sri Venkatramani will felicitate Dr. Pradeep Rai as well. Thank you so much, Dr. Pradeep Rai. Venkatramani sir, thank you so much. Of course, sir, please.
No, I forgot to request Karan for a favor. I'm not going to send a bill for my today's evening presence here. But I want him to open an account, a bank account, General Counsel and law firms love and friendship account. I'll put in my first check inside. Karan can follow and every one of you can follow. Thank you for calling me today evening.
Now, to give away the next category of awards, I'd like to invite on stage Honorable Justice A.K. Sikri. Justice Sikri, sir, can I please invite you on stage to give away the next round of awards? It is a pleasure and an honor for all of us to host you tonight for this award ceremony. And we are now beginning with our next award category, which is the finest legal minds shaping the profession today, top individual lawyers. These distinguished professionals have demonstrated exceptional expertise, sharp legal acumen, and an unwavering commitment to excellence. From complex litigation to high-stakes advisory, they continue to influence outcomes that matter. Their work not only serves clients, but also contributes to the evolution of legal practice in India. So tonight, we recognize their outstanding achievements and impact. We are starting with top individual lawyers in the above 10 years experience category. Once again, we'll be doing this in the alphabetical order. So first, I'd like to invite on stage Achal Tandon, Arita Legal. Can we please begin with a big round of applause? Congratulations. Next, I'd like to invite on stage Abhishek Sinha, Chitale and Chitale Partners. Anyone from the team? Okay. Abhishek Guha, Tri-Legal. Thank you for joining us. Congratulations. Our next winner in the top individual lawyers, Abhishek Singla, IC Rexwin Legal. Abhikshit Singh, ASP Advocates. Please join us on the stage. Congratulations. Next, I'd like to invite on stage Achint Kaur, Khaitan and Co. Ahan Mohan, Arita Legal. One more winner from Arita Legal there, Ahan Mohan receiving his award. Congratulations. Ankur Sangal, Khaitan and Co. Do we have the winner with us? Ankur, please join us on stage. Congratulations. Next, I'd like to call on stage Anshul Prakash, again from Khaitan and Co. Anupam Prasad, AP Law Chambers. Can we please have you on stage? And can we please have you all applauding loudly? All right, our next winner here, Arjun Mahajan, Expert Legal Services. Our next winner, Ashish Parwani from Rajani Associates. Okay, they're not here. Asmita Abhijita Nayak from SM Legal Advocates and Consultants. Okay, they are coming. Congratulations. Our next winner, Chirag Madan, MS Law Chambers. Congratulations. Next winner in this category, Gautam Tiwari from Probus Legal. Congratulations. Our next winner, Gauri Puri, Shardul Amarchand Mangaldas and Co. Next, Gunita Pahwa, SNA Law Offices. Alright, we'll have someone from the team to receive it on her behalf. Next, I'd like to call on stage Hardeep Sachdeva, AZB and Partners. Moving on to our next winner in this category, let me please invite on stage Jayati Chitale from Chitale and Chitale Partners. One man doing it for the entire team here tonight. Thank you so much. Let me do a quick check on our next winner here. Jobin Devasi from Desai and Divanji. Karthik Jain from J Sagar Associates. Kaveri Srivastava, Kocher and Co. Please join us on stage. Congratulations, ma'am. Our next award winner, Ketan Mukhija. Again, Kocher and Co. You'll take? Okay. I'll take it. So, Kaveri ji is receiving on behalf of Ketan Mukhija as well from Kocher and Co. I think you can convey to your colleague Krishna Vijay Singh as well, if he's not here, that he's also one of the recipients in this category. Thank you very much. Our next award winner is Krishnan Unni from Aritha Legal. Congratulations. Next on stage, we'd like to call Kritika Sahani, Ajay Sahani and Associates. The next award winner in this category, I'd like to call on stage Kshitija Wankede, MS Kshitija Vadatkar and Associates. Is that your son accompanying you, ma'am? Is that your son? You can come forward come. Come ahead, near the stage. Can we have a big round of applause for the little youngster here? I'm sure he's taking inspiration from all of you in this house. Congratulations, ma'am. Did you get your capture? All right. Let's invite the next winner here, Malak Bhatt from NM Law Chambers. Manish Kumar Sharma from Singhania and Partners LLP. Congratulations, sir. I'd like to call on stage Manmeet Kaur from Karanjwala and Co. to take her award. Congratulations, ma'am. Next in this category, Mayur Shetty from Kocher and Co. Minal Madan, SLP Law, Startup Lawyers and Partners. Congratulations. Next, Mithun V from Shardul Amarchand Mangaldas. Do we have you in the audience? Mohan Kumar from Kocher and Co. Please join us on stage. Congratulations. Next, I'd like to call on stage Mrinal Sharma, Shardul Amarchand Mangaldas and Co. Please take your award. I'd like to next call on stage Mukesh Bhutani from BMR Legal to take their award. Mukesh Bhutani with us? Okay. Mumtaz Bhala from Economic Laws Practice. N. Raja Singh from UKCA and Partners. Naman Joshi. Please join us on stage to take your award. We're just about reaching the halfway mark in this category. It is the most extensive list as we are honoring the top individual lawyers. Namrata Trivedi from Rawal Trivedi Associates. Please come on stage to take your award. Next, can I call on stage Neha Nagpal from NM Law Chambers? Niharika Nagarath from SPN Legal. Neelav Bandopadhyay from SNA Law Offices. Thank you for joining us. Please come on stage. Congratulations. Next, I'd like to invite Nirupama Ramakrishnan from Chandayok and Mahajan to please come on stage. Parul Verma from Denton's Link Legal. Parul, please join us. Pradeep Ratnam, Kocher & Co. I think Kocher & Co should have come with a big team tonight. We could have heard a big round of applause from all of you. Praneeth Bagh, do we have him here? Okay, next, Prashant Sivarajan, Lawman & White LLP. Please come on stage. Also, ladies and gentlemen, just don't forget to collect your original certificates from the registration counter outside the hall. In case you are sharing your pictures on social media, do not forget to use the hashtag Lexa2025 in your posts, and please do engage with us on those social media conversations. After this, can I please invite on stage Priyambada Shenoy Venkat from AZB and Partners? Okay, we have someone receiving it on our behalf. Next on stage, Rahul Narayan from Chandiok and Mahajan. Next, can we hear Kocher & Co. applaud for Rashri Chakraborty? Are they here? Okay. All right. Next, Rajat Mathur, VSM and Associates. Next, I'd like to invite on stage Rajdat Shekhar Singh, SNA Law Offices, to please take your award. Congratulations. I'd like to now call on stage our next winner, Rajul Bohra from JSA Advocates and Solicitors. Thank you. Next, can I please invite on stage Ray Vikram Nath from Aretha Legal. Congratulations. Next, do we have Reena Khair from Kocher & Co? Okay, we move on to Rohit Kocher & Co. Again, we'll have a representative from the company to take on his behalf. Next, I'd like to call on stage Sachin Pujari from Chambers of SS Pujari. Congratulations. Our next winner in this category is Sachin Sharma from KSV Tax Consultants. Our next winner here, Safir Anand from Anand and Anand. Congratulations. Our next winner, Sajid Mohammed from Agrit Partners. Samiron Borkatike from Kocher & Co. Sarika Raichur from Shardul Amarchand Mangaldas and Co. Thank you for joining us this evening, and please come and take your award. Congratulations. Do we have Savita Keshav Jagadisan from Kochur & Co. joining us tonight? Okay. Next winner, Seema Kejriwal Zariwala, BMR Legal. Seema. Shafaq Orezi Sapre from Chandiok and Mahajan. For the next award, may I please call on stage Shambhu Sharan from Singhania and Partners LLP. Congratulations. Our next award winner, I'd like to call on stage Shiv Sapra from Kochur & Co. Thank you for joining us. Our next winner in this category, Siddharth Sethi from J. Sagar Associates. Next on stage, Smita Singh, SNA Law Offices. We'll have someone receiving on her behalf. Thank you. Our next winner, Sohini Mandal from Nilaya Legal. Sonali Malhotra, can we please have you on stage, ma'am? Let's get to our next winner in this category then. I'd like to call on stage Sonal Singhania from Singhania and Partners LLP. Do we have Sonal Singhania? You'll receive on her behalf. Please come.
The attack is psychological.
Soumya Sai Kumar from Gauri Shankar Sai Kumar and Co. Our next two winners are from Kochur & Co. Please do come on stage if you are there. Stephen Matthias and Suhas Srinivasia. Sumit Agarwal from Rex Street Law Advisors. Sunaina Paintel from the Resolution Law Group. Okay, do we have Tanisha J. Monir from the Chambers of Tanisha J. Monir? Please join us on the stage. Thank you. Next winner, Tanya Uppal from Tri-Legal. Urvi Rathod from UR Legal, International Law Firm, Advocates and Solicitors. Please join us on stage, ma'am. Ladies and gentlemen, this is award number 81 in this category. My pitch is still high, but I think the claps have just quietened completely. Okay, our next winner, Varun Singh, Foresight Law Offices. Next on stage, Vijay K. Singh, SNA Law Offices. Congratulations. I'd like to call on stage Vikram Sopti from Chandiok and Mahajan to please take their awards. And Vivek K. Chandy from J. Sagar Associates, if we have you with us. Okay, so that wraps up our award winners in the top individual lawyers in the above 10 years of experience category. And with that, thank you so much, Justice Sikri, for giving away those 85 awards in total in the category. Big round of applause there for Justice Sikri. For the next round of awards, I'd like to call on stage Ms. Pratibha Jain, Head of Strategy and General Counsel, Everstone Group. Ma'am, first, if you could also deliver a keynote address, and then I'll request you to give away the next round of awards. Please welcome ma'am on stage with a warm round of applause.
Good evening, everyone. It's truly a pleasure to be here at the Fortune Legal Excellence Awards 2026 or 2025. For me, it's a great honor to be here today. Specifically, it's very humbling for me to have Justice Arjun Sikri and Mr. Venkatramani here, both of whom I look up to immensely in the profession. Justice Sikri, who's of course former judge of Supreme Court of India and judge of Singapore International Commercial Court, has been a source of immense inspiration. I've had the good luck of working with him multiple times. Alongside him, Mr. R. Venkataramani, the Attorney General of India. He represents the highest ideals of the bar with his intellectual integrity, unimpeachable rectitude, and amazing poems. Thank you very much. I actually other than that, he's the most giving person I know. I was working with him on a matter where the court had appointed him as a receiver. And I was working for the Ministry of Finance, creating this fund that was giving debt to projects one of those projects was what Sir was appointed receiver for. So I did very little in terms of just helping get that credit to the entity that Sir was responsible for. And he was kind enough to actually get me mentioned in the judgment, Sir. You won't remember, but you actually got the court to thank me for that. So I don't know anybody else who does such kind of things. So thank you. I'm so humbled to be here speaking in front of both of you. For those who don't know me, I am Pratibha Jain. I'm the Head of Strategy and Group General Counsel at Everstone Group. Why am I here? My journey, I must say, I'm Group General Counsel now. I was General Counsel 7 years into practice at Goldman Sachs, very young at that time. I had the opportunity to go to Oxford, Harvard. I worked in organizations such as Sullivan & Cromwell, Skadden Arps, Goldman Sachs. And all of this came to me very early in my career. And every time I was in a room with people from these organizations, I always felt like I was hitting way above what my weight was at that time. And that's how I feel about the crowd here today. All of you are great achievers in your own professions, and that's why you're here receiving these awards. And I thought I'll just share a bit of my journey, since LegQuest didn't really give me any outline for what they want me to speak about. Oxford, Harvard, I quickly realized that either I can get intimidated by all these people who clearly were more brilliant than me, or just work twice as hard and pretend I actually belong there. And, spoiler alert, that strategy actually worked. When I moved to Goldman Sachs, which was another turning point for me, I realized how important it is to have the exposure to be a general counsel. I think if you have a linear career path, you don't know what a client really wants. Now when I get emails from lawyers, which are 3-4 paragraphs long, I immediately have to write back and say, can you summarize this in a para that I can understand, because I don't have time for it. So when I was back in private practice, and that's what I did from Goldman, I moved to Nishit Desai Associates to set up their Delhi office, be the founder for the office. And I knew exactly what my clients wanted because I had been on the other side of the table. And that's really been a big blessing for me, and I'm very thankful to God that for various reasons, I wasn't just doing one thing in life. Even in terms of practice, I've done structured finance, I've done IPOs, I have done banking and finance, I have done trading markets, and now private equity. I say private equity, but our portfolio companies and our funds range across credit, across real estate, across climate finance, FMCG. The portfolios are numerous, and you need to be a both subject expert and know your law to be able to do those. And that's what keeps me very agile, excited, and I hope humbled in my career. So just very quickly, based on my journey, I just wanted to leave with 5 pieces of advice for the younger lawyers that have been getting the awards. First, don't follow a template career, because when I moved across geographies, across firms, from private practice to institutions like Goldman, to mid-career shift and build the Delhi office of NDA, it wasn't because there was a clear path. It was because I followed curiosity and opportunity. Your career does not have to look like anyone else to be successful. Second, push yourself to be uncomfortable in the rooms. Whether it was Harvard classroom, top-tier law firms, or government offices, or global platforms like Davos, which, when I was speaking there last year, I found myself wondering how a lawyer who used to love studying microeconomics in Delhi University is doing amongst businessmen and economists, but that's what happens when you have a diversified career path. Third, think beyond the brief. This is very important, because what I've seen is the best lawyers I've worked with are not the ones who just answer the question. They are the ones who understand why the question is being asked. When you start thinking about the client and you start thinking about what you're working towards, you move from being a lawyer to being a trusted advisor. And that's what all lawyers in private practice should aim for. That's what the client's looking for. Fourth, very important, build something larger than yourself. Giving back to society is very, very important for me. That also meant working in public policy. And when I work in public policy, it's not just furthering what is good for my organization, it's what's good for the profession, what's good for the country. And I founded a foundation called We For Her Foundation that works on women empowerment and specifically on gender justice. And that really keeps me grounded, and your impact is what gives it its meaning in your profession, I believe. And finally, stay resilient and keep your sense of humor. I think this is very difficult for lawyers because of the long hours. In fact, I see some lawyers who are sleepy, and I can see that's sometimes good for our profession, but it can also be something wrong with our profession. I'm never sure, you know, when lawyers are sleeping, looking sleepy, is that a good thing or a bad thing? So those were my take-backs from the career. I see a lot of old friends who are contemporaries to me, maybe some who are senior, and it's just, again, a great honor, and congratulations to all of you who have got the awards tonight. Thank you.
Is psychological and powerful.
Thank you, ma'am, but I'll have to call you back on stage because we will have you give the next round of awards, which we are quickly moving on to. And this is going to be the category of top individual lawyers below 10 years of experience. So in this category, we are now going to celebrate the rising stars of the legal fraternity, top individual lawyers under 10 years of experience. With fresh perspectives and strong execution, they are already handling complex matters with confidence. So let me invite the winners once again on stage. We will go in the alphabetical order, starting with Adip Kumar Ray, S&A Law Offices. Congratulations, and the next winner also is from S&A Law Offices, Anand Pratap Singh. Okay, we'll have someone from the company receiving it on his behalf.
And powerful.
For our next winner, I'd like to call on stage Anuj Tiwari from Anuj Tiwari Law Offices. On his behalf, okay. Let's move on now to our next winner. And for that, I'd like to call on stage Archit Singh, Circle of Counsels. Please join us on stage. Congratulations. Our next winner in this category, Diksha Malik from Khaitan & Co. Jatin Kapoor from S&A Law Offices. Our next winner for this category, I'd like to call on stage Kashmira Lambert from MS Lambert & Leggi team. Moving on to our next winner, Kumar Shashwat Singh Sauno from S&A Law Offices. Next, I'd like to call on stage Pranish Goyal from MGCO. Congratulations. Our next winner is also from MGCO. I'd like to call on stage Rohit Sharma to please take your award. Congratulations to you too. Our next winner in this category, Samriddhi Arora. Saurabh Sharma from Chambers of Saurabh Sharma. Please come on stage. Next, next, I'd like to invite on stage Shashank Diwan from Chambers of Shashank Diwan. For the next award, can I please invite on stage Tanay Agarwal from Sandeep Agarwal & Co. Congratulations. For the next award, I'd like to call on stage Ujjwal Anand Sharma from Lawman & White LLP. Vishrut Kansal from Shardul Amarchand Mangaldas & Co. Please join us. Congratulations, and with that, we're also wrapping up this category. But I'm going to request you, ma'am, to please stay with us as we are starting now with the next category of awards. Ma'am, we have some more awards to be given tonight, and I'm going to request you to please stay with us. Now, the next category recognizes top in-house counsel who serve as strategic pillars within their organizations. Their ability to balance legal precision with commercial insight sets them apart, and we are proud to honor their excellence and leadership. Let's announce then. First, winner Gauri Desai from LN Group. Please join us. Our next winner, Niyati Ojha from HP. Okay, Riya Pathania from WeWork India Management Limited. Congratulations. Our next winner in this category, Shikha Guleria from Contagious Online Media Network Private Limited. And our last winner in this category, Vaibhav Jaiprakash Parekh, Reliance Retail Limited. Please join us on the stage. With that, congratulations to all the winners, and we are moving on to the last category of awards tonight, but we are going to do it once again in the above 10 years and below 10 years experience category, and this is top law firm management professionals, the force behind efficient and high-performing law firms. Their work ensures consistency, structure, and excellence across the firm. Today, we recognize their outstanding impact. So let's begin with top law firm management professionals above 10 years experience. And I'd like to first invite on stage Pramita Sen to please take the award. Congratulations. Next for this category, I'd like to call on stage Priyan Garg, Cyril Amarchand Mangaldas. Priyanka Gupta, Kocher & Company, Advocates and Legal Consultants. Please join us on stage. For the next award, may I please call on stage Rahat Beri from Blue Ocean IMC Private Limited. Okay. The next award, Sneha Sagar, Singhania and Partners LLP. Dr. Vivek Das, Pro Consulting Solutions. Thank you and congratulations. With that, ladies and gentlemen, we're moving on to top law firm management professionals in the below 10 years experience category. And the first winner here in the alphabetical order is Bhavya Bhatt from Clause Play. Charmi Patel, Rawal and Trivedi Associates LLP. Please join us on stage. Congratulations. For the next award, may I please call on stage Divya Anand from Blue Ocean IMC Private Limited. Next, Divya Anand from Blue Ocean IMC Private Limited. Congratulations. We're honoring top law firm management professionals in the below 10 years experience category. And our next winner is Farheen Khan from JSA Advocates and Solicitors. Okay, next, can I please invite on stage Garima Kale Chaudhary from ALMT Legal. Congratulations. And from the above 10 years experience category, Priyan Garg from Cyril Amarchand Mangal Das. Can we please have you here to receive the award?
I see your talents have gone beyond the mere physical level.
Well, that essentially is the last award of the night, and I think that deserves a round of applause as we wrap up this wonderful evening. Thank you very much, ma'am, for doing the honors and giving away the awards to our winners there. So, ladies and gentlemen, with that, we have come to the very end of Fortune India Legal Excellence Awards and List. That's Lexa 2025. It has been a fantastic evening, and the credit for this goes to each one of you who have taken out time to join us today for this event. I'd like to thank all the esteemed guests and speakers for their participation, and also a big thank you to all of you for being such wonderful audience. Request you all to now join us for cocktails and dinner, and of course don't forget to collect your original certificates from the registration counter just outside this hall. Thank you once again.